Yes.
May I make a mention?
Yes. Give it to the court officer, it will come. Yes.
Petition on 13th. Execution is on 13/12, my lord. Tomorrow for admission.
When did you file the petition?
1 month back.
It has never listed. Why the fresh matter is not listed from 1 month?
That's for office objection.
If office objections are not complied with, it will not be listed.
Now I complain.
We will see. Yes.
The agreement was entered into in 2018, my lord, but till date, the construction has not
No,
been
take
completed.
it.
The coordinate benches have passed interim order in similar matters, EMI stoppage matters. Those were listed before my lord as well, on the previous occasion.
What are those matter?
It's a EMI pause matter in case of release of the funds from the banks without looking at the stage of construction, which goes against the RBI guidelines.
No, we will not grant any fresh interim orders in this. We will hear the main petitions. You also let this come along with the list.
But
Because-
this is a pending matter that has been adjourned for a few times, my lord.
No,
Because
the entire batch is pending. It has to come. We'll list it.
it
List
may
it
at least
someday.
be connected with that matter, my lord.
Connect along with the batch. Huh? All 60 matters one day will take someday in this
Let
week.
this be connected with
Yes,
that matter.
yes.
This vacating stay, they have not complied with the orders of this honorable court. I filed vacating interim order.
Vacate petitions, not this side of the vacation. Yes.
My lord's child
Because there is a
health
urgency
has
in
been
my lord.
affected by the visiting orders, my lord. It is very urgent matter.
Child,
Child health is affecting by the visitations order, my lord.
when was the
Child-
visitation order passed?
25th of April, my lord.
25th of April, health is affected, December
Well, they are,
urgency.
because since from 3 months, child is not feeling well, but respondents are been.
When did you
forced-
file this petition?
My lord, 16/9/2025.
Then what is urgency now? What were you doing all these 3 months?
Hi.
No urgency. Yes.
My lords, I'm for the petitioner here. My lords, a possession notice has been affixed to the petitioner's flat to vacate in 7 days. Today is the 7th day, my lords. If today the hearing is not done, tomorrow they'll break open and take the possession of the flat. There's no liability on the petitioner, my lords. That's why I'm asking to list the matter at the end of the list, my lords. For today.
Have you filed it? Have you filed this matter? When was this petition
Yesterday,
filed?
I have filed the case, my
If
lords.
office objections are complete, it would have been listed today.
My lords, if there's any objections by the time, I'll comply by it, my lords. Kindly, there's an urgency. my
I am
lords.
not granting any interim in this lunch motions in this matters. If you are vigilant, you should have come before or else it will come tomorrow.
No, my lords,
No lunch motion.
3/12, the order, possession notice was affixed, my lords, the 3/12. Today is 9/12, within 7 days, we have to come approach this honorable court.
You can come. What is the
Yes, my
difficulty in
lords,
coming?
so today is the 7th day, my lords, if no interim order is passed, tomorrow they'll break open and take the possession, my lords.
We will see tomorrow. It will come tomorrow.
Ma-
Listen. Tomorrow, no lunch motions. Yes.
All 5 matters, my lords, same, different flat numbers, that's it.
Let it be.
Much obliged.
Sale action ಇದೆ ಸಮಯ ನಾಳೆಗೆ
You have to come this side. I'll go this way. Once I finished it, I'll not hear it again. Yes.
ಸಮಯ ಬ್ಯಾಂಕ್ ಸೇಲ್ ಆಕ್ಷನ್ ಇದೆ ಸಮಯ
When was it?
ಸೇಲ್ ಆಕ್ಷನ್
When is it?
tomorrow ಸಮಯ
When did you file the writ petition?
22/11 ಸಮಯ
Huh?
fresh matter ಸಮಯ 22/11
Fresh matters will come. Yes, next.
tomorrow please
It will come. Yes.
My lords, there is
I said you have to come this side. Yes.
Madam, this is the DRT matter dismissed by default for restoration. Otherwise, they will take recovery officer to action the property.
When was it dismissed?
No, the month of July, madam. The August I filed that application.
So what is not happening from August? What will happen
And
now?
office subject, everything is complied.
We will see. There's no urgency for that.
My lord,
My
7
lord,
days.
if not, they
vacate
will
notice-
act action,
We will
madam.
see. No. Yes.
My lord, 7
My
days
lord.
vacate notice have been issued, my lord.
Huh?
7 days vacate notice have been issued, my lords. The petitioner are staying in first.
It will come. It will come. Yes. Yes.
Demand notice issued, my lord. 2015 and 2016 MSME Act policy rules and regulation violation ಮಾಡಿದ್ದಾರೆ ಆಮೇಲೆ ಆಕ್ಷನ್ ಸೇಲ್ ನೋಟಿಸ್ tomorrow ಇದೆ kindly tomorrow.
It will come. Yes. All the fresh matters will come. Don't make a mention. Whatever is urgency, I will not take it up today. And once office objections are complied with, all fresh matters will be immediately listed. That is the specific direction from this court. So please don't, don't have to mention anything because I'm not going to grant. Yes, other than that, other than the fresh matters.
My lordship,
Huh? It will come. All, if you file, it will come. I will not grant out of,
My
I will
lordship.
not take it up out of turn.
Yes.
Yes.
Respondent bank has issued a sale notice and they want to sell off the action. They have to auction the scheduled properties and have taken steps for the recovery.
Let them take. We will, you file it. Once it is numbered, once the office objections are complete, it will come. Huh? Old matter. Then what is urgency now?
Last time sitting in Lila, so available.
That's what, those matters also will come. That's what I have directed them wherever, like while I was on leave, wherever the matters which are adjourned, all of them shall be listed within this week. They will come. Yes.
the SARFAESI, my lordship,
Where is the list?
my lordship, SARFAESI matter.
Surface a matter, fresh matters will
Yes,
come.
the respondent issued the possession notice, my lord, 2/8
Yes,
also.
it will come.
We are ready to, my lord, we are ready to regularize the loan amount.
Whatever it is, it will come. I will
The
not.
tomorrow, my lord.
No.
The urgency is there, my lordship, the possession notice issued by respondent.
Yes.
The,
Yes.
my lordship,
KSRTC appeal, my lord, the KSRTC appeal, this matter was settled, my lord, to file joint member tomorrow or day after tomorrow. Parties will come, my lord.
Yes.
My lord, date given matter
Yeah,
was
date,
not
date.
for
The date
admission.
given.
1911, my lord.
What is urgency?
My lord, urgency is a bank matter, my lord. We are ready to close the entire loan amount, my lord.
All the matters that are adjourned, they will come. That's what I have specifically said. So,
My lord, pending matter, my lord. Interim order not complaint, my lord.
huh?
Interim order.
If it is not complete, we will see after vacation. Yes, call the list.
the, my lordship, the respondent issued the notice issue, my lord, possession.
Surface matters will come.
Orders matter
Yes, ma'am.
Yes.
for number one, for adjournment, your lord.
Huh? Petition.
Order, both the cases have been clubbed and put up the lordship opposition order.
Has not come. Look at it.
My lord,
Yes.
a DRT matter, I have regularized my
DRT
account,
matter.
but not handing over
File
my
it,
property.
it will come. File it, it
The
will
file
come.
it, objections also is complied, my lord. It's been almost
It
2
will
weeks and
come.
it's not
It will
listed.
come because it was not coming because I was not sitting. Now it will come. So don't mention. Call the list.
Your lordship, serial number four.
For release of
For
amount of MSM.
He
orders,
already said, give it to the court officer.
your lordship.
Yes.
Serial number 59, your lordship.
She has to call the list.
Oh, apologies, your lordship.
Page-wise adjournment, page number 6, serial number 13 to 19, page number 17, 20 to 23, page number 18, 24 to 29, page number 9.
Page number, office number 1, page number 29, my lord. I request for a short adjournment to file objections. The petitioner is present as well.
No objection. This is matter after vacation at the request of land counsel, the petitioner in 2583 of 2025. Yes, next.
Page number 9.
Interim order in all these adjourned matters, if interim order is there, extend.
Date
They
may be
ask for
fixed,
now.
my lords.
Huh?
A date may be fixed, so serial number 29.
It will come after vacation. You
Serial
can
number
move.
9, page number 9, serial number 30 to 36, page number 10, serial number 37 to 45, page number 11,
Serial number 40.
Serial number 40. What do you want?
Maybe a
Huh?
week's time. No objection.
Yes, this is matter after vacation at the request of land counsel, the petitioner. Yes, next.
serial number, page number 11, serial number 46 to 53, page number 12, serial number 54 to 58, page number 10, serial number 59 to 63,
59, your lordship, appearing for the petitioner. Senior counsel is not available. We have informed the other side if the matter may be taken up after.
They have no objection.
No, your lordship.
Land counsel, the petitioner seeks time. It is submitted that it's already informed to the land counsel, the respondent, and they have no objection. This is matter after vacation.
Interim order.
page
Yes, interim order earlier grant is extended.
Serial number 61, your lordship.
Yes,
Serial number 61, in this settlement terms have been finalized. We need about 12 weeks because there is a property that's being released and registered. serial number 61. I'm for the respondent and the petitioner is also aware of
Increase
this.
the sound. Yes. Yes.
Submit, ma'am. 61.
Yes, the settlement terms have been finalized, Your Honor. There is a gift deed that is being registered. We need about 8 weeks' time and the matter will be closed. I'm for the respondent.
In a FC matter, why do you require 8 weeks time and what is the matter about?
It is a custody matter, Your Honor. The mother has filed the petition challenging the
Have you
visitation
informed the other side?
Yes, yes. We
Have you informed the other side?
Yes, yes.
At the request of, it is a request of land counsel the petitioner. This is respondent, this is matter after vacation. It is submitted, that's already informed to the counsel for the petitioner. Yes.
13, serial number 64 to 69.
Serial number 65.
67, my lord. I am for the petition, my lord. I am in out of station, my lord. Date given on 3/12, my lord. Matter was not listed on 3/12, my lord. Kindly urgent the matter, my lord.
Serial number 65. Appear for the petitioners, my lord. Kindly grant short accommodation.
What about, have you informed the other side?
Yes, my lord. I will inform others.
Not I will. I am very clear in what I asked. I said, have you informed?
No, ma'am.
Then please wait.
Serial number 67, ma'am.
My lord,
Yes,
serial number
67.
67, my lord. It's a date.
Have you informed the other side?
Date is given on 3. No, my lord. No.
So please inform them, then wait till the matter reaches. Yes, next.
Page number 15, serial number 70 to 72.
Yes.
Ordered matters. For orders matter, serial number 1.
So this matter, this 5 PM matter, I think it is not possible today. Inform the advocates.
Page number. Oh.
Finally, hearing this 5 PM matter. Today there is a meeting. It's not possible. Yes. Call the list.
Sonia Rajesh.
Yes.
For orders matter, serial number 1. Narmani for petitioner. Vignesh Shetty. For respondent.
Yes.
My lord, there are three
Lord's,
matters.
challenges to the sale notice. The
Yes.
challenge, my lords, is to the orders under section 14.
There are three matters, sir. Which matter you are referring, sir? All the three matters?
8696 of 2024.
Before that, my lord, there are two more matters. That is, my lord, 1.1275 of 2024. I think by Kavita is appearing. My lord, in this matter, my lord, kindly come to the prayer which they sought. Issue writ of certiorari setting aside the sale notice.
I am here on my legs. I'll finish my arguments. 8696 of 2024.
No, these are all connected. He's saying something. What is it? Yes, what is it you want to
My lord,
say?
in that matter, there, my lord, the prayer they sought before this honorable court setting aside the sale notice dated 5/12/2023. The sale is not taken place. Therefore, my lord, this writ will not survive for consideration. Therefore, my lord, this writ can be disposed of.
Then what about the other?
Only one writ will survive for consideration. That
And
is my
1.2?
1.2 also will, my lord, that is a possession notice which they received before this honorable court. That will survive, my lord. That will make a submissions. That also I don't think so. My senior counsel will argue on appearing on that matter. There are three matters filed by the very same petitioner.
So let's hear the senior counsel first.
Please, my lord.
Yes.
Lords, the challenge, my lords, is to the order under section 14. Lords, it is premised on the basis of the recovery process initiated pertaining to multiple loans clubbed into one loan. This is essentially where the gist lies. So I'm just passing on a list of loans which has been borrowed. There are 4 entities
Yes.
in the name of which the loans were borrowed. Put here now. I'll go and copy. Lords, these details is already forthcoming, my lords. So this is as a matter of convenience. This is part of the writ petition papers itself. At page number 12, my lords, we have given the details.
Have you heard this matter before?
No, my lords. Lordship is taking up this matter for the first time.
Yes.
No. Lords, your lordships will see the property, the auction of which, or the property, the possession of which is directed to be taken under section 14 is survey number 21/2. Not survey number 21/2, according to our case, was mortgaged as an agricultural land in the year 2007. 2010 it was converted. 2014, there it was converted into an MSME loan for 30 lakhs. So this property, according to us, is mortgaged only for the loan which is borrowed to the extent of 30 lakhs in the name of Sampath Kumar. This is a property belonging to Sampath Kumar. I take your lordship, there is an element of fraud, that there is a little more than what the eye meets. Then the next page, Maruti Enterprises has borrowed 4 loans. But one thing which is a little conspicuous, what I feel is, your lordship may kindly take a note of loan number 4. Not all the loans are secured with other properties. Loan number 1, 5140 is Khata number 54/1. There are 3 properties. Same properties are utilized for advancing loan numbers 2 and 3 in the name of Maruti Enterprises. Loan 4 is 75 lakhs advanced on the property which is mortgaged, that is 60/1, 60/2 and Khata number 35/1 and 131/1. This is a little crucial because the document which they have subsequently now included wanted to include the 75 lakhs. I'll demonstrate how they have played this fraud. Then next page, Maruti Gas Distributors. Again, Maruti Gas Distributors, survey number 54, Khata number 54/1 is mortgaged for covering 6 lakhs, 20 lakhs and 75 lakhs along with another property. This 75 lakhs is again in the year 2015. 28/9/2015 is the loan, both the loans, 28/9/2015. Maruti Enterprises and Maruti Gas Distributors. Then Shruti Sampath Kumar. Again, there are 4 loans, 40 lakhs, 3 lakhs, 20 lakhs and 7 lakhs. One is a vehicle loan. Second, that is number 5 is a vehicle loan. Then again, number 7 is a vehicle loan. These are unsecured loans. The security would be essentially the vehicle. Then there are 2 properties which are distinctly mortgaged in respect of these loans. Now, SS Service Systems, this is also again by Sampath Kumar only. This is a OD account. And there is one more loan of joint loan of the husband and wife, Sampath and Shruti, for which there is another 80 lakhs for which the property has been mortgaged. Now, the reason why I am submitting this is that for every loan transaction, for every application which we gave, there was a distinct security which was created. We are very conscious that this is how the documentation has taken place. We have not executed any other documentation other than the documentation this was done. Now, what they did was, if your lordships were to just have a look at page number 96, 21/1, the only extent for which we have mortgaged this property is 30 lakhs.
No. Please come to the whatever is impugned here before this court.
Lords, it's the order passed by the learned magistrate. Lords, if your lordships were to see
that order where that is pertaining to which, what is that?
Lords, your lordships will find that order at annexure A, page 44. At page number 44.
Yes.
In that, your lordships may kindly have a look at 48. Lordship gets it, lords.
Term loan of 30 lakhs.
30 lakhs. Said loan was obtained against the security of the scheduled property. As per the loan papers, the respondent has to pay the said loan amount.
So where do you get this 30 lakhs at page number 1?
Lords,
serial number 2.
Serial number 2. This is what your lordships is now reading the same paragraph number 9 at page 48.
What that is referred there?
Lord, that is at serial number 2 in the first page. This is the
lakhs.
loan. This is an admitted loan. We are not disputing this loan. It is only 30 lakhs.
What is mortgage for that? Survey number 21.
21/1. I'm sorry, survey number 21/2 of Shanmangla village. They also filed the petition saying that survey number 21/1 is 21/2 is mortgaged for 30 lakhs. I just read those further because this is the contention which they have raised before the learned magistrate. After I took a stand that there is a merger, which I take your lordship a little while later, they have changed their stand and there appears to be a manipulation of the documents. I was, as a matter of fact, one of my friend had put up on his status that he's purchased a vehicle. So I saw him signing because he's put up on his status. The financer was turning the pages, he was signing the pages, and then he gave it. He's a lawyer. And then he took the vehicle, he unveiled the vehicle and he took delivery of the vehicle. That's when I was thinking, so many cases which we come across, we as lawyers, we will sign the papers blindly at the time when we obtain the loans. I just point out, lords, what has happened. Page 48, as per the petition averments and also the averments made in the affidavit accompanying the petition, respondent has availed a term loan of 30 lakhs from the petitioner bank. Said loan was obtained against the security of the scheduled property. As per the term of the loan papers, the respondent has to repay the said loan amount. After availing the loan, respondent has failed to keep up the promise of prompt repayment in spite of repeated requests and demands made by the officials of the petitioner bank. At the present, there is an outstanding balance of 4 crores 18 lakhs in the loan account in question. Hence, the loan account is classified as NPL. Let's kindly mark this. 30 lakhs in the year 2014, according to them, has become 10 times. No, not 10 times. It is like, I'm sorry, about 13 times. 13 times. That is 1,300%. But that's not correct. This is a false statement which they have made before the learned magistrate. The reason why I'm making that this is a false statement is, I just complete that. He, being a secured creditor in law, is entitled to obtain physical possession of the property, so on and so forth. They went before the magistrate with a narrative that 30 lakhs is the loan borrowed. That 30 lakhs has now become 4 crores 18 lakhs 6,000 rupees and 554 4 paisa. And therefore, we want to take possession of the property. This is the narrative with which they went before the. Now, your lordships may kindly take notes the sale notice at page number 96. What is that they have done? So that's not a correct statement with which they went before the magistrate.
No, before that, whatever that is stated before the magistrate.
Yes.
Before that, they might have given you a notice under 13.2. What does it say?
13.2 notice was individually given in respect of the NPS which was treated earlier. We had no difficulty about this NPS. Now, the question is, at the time when they want to take action in respect of individual loans which are borrowed
So
for
where
this,
is the 13.2 notice pertaining to this transaction?
13.2 is not part of the record minutes. We have only produced the sale notices.
So you have mentioned in your affidavit saying that the 13.2, or I think that some 13.2 notice is also there.
No, it's 13.2 note, it's 8.6, rule 8.6 notices are there, minutes. Because after annexure B series yesterday, I saw that these are all 8.6 notices. But if your lordships were to see, minutes, even the 8.6 notices.
So even the sale notice refers to what is outstanding?
Lords, kind of have a look at page 96.
1 crore 99 lakhs.
Lords, page 96. What they refer to is
Sale notice.
the 4 crores 71 lakhs 80,051 rupees 60 paisa at page 96. And what properties are brought to sale is very important. If your lordships were to just hold this list which I have given, notes this property numbers 1 and 2 are given to Maruti distributors, gas distributors. Khata numbers 55/130 and 54/1.
So what is this notice at page 59? That is also a sale notice.
That's also a sale notice.
So now we are, this is pertaining to what?
Notes there is no sale of property in this. Here, lords, if your lordships were to see here, they say that due is 1 crore 99 lakhs.
The same thing as stated before the magistrate?
No.
Magistrate is
Before
4
magistrate, it is 4 crore 18 lakhs.
crores.
Now, lords, this is pertaining to 59 is 60/1. It's a different site. The reason why the sale notices are produced is to indicate that even they had purported to bring different properties to sale for the purpose of recovery of different debts.
No, as far as this petition is concerned.
It is pertaining
this
to
is for
21/2.
Survey number 21/2.
Your lordship's right.
So 21/2, where is the sale notice?
Lords, that is page number 96.
Yes. What it says?
4 crores 71 lakhs 80,000 at page number 96. Item number 4 in this sale notice is the property in question, where they show that the debt due is 202 lakhs 30,000. I will point out to your lordships what is this missive, but this is where it is included. Now what they have done, my lords, is they don't indicate. If your lordships were to see, who are all the persons who have purchased, who are all the persons who have been extended with this loan facility. If your lordships were to see the requirement of issuance of a sale notice, it is debt specific. It is a security agreement specific. The law itself proceeds on the basis of a security agreement. Where the security agreement, what is the debt due and what is required to be recovered from that secured asset is what is required to be spelled out in terms of Rule 8.5 of the securitization, the security interest rules. Here they don't mention anything. They club about 4 items of property in which this is one of the items and say that different amounts are outstanding as against different properties. 32 lakhs reserve price of the property. So without mentioning what is the actual due, this is how they do it. Now, the first and foremost question is, I will just take your lordships to the other part of it also, my lords, how they did this mischief. So with this, we came before the court and said, this is the mischief played by them. I have never mortgaged this property in excess of 30 lakhs. You can't make this secured asset as a secured asset for some other loan for which I have not offered this property as a secured asset. That's essentially the statement which we made. Then they came out, my lords, with a statement of objections, which is very important.
Yes.
They have not been fair to the court, is what I can say.
We'll point out.
Lords, they have filed something called as memo of documents. I'm sorry, which is filed on
11 June 2024. 11 June 2024, we filed a my lord, set of documents by way of memo.
Where is that? There's something on 8/12. You said what is the date? 10/11?
My lord, 11 June 2024.
11 June.
Please, my lord.
ಇದಾದ್ಮೇಲೆ ಅದನ್ನ ಹಾಕಿದಲ್ವಾ ಆಮೇಲೆ ಅಬ್ಜೆಕ್ಷನ್ ಅದರೊಳಗೆ ಅದನ್ನ ಹಾಕಿಲ್ಲ ಇದರಲ್ಲಿ ಇದು
This is 11 June.
ಅಯ್ಯಲ್ಲ this ಅಲ್ಲ memo, this memo in 8696 only.
You filed something on 10/11, 17.
That is recently which I filed a memo, my lord, with last sale deed. What is a, my lord, consideration which, my lord, the petitioner given.
Let's see this.
Please, my lord.
Lords, if your lordships were to see the memo of documents, the memo is there, the contents of that memo. Letter evidencing deposit of title deeds for 6 lakhs, 26 lakhs, 15 lakhs, 75 lakhs. Lordship gets it, lords. This is 4/12/2006, 22/9/2008, 23/9/2008 and 27/6/2014 is what they have mentioned. There are separate, if your lordships were to kindly take, lords, the list of documents, letter evidencing. Lords, in that, the page number, Sanchuru.
It's 3, page number 3.
Page number 3, my lords, is Sampath Kumar for Maruti Enterprises. The property which is mortgaged is 54/1. Then next, 3, 4, 5, 6. In 6, for 26 lakhs, there is no schedule. They say it is a property at Bhimanahalli village in the middle. I don't know what property they have mortgaged. Fully described in the B schedule here too. Probably they have not produced the documents as I can understand. Anyways, no document is produced. What is then next page? That is 6, 7, 8. Lords, in that again for 15 lakhs, 54/1 is mortgaged. Schedule A is mentioned, and then after that, page number 13. Page number 13, letter evidencing deposit of title deeds for 75 lakhs as on 27/6/2014. This is for Maruti Enterprises. Note this is again 55/130, site number 130, 60 into 40.
Yes.
Just page number. Page number 18 is very important. This is where we are pointing out what is the fraud played by this bank.
Hmm.
Lords, at page 19, your lords, may kindly take.
Hmm. Yes.
26th of August.
27th
of August 2014 is said to be the date.
Hmm.
I just read it, my lords. Total limit of 1 crore 80 lakhs sanctioned to me or us or to Marti Enterprises by way of OCC and term loan, and now Mrs. Marti Gas Distributors Sampath Kumar. We place on record that I have attended your office on 27/8 when it was agreed that the title deed specified in the schedule, kindly mark this, A1 to A6, they have inserted there, there is no counter signature. I'll point out why they have done this. To the annexed relating to the landed properties situated at Shanmangla, place where the properties are situated and more fully described in B schedule annexed here too. There is no B1 to B6 here, which has already been delivered to you on -6 2019. 14, I'm sorry, -6 2014. We don't know, because confirmation of deposit of title deed should be referable to a past event, which should be, if they are mentioning a date, there should be a date pertaining to this. This is also not correct because the landed properties was mortgaged in 2007 and 2014. So this, whatever they are now telling, the property documents were never with us. The property documents were already there with them in the year 2007, which they took it as a mortgage for the subsequent loan. I will just read complete reading this. Original date of deposit, intent to create security in favor of Canara Bank of the said landed properties described in schedule B1 to B6. Again, they inserted B1 to B6. Here to annexed, including buildings thereon and all machinery therein, or to be brought in connection with various limits sanctioned to me or us, that is Maruti Enterprises, up to 1.5 crores, permitted earlier to me to be mentioned, shall be held and retained by you as security for repayment of the principal, some interest and all other money that may be due to you or your by us and by Sampath Kumar on account of the present additional loan, working limits of rupees 30 lakhs availed to be availed by me or by Sampath Kumar, and all pecuniary liability arising therefrom, which are in addition to the previous limits of 1 crore 50 lakhs, maximum limit permitted earlier mentioned in the intention being created a further equitable mortgage by deposit of title deeds with the meaning of section 58 of F of the Transfer of Property Act, so on and so forth. Then they say it is 1 crore 80 lakhs. In this, the property in question is, now lords may now kindly see what is this B1 to B6 schedules. A1 to A6 is the list of documents. A1 to A6 is already there with them. A1 to A6 is never given for this loan. A1 to A6 is already, A1 to A6 is not for the first time given in 2014.
When was it given?
Lords, all the loans, if your lords were to take the list, my lords,
From 2005.
2005, every document is there with them on that date. B1 to B6, how they insert this is the question. For 1 crore 80 lakhs, how they come about this figure, I'll also make a mention. Now, after doing this, the property schedules which they are mentioned is the same properties which is referred to in the earlier mortgage deeds, which they are not deliberately producing it before the court. They are all the mortgages pertaining to the earlier loans. Then the property in question which we are now concerned with is 20, 24 and 25.
Where do you get that?
B2, my lords. Allah, the page A2. 24. Correct.
That is survey number 21/2.
Yes, 21/2. This handwritten one page. On the next page, again in the handwriting, it is there that this property is included in A1 to A6 and B1 to B6. We have executed a distinct letter of, because I don't have the custody of the document. We have executed a distinct letter under which we have acknowledged this property being extended as a security for 30 lakhs of the MSME loan. This is not the document which we have executed for 1.8 crores. We have never executed, but nonetheless, I'll point out how they did this. Then this property is included amongst the other properties which are already mortgaged to them for different loans. Now, how do they get this 1.8 crores? Notice what this 1.8 crores is. We have borrowed, your lordships may kindly take. I had requested your lordships to make a note of this 75 lakhs loans. 28/9/2015.
No, they have calculated all this 1, 2, 3, 4.
No, they have taken these two loans, serial number 4 of Maruti Enterprises and serial number 3 of Maruti Gas Distributors, to put it into 1 crore 80 lakhs. 75, 75, 30. At serial number 2 in the first page.
But those are all of different dates. One is 2014.
2014, we had never borrowed that loan as on that date.
2015, 2 or 2015.
Yes, my lords, we had never borrowed that loan as on that date. We had never even made an application for 75 lakhs.
2014.
In 2014, we had never even made an application seeking loan of 75 lakhs in the name of Maruti Gas Distributors and Maruti Enterprises. Where is any question of giving them security for this 1 crore 50 lakhs? All my other loans are secured loans. And even these two loans, what they are not disclosing is, even these two loans is on the security of the properties which are mentioned here. They are withholding the documents. One difficulty which we face with the bank is that they will produce only those documents which is very convenient. And I'll just tell the story why all these things has happened.
Is it your case that this particular document which you are referring is not
No.
executed, signed by him?
Lords, the signatures may be my signatures because they have produced the photocopies. In the photocopies, yes, this signature appears to be my signatures. But there is something more than that. If I were to just complete my part of the story, your lordships will. Survey number 21/2 was proposed to be purchased of a portion by the then manager of the bank who was working in Canara Bank in the year 2008, who sanctioned this loan. So for the refund of this money, which he says that it was a loan, it was a transaction for purchasing of a property, since a check had been given, he filed check bouncing case against us, this very manager. The manager having filed a check bouncing case, subsequently the proceedings, whatever would have happened, he stood transferred to the central office, ERM2 as a DGM, the very same officer. These are the properties which are situated within the limits of the recovery officer or the authorized officer of Biddi, of Mandya. No property is sought to be brought to sale in Mandya. Properties are, all the files are withdrawn from Mandya to the ERM2 office and they are sought to be dealt with in Bangalore.
That's not correct. It is not correct.
Kindly have a look at, I will show it. There is a private complaint, page number 25 along with my rejoinder. If you want to make a statement, he can make a statement, no difficulty.
Your rejoinder is dated?
Lords, my rejoinder is dated 17/11/2025.
Yes.
B. Jairam Reddy, he was the manager at that point of time. Kindly have a look at page 26. He is the ARM. He was the ARM, Lord's DGM in ERM2 when he retired. Page 26.
Yes.
Accused is doing real estate business and also landlord of 21/2 of Shanmangla village, Biddi Hobli, Ramnagar. Accused approached the complainant that he would form a layout and sell one site to the complainant for cheaper rate and also informed complainant to give sale consideration of 25 lakhs by installments. The complainant believing his words and based on some documents shown to the complainant has paid 25 lakhs as consideration.
The manager has given this complaint.
The Jairam Reddy was the manager who sanctioned the loan in the year 2008. He was there up to 2011. Correct? Huh? Up to 2015. Up to 2015. Just ask what is the date. No, it's the reason why I'm submitting this is, it is not that the bank was not personally interested or the people who are 2010, he was not personally interested. There was somebody in the bank who was personally interested in this property, for which he claims he has funded this property. ERM2. Why from authorized officer Biddi to ERM2 Bangalore? Administratively, you may say that, yes, we can do it, but why? I'm showing. Do you do it in all the cases?
Yes.
That it comes from Birdi to ERM2 in all cases?
Yes.
Notice now, this property, the reason why there is a further significance for this property is, this was a property which was converted in the year 2010. Agricultural land was mortgaged in the year 2008. 2007. I will show the valuation slip obtained by the bank in the year 2007 is 2 crore 5 lakhs as an agricultural property. Converted in the year 2010, layout is formed. One site is 25 lakhs. That is essentially what they are saying. That is at the cheapest price. It is not. I wanted to say that because he wants to take it at the cheapest price. Now, property is sold at 2 crores 5 lakhs. 2007 agricultural land valuation is 2 crores 5 lakhs.
In 2007.
In 2007.
In 2020, when was it sold?
2023. Notice, this is essentially the three contentions. One, the scheme of the statute does not permit that you can club the loans and say that, yes, we are going to do this exercise. So far as the document which I referred to your lordship's minutes is a document which I am making a statement that as on that date, we had not borrowed 1.8 crores on the basis of this property. We had borrowed 30 lakhs. Another 75 lakhs was borrowed in the year 2015. Two loans were borrowed in the 2015 on the basis of the security documents executed for those properties which were mortgaged for them, not for this 1. Now this 30 lakhs is concerned, we wanted to close it. We were also offered one-time settlement. We paid part of it. We did not, but that was for the.
What about the other loan accounts? Have they also declared as NPA?
No, all the loan accounts are declared as NPA. There is no difficulty about it. All loan accounts are declared as NPA.
The other day you are saying that as per the RBI guidelines, once within the same bank, if you have different accounts and if they are declared as NPA,
that is the point.
They can't regularize this account, one of the accounts.
No, it's one of the account. See, now it is because of the requirements by the under the RBI guidelines. It says that the bank, it is not a mandate. Once one of the account is treated as an NPA, if I am having other accounts, then even those accounts can be treated as NPA. That's what the RBI, it would have been cited before your lordships in any number of cases. It can be done. But if I want to close one loan account and the other loan accounts are fully secured beyond the value which is required to be recovered for pertaining to that loan account, this loan account, they'll close it. They will anyway get the money. Pertaining to one account, they'll get the money. This is a leverage where they can arm twist to say that, no, you'll have to pay up so that this can be regularized. This essentially appears to be the object as I can understand or decipher from the RBI circulars. But now, if your lordships were to see the scheme of the act, not how the acts, the provisions of the act, it starts.
Which act? MSME Act or the
SARFAESI Act?
Yes.
Notice the certain times when such unbridled powers are given to the bank or the authorized officer, if such are the kind of cases, whether the authorized officer should really deal with this kind of matters. Because he is the judge, he is the jury, and he is ultimately the executioner. This is essentially where everything rests in him. But if he point out that there were issues which required his consideration or there were issues beyond his consideration, those are not the kind of cases which should be permitted to be handled, milords, under the securitization proceedings. Your lordships may kindly see, milords, what is meant by a security agreement 2ZB.
Sir?
2ZB, milords.
Yes.
Security agreement means an agreement, instrument, or any document or arrangement under which security interest is created in favor of secured creditor, including the creation of a mortgage by deposit of title deeds with the secured creditor. So what your lordships may kindly mark is security interest and the secured creditor. These are the two phrases which your lordships may kindly mark, because These are again the defined phrases.
Security interest and security creditor.
Security interest and secured creditor.
Hmm.
Notice I'll read security interest at 2ZF and then come to secured creditor, because secured creditor is essentially any bank or financial institution.
Yes.
Security interest means right, title or interest of any kind other than those specified in section 31 upon property created in favor of any secured creditor and includes any mortgage, hypothecation, assignment or any right, title of kind, tangible asset retained by the secured creditor as an owner of the property given on hire or financial lease or conditional sale or under other contract which secures the obligation to pay any unpaid portion of the purchase price of an asset or an obligation incurred or credit provided or enabled the borrower to acquire. Such right, title or interest in any intangible asset or assignment or license of such intangible asset which secures the obligation to pay any unpaid portion of the purchase price of the intangible asset or the obligation incurred or any credit provided to enable the borrower to acquire the intangible asset, license of the intangible asset. This is what is meant by the security interest. That means any right, title, interest in the property, including the ones which are mentioned in 1 and 2. Now, secured asset is 2ZC.
Yes.
Secured asset means the property on which the security interest is created.
Yes.
Then, if your lordships were to see security asset, security interest and security agreement now stands conspicuously mentioned in section 13.
Yes.
This is very important, my lords. Subsection 2, where any borrower who is under a liability to a secured creditor under a security agreement makes any default in repayment of the secured debt or any of the installments thereof, his property in respect of such debt, lords may kindly mark that words, in respect of such debt is classified by the creditor as non-performing asset, then the secured creditor may require the borrower by notice in writing to discharge in full the liabilities to the secured creditor within 60 days from the date of notice, failing which the secured creditor shall be entitled to exercise any of the rights. Notice 3 things which emanates in this. Because that RBI circular, this argument had canvassed notes before another court, but ultimately it so happened that the sale did not take place. Writ petition became infructuous. But what the argument which we canvassed is, so far as NPA for the purposes of Securitization Act is concerned, you can't rely upon the RBI circular because it's a subordinate legislation. Anyway, it may have the force of a legislation. But where the provisions of the Securitization Act, the requirement is mentioned here. Liability to a secured creditor under a security agreement, number 1, makes any default in repayment of the secured debt to of arrangement on his account in respect of such debt is classified by the secured creditor as a non-performing asset. So, for the purposes of classifying any debt as a non-performing asset, therefore, I made a statement very carefully that it is a debt-specific statute. Security agreement is created for a secured debt, and that secured debt, when it is due, then you can treat my account as an NPA. This proceeds further. If your lordships were to see, the notice in subsection 2, that is subsection 3. The notice referred to in subsection 2 shall give the details of the amount payable to the borrower and the secured assets intended to be enforced by the secured creditor in the event of non-payment of the secured debts by the borrower. So the secured debts for which there is a default, for which there is a declaration of NPA, notice will be issued to me saying that the secured asset, it is not necessary that they should proceed against all the secured assets in a security agreement. The secured asset against which they propose to proceed under 13(3) is required to be notified for that secured debt. Then 3A, if on receipt of the notice under subsection 2, the borrower makes any representation or raises any objection, secured creditor shall consider such objection, or if the secured creditor comes to the conclusion that such representation objection is not acceptable, he shall communicate the same within 15 days of receipt of such representation objection and the reasons for non-acceptance of representation, provided that the reasons so communicated or the likely action of the secured creditor at the stage of communication of the reason shall not confer any right to the borrower to make an application to section 17 or 17A. In case the borrower fails to discharge his liability in full within the period specified in subsection 2, secured creditor may take recourse to one or more of the following measures to recover the secured debt, namely 1, 2, 3, 4, 5. I will not trouble your lordships on other things. But the emphasis is therefore on 4 words. There is a secured creditor, there is a secured asset which forms a part of a security agreement based on which there is a secured debt. This is a composite transaction by itself. Now, if they want to spill beyond this, they go beyond the scope of what is contemplated under the scheme of the Act itself. Act never contemplates this. No, this is a special statute. Notwithstanding what is contained under the Code of Civil Procedure or any other law, special powers are entrusted with the officer. These are more expropriatory in nature. I don't say it is remedial, because they have the powers to expropriate the properties through the process of law which is provided for under this Act. So the expropriatory legislations always require strict construction. Now, if this is the expropriatory legislation which we are dealing with, the requirement was they should have issued specific notices, debt specific, and then they had to proceed with the proceedings debt specific. Only exception may be that if one property is mortgaged in respect of 2 debts, let us assume a situation of that kind. Secured asset is 2 for both the security agreements. There probably it may be permissible. Even there, the proceedings will have to proceed parallelly, but not as a club proceedings. Because one property, if it is mortgaged, the other mortgage, there are rights of marshalling, which is provided for even under the scheme of the Transfer of Property Act. So they will be entitled for it. This being the scheme of the Act, what they have now done is 30 lakhs loan, which I borrowed in the year 2014. They say that no, this is about 1.8 crores is the security which we want to extend on this property. I will show how hollow this is. 1.8 crores cannot be. Lordships may kindly have a look at the valuation of the year 2014 when they had advanced this loan to me.
Where is that?
Page number 15 of the rejoinder. Lords, page number 15, annexure AK. This is on 26/8/2014. Lords, this is submitted to so and so. Office note. I'm sorry. The one in the upper portion is the office note. Sanctioned term loan 30 lakhs for construction of so and so.
Yes.
Lords, this is on 26/8/2014.
Yes.
The date on which the document comes into existence, this is on 26/8/2014.
What is that date?
26/8/2014.
Even that document.
That's
No,
27/8.
Hmm.
30 lakhs for construction of storage godown. This is what I have borrowed. Now your lordships will kindly see at page number 17.
Yes.
Lords, the construction of storage godown is the hypothecation of storage godown valued at 40 lakhs. Collateral. Continuing EMT of converted land at survey number 21/2 of Shanmangla, Biddi, Hobli, Ramnagar district in the name of Sri Sampath Kumar, measuring 31581 square feet valued at 205.28 lakhs as per the valuation report dated 24/6/2014.
What is the present value? No, they are
Same value, 2 crores 5 lakhs. In 2023, after the layout is formed.
2 crore 2 lakhs, sir. 3 lakh less. 2 crore 2 lakhs.
2 crore 2 lakhs. I'm so happy about it.
Yes.
Lords, the reason why I read to your lords, may I kindly also have a look at page number 18. This is the valuation report which they are referring to by B. Lakshmi Narayana. Ido, 2014.
Then 2 lakh, 2
Yes.
crore 5 lakhs.
2 crores 5 lakhs. Now, your lordships may also have a look at in the writ petition papers, annexure P, annexure P and annexure N,
Page numbers.
page number 120. This is when they wanted to bring the property to auction in 2023. Same Lakshmi Narayana is the valuator. We got the valuation from the same valuator, who is the empaneled valuator. Notice the property value is 6 crores 15 lakhs, according to the valuator of the bank.
He says the value of the land is 3 crores.
Lord's value of the land by adopting GLR, guideline rate, is 3 crores 96 lakhs. It's only the guideline rate.
Then why why the offset price is 2 crores?
Lords, then prevailing market value is 1950 per square feet. Lords, at any rate, there are constructions on this property. Lords, is taken that anyway, 3 crores 96 lakhs is as fixed by the sub-registrar.
At that point, my lord, he can't raise before this honorable court. Sale.
I will conclude my argument.
This argument only in respect of section 40.
Lords, I will conclude my argument. Section 14 argument is obtained fraudulently. My entire case is that this order has been obtained.
Argument only with respect to section 14, my lord.
I know what butterflies are running. I know, I can understand what would have been happening. It's not a straightforward case for Mr. Vignesh Shetty. I can assure that much. Now, this is the valuation. Let us presume that this is not the valuation. 3 crores 96 lakhs is the valuation even as per the sub-registrar value. Now, your lordships may kindly see the encumbrance certificate produced along with my rejoinder at page number 22, under which they have caused the sale certificate to be registered.
He appears for the auction purchase.
Yes.
20?
22. Article name, certificate of sale, market value is 3 crores 81 lakhs 45,000. Consideration amount is 2 crores 2 lakhs 8,000. Half. My property was mortgaged only for 30 lakhs. One site was sufficient or 2 sites were sufficient for the purpose of recovering this entire money. But what they did, they had all these papers probably. We do not know because we have been there from 2005 and onwards. We have been there. Our accounts were not treated as an NPA till such time the first default occurred because our gas go down under which we were getting this money shut down. Otherwise, we were servicing the interest. They would not have given us the loan up to 2014, 2015 because 10 years we were very loyal customers. We have been paying all the interest. After this is the mischief which they do. They knew that this is the property, this is the secured debt is only 30 lakhs. And for that, they wanted to show that the due is in excess of 4 crores 18 lakhs and they wanted to recover possession on this property. They have virtually played a fraud because the requirements under 13(2) having not been complied with, they cannot proceed further because 13(4) arises including the power to take possession of the property only if they have complied with 13(2). 13(2) they are in a position to demonstrate they have not complied with. And there is a fraud played by them. Now, if your lordships were to also have a look at that sale notices issued, etc. Lords, I'll just take your lordships to that rejoinder, page number 51.
Yes.
This is the layout which has been formed. This was in 2011 that the layout was formed actually. The complaint filed by him resulted in acquittal. All the properties have produced the khatas.
Who has purchased the property now? Who is he?
Not
I'm
some-
purchasing the property. They are purchased in auction.
Third party.
My lords, we know what they have done.
Someone,
In fact, we also will point out. This is a one case.
he's also working in the bank.
No, no.
My lord, saying something, my lord, it is nothing on record. My lord, saying something, my lord,
Considering
anybody can say
everything on
anything.
record, I'm
I'll
referring
point
to
out
documents.
From the order passed by this honorable court, how they refuse to.
File my rejoinder.
Mr. Senior Counsel, we'll hear him. I think you've come.
Just one more statement, my lords, I wanted to make and leave it at that. If your lordships were to see the Securitization Act. ಎಲ್ಲೋ ಇತ್ತದು? Where is it? Page number 96, which I have drawn your lordships to.
96 of the red petition.
Yes, this is by the Asset Recovery Management ARM2 branch, MG Road.
Hmm.
All these properties are situated within the limits of Biddi. And there is an authorized officer, which the jurisdictional authorized officer for this is Mandya. Why it was withdrawn to ARM? Lords, we have made a statement that he is the person who has done this, Jairam Reddy, because he eventually retired as the DGM of ARM2. I don't know when he retired, but he is retired there as. So now, my lords, this is the difficulty with which we are placed. If it was on a loan-to-loan basis, we could have easily cleared it. Now I want to go to the next step. What happened? They gave a OTS. We paid about 1.5 crores. Further amounts we could not pay it. It did not happen. Whenever we pay the money, they will adjust the money towards the loan accounts which they want to. If I want them to make this payment and say that you close this loan account, they don't want to close this loan account because it is a secure debt specific. As long as the property is not brought to auction, I had the right of redemption. But property should have been brought to auction for that secure debt. Beyond that, they don't have the jurisdiction to exercise because 13(2) restricts their jurisdiction. Now, there are a series of judgments, which I will let them conclude. I'll just point it out.
Lord, I just.
No, Mr. Vignesh.
This one property is sufficient, my lord, sir.
It is a one case wherein, my lord, it's a classic case. My lord, abusing the process of law. I'll just point out, my lord, two order passed.
No, you can make your submissions. Before that, you just clarify 2-3 aspects. One is, now as far as this order under section 14 is pertaining to survey number 21/2. That is what they have, you have the copy of this.
The one property which I sold.
Yes, that is sanctioned amount is 30 lakhs.
My lord, kindly come to their own admission. My lord's argument, my lord, my senior counsel made it. Kindly come to page number 12. Their own admission, or how many loan, my lord, they availed. They can't go back from their, my lord, pleading now. Kindly come to, my lord, page 12.
Not about that.
I'm so sorry.
No, you please tell the court this proceedings under section 14 are in respect of this loan account.
30 lakhs.
MSME loan account 30 lakhs. 7/8/2024, and the property mortgage is survey number 21/2 so and so.
Yes, ma'am.
So you have issued the notice in respect 13 notice in respect, and what is the outstanding loan amount for this
my lord
property?
My lord, that is the reason, my lord, I said, my lord, kindly come to page number 12 of their petition. Their own admission, there are 9 loan availed in respect of the very same, my lord, subject property. Out of that, one of the term loan is, my lord, kindly come to page number 12 for a moment, tableau number 4.
So you mean to say they have obtained the loan in respect by mortgaging the very same property?
Same property. There is no, my lord, page number 12. Their own admission, I'll just read it.
From here you can see.
Not that petition.
Para 3 of the petition.
Page number para 3.
Yes, read it.
The petitioners need to housing loan and also financial assistance for the business of, therefore, the petition approached the respond bank and respond on the collateral security of 8 immovable property owned by the properties, sanctioned various trade facilities to the petitioner and his wife under the individual names as well as their propertyship concerns, name which are listed below. 1, 2, 3, 4, 5. The fourth loan, which is mentioned 30 lakh, 5, 6, 7, 8, 9. So one of the loan is, my lord, term loan is 30 lakh rupees. Therefore, we file an application under section 14. There is no bar for me on that. My lord, in fact, my lord, I have a banker's lien also. My lord, in fact, I have additional my lord, this aspect, my lord, raised before this honorable court in earlier rounds of litigation, that I'll just point out. My lord, we answered. Kindly come to page number 186 for a moment. The very same prayer, my lord, first and foremost, my lord, he has to answer before this honorable court how this writ petition is maintainable. Very same section 14, my lord, assessed before this honorable court dismissed with cost. That order I'll point out. My lord, kindly come to page number 186 for a moment.
186.
My lord, order dated 19 January 2024. Heard so and so learned counsel for the petitioner and so and so learned counsel for the respondent. My lord, I'm reading 187. The petitioner is before the court calling the question proceedings series number 117 of 2023. My lord, kindly come to a prayer we sought before this honorable court now. At my lord, page number 41.
My learned friend is capable of finance enough to understand. We challenge the proceedings when it was pending before section 14 court. In
I'll
that
just
writ
read it,
petition,
sir. I'm not just 1 minute. Kindly clarify. I'll just read the entire order. 117 of 2000 pending before the principal civil judge at CJ Ramnagara under section 14 of the SARFAESI Act. What is called in question is not an order passed by the learned magistrate under section 14 of SARFAESI. The bank files an application under section 14 of SARFAESI Act for the necessary orders for hands of the learned magistrate. Even before the order passed, the subject petition is filed before this court. The petition is a borrower defaulter in making the payment on the finance so secured from the respondent bank. The petition then approached this court in WP number 6268 of 2023, in which certain interim order is passed. The said writ petition is pending. A second writ petition comes to the filed on dated on WP number so and so, which comes to the dismiss on dated 29/9/2023 by the following order. See, say so and so learned counsel has entered appearance for the respondent. Learned counsel submits that he has received a copy of the writ petition along with annexes. Learned counsel for the respondent bank submits that the petitions have not approached this court with a clean hands. The petitions have not mentioned that earlier they have filed writ petition number so and so and obtained interim order at the hands of this court on 17/3/2023. This court had restrained the respondent bank from proceeding further in view of the interim order passed by this court. However, the petitions are directed to demonstrate their bona fide by making substantial payment to the respondent.
I've seen that.
Well, this on page number, paragraph number 9 says, mere filing the petition by the bank cannot be seen to be giving petition to the cause of action to knock the doors of this court. Mere so the light of the fact that petition is a borrower on every occasion changed the counsel and has secured the interim order at the hands of this court. The last being the what is quoted supra, though the interim order dated 30/3/1/2024 in WP number 275/2024 is not complied. The time stipulated, my lord, this honorable court, my lord, dismiss the writ petition. My lord, I'll just point out two aspects. I'll just point out two aspects. Before my lord going to the merits, my lord, I'll just point out two aspects. One, the prayer we sought before this honorable court, my lord, order passed under section 14 by the magistrate. It is also not in dispute, my lord. Earlier rounds, there are 8 writ petition filed before this honorable. This honorable court dismissed, my lord. They themselves produced, and in fact, my lord, I also date with my lord dates.
The manner in which the affairs are conducted by the bank are fair, and according to the provisions
No,
of the Act.
the allegation which is making, my lord, I am.
Why don't you answer on the merits of the matter instead of going to the technicalities? So whatever the senior counsel is arguing appears to be some glaring aspects.
Please, my lord, my lord, may I ask?
So you please address the court on those issues.
Please, my lord.
Yes. Now, first is now we will. What is now the for this property that is in survey number 21/2? What are the amounts that are borrowed by mortgaging this property?
My lord, there are total 8 accounts. That is the reason, my lord, I'm keep on saying, my lord, my submission before
this property I'm asking. By mortgaging survey number 21/2.
It's a common security for all the loans.
That's what that you can tell. What are the loans?
My lord, one loan is, my lord, their own statement before this honorable court at page number 12.
They don't say so. What you have read is they say we have taken 8 loans by mortgaging different properties. That's what they said so in paragraph number 3.
My lord, I'll just point out in this way. There are 8 loans availed by them. There are 8. I agree, my lord. There are 8 loan, my lord, 8 properties, my lord, given as a collateral security to me. It is not in dispute. There are 3 loan. There are 8 loan, not 3. There are 8 loan. In respect of that, I initiated 3 separate proceedings. Therefore, 3 writ petition before this honorable court.
I think my question is very simple. I said in respect of survey number 21/2. Where he has, according to them, they have borrowed 30 lakh loan. According to you, apart from this 30 lakhs, by mortgaging survey number 21
My lord,
oblique.
kindly get it.
Have they-
I'll take an instruction on that effect. My lord, kindly pass it over. That one document I'll put.
No, apart from that also, I'll ask you 3 questions.
Please, my lord.
That also you clarify.
Please, my lord.
So this is one. Now, apart from this 30 lakhs, have they borrowed any other loan by
Please.
mortgaging this property is number one. Then number two, as per the valuation in the year 2020, 2014.
For that, my lord, I can
when
answer.
When the property is valued at 2 crores and odd, you have sold the property, less than 1,000. That was the offset price that is set by you for
The
this sale.
2017, my lord, the account became an NPA. I put the property for, my lord, multiple occasion. I put the property for auction.
But you
No
sold-
bidders
sold
came
it in
forward except, my lord,
2020.
litigation from the, my lord, petitioner. What is the other option for me? I have to reduce the price and I have to sold it. And in fact, I took a valuation from the, my lord, I produced, my lord, kindly see the last state of order passed by this honorable court. They argued on the, my lord, valuation of the property. And, my lord, they said that my property worth of 5 crore rupees. That's what, my lord, it is, in fact, it is accorded. I produced the, my lord, sale deed. My lord, which they purchased the property. It is before this honorable court. What is the value of the property? The sale deed which I produced. And also, my lord, I took an valuation from the approved value, which Act, my lord, contemplates. I took an valuation. It is produced before this honorable
He
court.
says 3 crore and odd.
No, 2 crore. My lord,
No,
kindly
no.
come to, my lord, the memo
According
which I
to
filed.
it is 3 crore 98 or 88. he
My lord,
says
kindly
so.
come to memo which I filed on 10/11/2025. The valuation report which I produced, valuation which I obtained from the approved valuer, panel valuer. My lord, kindly come to, my lord, valuation report for a moment at page number, my lord, 15.
What is it? What is
It
the
is, my
amount?
lord, it says that, my lord, 2 crore 2 lakh.
How can it be?
My lord, valuation is, my lord, mixed, my lord. Valuation, my lord, my lord,
Sub-registrar's value will be there, first of all.
My lord, it is a property which I am not able to sell it. From 2017, I am putting the property for auction next to, my lord, property, my lord, burial ground. Even though, my lord, sub-register value is there, my lord, if I am keeping next 25 years also, I can't sell the property. I don't have option. Next to this property, my lord, I will produce photographs. This is burial ground. Nobody is coming forward to buy this property. What is option for me? 2017, my lord, I am running pillar to post. Except, my lord, one after one writ petition, my lord, he is not paying money. I given a one-time settlement offer. Now, my lord, my senior counsel made a submission saying that I am not able alone. That is the case, my lord. Why they accepted the one-time settlement offer, which is their defaulted? They paid some part.
And one more thing, what you have to clarify is, when this loan is obtained by mortgaging a particular property, under which provision, under which law, the bank is entitled to sell this property in respect of the other secured loans. Which
we are not done in this matter.
Huh?
Which we are not. I'll file memo.
No. Now, the 14 order, section 14 order by the magistrate, wherein you have stated that the outstanding amount is 4 crores. How that amount has become 4 crores? When the property is, the loan that he has taken is 30 lakhs, how it has become 4 crores?
That, my lord, I'll answer.
That also clarification is required.
My lord, kindly pass it over, my lord, 2:30. I'll okay.
Great fingers.
Cell number 2.
My lord, I beg to appear on behalf of my lord, respondent.
Yes.
Valuation.
Yes.
Yes.
This DRT matter, I'll withdraw this case, withdraw the petitions in a state of kindly week time.
No, for withdrawing the petition, why should we grant a week's time?
Because I have to
For
file memo.
representation on 112.
I'll file memo, ma'am.
My lord, I filed a statement of objections. In fact, huge outstanding is, my lord.
We paid it, ma'am. Paid it, already paid it to all, whatever the huge amount is, paid it to you. I think maybe 8 crores due. You are paying a regular in, no,
13 crores.
Only 8 crores.
8 crores. Others 24 crores, my lord.
Oh.
That's all.
So you have an interim order from 24.
Yes, I'm paying, ma'am.
Then why should we grant you 1 week time?
Because I have to get signature from a client, my lord.
It's already under the caption dismissal because you have not appeared from the last 2 occasions, not 2 occasions. I think 3 occasions.
In fact, my lord, subsequent to this, one more writ petition filed before, my lord, coordinate bench, and that got dismissed last week. They had given
What is that writ petition?
opportunity.
Questioning what?
They're challenging my, assailing my sufficiency.
Submissions, this court has not proper jurisdiction. You have to approach before the order.
That is a order passed by the coordinate bench. Last week only.
That's what this also applies.
No, that's what I feel, memo of withdrawal before. Otherwise, I have to give 1 month's time. I'll appear before the proper court.
No,
Anyway, no, in this case, my lord, at least 2
This
weeks
is
time.
Pata on Monday
Yes,
under the
madam.
same caption.
Yes.
Finally, at the request of learned counsel for the petitioner, next three.
Cell number 3, Kavita D.
My lord, in this case, with liberty to give approach DR80, my lord.
Oh, who stopped you from
No,
24?
no, my lord, in
approaching the
this case
DRT?
only I have given mandamus direction, my lord, to consider my representation. If they consider, my lord, today itself I am ready to
For the
clear
OTS.
entire loan.
For the OTS. How
OTS,
can
my
we
lord.
grant such a mandamus recognition
No,
to the bank to consider your OTS? They'll consider
My
it
lord,
as per
from
their
past
procedure.
4 years, we have been in struggling only. We have no even income from
But
the.
unfortunately, court can't issue a mandamus.
But it's a case, my lord, where, my lord, they, my lord, manhandled my officers. We have taken a physical possession of property. They came before this honorable court. This honorable court shown certain indulgence. We have handed over the key back. When you're handing over the key back, my lord, in fact, I reported in the earlier rounds of it. They are not entitled for any relief from this honorable court. In fact, interim order also not complied.
Interim order is complied,
No, no.
fully complied. Interim order is complied, my lord. 10 lakhs we are supposed to deposit, I have deposited.
The present petition is fine. Seeking the following prayer. Learned counsel appearing for the extract the prayer. The learned counsel appearing for the petitioner submits that the petitioners are requesting the bank for one-time settlement and so far. And in spite of repeated requests made by the petitioner, the respondents are not considering the same. Hence, there may be a direction to the respondent bank to consider their representation, seeking one-time settlement. Learned counsel appearing for the respondent bank submits that the petitioner is not entitled for any relief from the court, and as for in the light of the settled law, there cannot be a mandamus mandamus cannot be issued to the bank, directing them to consider the one-time settlement as requested by the petitioner. What is the interim order in this?
10 lakhs I supposed to deposit, my lord.
What is outstanding?
For my OTS proposal, my lord, 40 lakhs, but their calculation is 78 lakhs, my lord.
On 1/10/2024, a coordinate bench of this court had granted an interim order directing the petitioner to deposit a sum of rupees 10 lakhs within 2 weeks, failing which the interim order will stand vacated automatically. And the bank is at liberty to proceed in accordance with law. Then counsel for the petitioner submits that as per the interim order, they have paid an amount of rupees 10 lakhs. 10 lakhs. It's for having heard the counsels on either side for a material on record. The petitioner is seeking a direction to the bank, seeking a mandamus to the bank to consider their representation for one-time settlement. This court cannot issue such direction to the bank. And if it is for the petitioner to avail any legal remedy if the appropriate remedy, but there can't be any direction from this court. Accordingly, this petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy.
Still number 4 for order. J. Mala Shetty.
I appear for the appellate. I have made the deposit before the court. My lord, this is a matter arising out of Employees Compensation Act. I made a full deposit before the trial court. They issued a certificate at page number 35. Since there was no signature, this court, my lord, directed the registry to secure the, my lord, a certificate from the court below, whether we have deposited or not. Accordingly, I understand there is an email conversation and they have produced the email conversation stating that insurance company has deposited the 100% of the award amount with interest. And for several days, my lord, the file was missing. We were following the file.
So what happened finally?
Finally, now, my lord, the office objection which was raised that whether the deposit was made or not, my lord, has to be overruled in view of the email.
File MFA number may be security after taking further steps. File received from pending branch on so and so. A letter has been addressed to the concerned tribunal to set details for deposit and same is placed at flag number so and so. in the light of the fact that the tribunal has sent the communication to show that the amount is deposited, the office objection with regard to payment of the amount is overruled.
There is
Yes.
one more official note, office note, note that page number 11, the
Page
judgment, the date is mentioned as shown as 17th December 2024. But however, page number 11. However, it was decided on 16/1/2025 at the top, my lord may please see. And my lord, it was signed also on 16/1. Kindly see page number.
All these objections, it is your problem to get it rectified from the trial court.
Not, since these are the, my lord, the
What I'm saying.
typographical errors.
No, that's what, if there is a typographical error, you should get it done.
Okay,
No,
okay.
all the insurance companies, all the owners, they're coming before the court saying that as if a office will raise the objection.
But there are dates, my lord, which shows the correct date. That's precisely what my request is.
So that is true, but you should have,
For
your
these-
counterpart should have sought for a clarification from the court and should have get it clarified.
But it is forthcoming in the order itself, my lord, is my submission. At page number 30, my lord, may please see.
No, for example, if I am dictating the order, I would say dated 17 December
17.
2024 because it is there.
That's precisely.
So what is the difficulty in getting it rectified? That is what I am asking. I have informed all the council that hereafter I will not consider this. The
This time.
officers, there is other objection that the order at one place, it is shown as date of order as 17 December. And at the other place, it is showed as decided on 16/1/2025. Even the signature of the judge is also 16/1/2025. If that is so, it is for the petitioner to get a clarification on that typographical error from the court. But unfortunately, they're seeking whenever office objections are raised, they're coming before this court with a counsel submission. It is clarified that further these kind of the objections raised by the office will not be overruled, and it is the responsibility of the petitioner to get it clarified.
Please.
As far as hence the objection with regard to the date of the order at page 11 is overruled.
Sought for stay of the matter.
What is this, how much is the
So
amount?
1,32,000 is awarded. The policy does not cover, Lord, the liability under the Employees Compensation Act. That was the condition taken. And there was no employee-employer relationship.
It's submitted that there is no employer-employee relationship, and in spite of that, the tribunal has granted the compensation. Hence, there shall be stay of all further proceedings. Notice to the respondent.
Please,
Yes, next.
grateful.
Cell number 5. Cell number 5, A. Krishna Swami.
I'm appealing for the appellant, my lordship.
Revalidation.
My lordship, kindly permit for the revalidation of check, my lordship. We already produced on time.
The petitioner.
Kindly grant for the 8 weeks time, my lordship.
Why? For
Because-
depositing the amount 4 weeks and for
Because
revaluation 8 weeks.
again, the insurance company required to intimate the HO as well as the PO, my lordship. That's the reason.
Then we will vacate the stay.
We already deposited, my lordship, by the,
But it can be realized.
at a 6-week request. My lordship. Because
It is submitted that the petitioner sought permission to revalidate the DD dated 9/9/2025 for an amount of rupees 3,33,816. The same is permitted, and the revalidated DD shall be placed before shall be filed within 6 weeks from today. They should return the DD. Registry is directed to return the DD. Yes.
Cell number 6.
oblige, my lordship.
Cell number 6, Ravi Shankar CR.
Appellant, my lord. It is the time barred, sir. Time barred.
No, what is this council
amendment.
submission, maintainability?
That is the only one, because,
It's a case of death or injury.
injury, lordship.
The-
81,000, 26,800.
This is taken or is objection with regard to the maintainability as the amount that is awarded by the tribunal is below 1 lakh. Is below 1 lakh. The land council submits that the insurance company is on the question of maintainability. Hence, the bar will not apply. Accordingly, the office objection with regard to the maintainability is overruled. I number 1 of 25. When counsel appearing for the appellant submits that, what is it? It is a time barred.
Yes, Your Lordship.
It is that the beyond the limitation, the claim petition is filed and the same is entertained by the court. Considering the same, there shall be stay of all further proceedings. 50% 4 weeks. Notice to
Right.
respondent.
50% already departed because 26,100.
You already deposited.
It is a 15,
If it
statutory
is there, it
itself
is-
is, statutory itself is 50%.
The next 7.
Cell number 7, B. Pradeep.
I am for appellant, my lords. Insurance company challenging on the road liability, my lords, as on data permit violation, my lords.
In this case, same as far as the maintainability is concerned, now it is with regard to the permit violation, that is post amendment.
Please, my lord.
Amendment and insurance company is not liable. It is the appeal is, hence the appeal is maintainable. In the office objection with regard to maintainability is overruled. Then coming to the IA for stay, it is submitted that this accident has taken place after the amendment and that there is no permit and there is violation of terms and conditions of the policy. The insurance company is not liable, but still the burden is placed on the liability is placed on the insurance company. Hence, they shall be stay 50% notice 4 weeks. Next.
Cell number
I
8.
have connected matters, my lords. 3 more matters, my lords. Already granted stay, my lords. Matter may be con-
List these matters along with so and so.
Please, my lord.
Yes,
8.
8.
N. Suresha for petitioner. Vignesh Shetty.
My lord, the petition, my lord, challenge the sale notice.
Interim order is there in this.
Interim order is there, interim order not complied. In fact, my lord, the last one line, my lord, the liberty to be reserved if any, my lord, that is the reason I'm not issued a sales certificate in favor of the auction purchase.
When was the interim order granted?
Sale notice dated, my lord, 24/5/2024.
No, when was the interim
IO
order
granted on 25/6/2024, my lord.
No representation on whether petitioner is this matter for dispute.
Your Lordship, just had a short submission. I've actually filed an application to implead. Now, what has also happened is that the premises that was actually put through in an auction was owned by the petitioner. Now, they're harassing me, although I've actually been successful at the bid. They're harassing me.
When we are dismissing the writ petition itself,
Much obliged. Much obliged.
tomorrow for dismissal.
Great.
Cell number 9.
500 square feet property, Lord, 7 lakh rupees the due amount. They're ready to pay the entire due loan.
Where is the counsel for the respondent, Mr. Shashidhar?
Mr. Sridhar is from past 2 occasions, he also not
Let's see.
paid, Lordship. Lordship, this is a
It's a
small.
2024 matter. I
Yes,
think there can't be
2024
any
matter. We
urgency
made
for
all
this
the
now.
efforts to list it several times, this matter, Lordship. Small amount, we wanted to pay it. There is some
Which is
discrepancy
the
also.
bank?
Bank is the NBFC, Lordship, Aptus Value Housing Finance. Now we also came to know, now they are transferring it to ARC, Assisted Reconstruction Company. So before that, it will be settled down, Lordship. This 7 lakh rupees, small amount, 500 rupees, 500 square feet property, Lordship.
There is no representation on behalf of the
I filed
respondent.
one IA also to stay the proceeding, Lordship.
I will not grant it in 2025.
Now we are ready to pay the entire amount.
No, no, no. There is no representation on behalf of the respondent. Counsel for the petitioner is present. Let's just matter next week. If on that day also there is no representation, orders will be passed based on the merits of the matter.
I request for the date, Lordship.
16th.
Yes.
Cell number 10.
Obliged.
Waiting for respondent.
And Dada.
Petitioner in this matter matters.
Yes. And office objection shall be complied by the next date of hearing in 9, or else the writ petition shall be dismissed on that ground. Even in the other matter also, 8 also.
Office
the
objection
shall be
needs
complied
to be
with.
complied by the
For you.
respondent.
Annexure D is, we'll furnish the copy, Lordship. Their copy will furnish. We'll comply, Lordship.
That's what I'm saying. You have to comply. Yes, 10.
I am for the petitioner in this matter, my lords. They filed an application for vacating of the interim order which granted. I pressed time to file objections
Why?
for this application, my lords.
Why?
I filed an application
Application?
to vacating the
I have
interim
filed
order which has been
application for
granted by
vacating
this
stay.
court.
He is seeking for time to file objections.
Not required.
Please, my lords.
Yes, Arvind. What is the impugned order?
Impugned order is this. Say we have challenged the notice dated
Pass the communication letter
20
issued by the
20
second respondent.
Please, my lords, annexure M page 46.
Who is the second respondent?
Respondent number 2 is bank, my lords. Bank has caused a notice to me informing that the property will be going to action.
Ashok Nagar Cooperative Bank
Please, my
authorized
lords.
officer.
Please, my lords.
So why it should be quashed?
The facts is this, my lords. One Naganme Goda has availed a loan. He is the surety. Petitioner is the surety. They given a OTS proposal for me on 26/8/2024 as per annexure L, page 44, saying that outstanding amount as on 26/8/2024 is 22,50,241. Whereas for OTS is concerned 17,50,241. I have paid 17 lakhs, and the rest of the amount is concerned I have given a DD. That is, these proceedings has been before the authorities, before the first respondent authorities. But they have not accepted the DD and refused the same, and they proceeded to take an action against the property. That is the letter we have challenged in this writ petition.
Yes.
I am interested to clear the entire things
Yes, yes.
as per the OTS.
Malad, I am the successful bidder, Malad. I have
Where
done
is the bank?
bank or bandilla. Bank or
Bank respondent number 2 bank has to be. Respondent number 2 is the bank.
No, we are given NOC. No, I have given NOC. Some other lawyer has appeared. Filed wakalat on my.
I'm sorry, Malad.
RP
You know,
so
his
much-
sir is appearing for.
I'm appealing for the bank, Malad. Malad, in this case, Malad, the impleading applicant, Malad, who is the successful bidder, Malad, he has deposited the entire amount of rupees 1 crore 10 lakhs, Malad. He has taken possession and he has been paying the installments regularly, Malad.
Not on that.
Please, Malad.
When you have come forward for a OTS settlement, OTS scheme, and he has paid the amount, why did you put the
Malad, he has
property
not
to
paid the amount, Malad. Therefore, Malad,
What is that? What is the OTS amount that you have offered? What he has paid or
Malad,
not
you
paid?
can turn to annexure B, Malad.
Page number?
Page number 26, Malad. Annexure C.
Yes.
This is the letter addressed by the petitioner to the bank, Malad. Payment made by me pertaining to compliance, Malad. Only part of the amount was deposited, Malad. According to the letter
He's
himself.
saying he has paid 17 lakhs.
Well, rest of the amount he has not paid, deposited.
What
Malad.
is the rest of the amount?
Well, totally 33, Lordship, can you turn to?
No, you have filed your objections for your vacate stay. You must have stated so all that. Come to your vacate petition.
That is not their pleadings in the application filed by us.
You appear for whom?
Malad, my colleague is.
Then already somebody has filed impleading application.
Impleading application is filed by the purchaser, Malad, for
Where
vacate.
is the counsel?
Council is.
Where did you say so in your vacate petition? Please tell the court.
Malad, in the vacating stage, which they have served,
I find a caveat here. All judgments, no facts in the vacate petition. No, according to him, as per the OTS, it is 17 lakhs 48,000 something. He paid 17 lakhs and 48,000. He has given some
No,
video.
that is not the OTS one. Malad, he has failed to pay the amount of rupees.
That should have been stated in your vacate petition.
Malad, I will get instructions. Malad, you will actually carry out tomorrow, Malad.
Even
No
annexure.
tomorrow. List this matter after vacation. Interim order earlier granted is extended till then.
Cell number 11,
Yes.
Karyanar.
Hearing for the respondent bank. My
Divya.
lord, in this case, sale notice is being challenged and also possession
For
notice.
petitioner.
They have not complied with the interim order, my lord.
They have not complied?
They have not complied, my lord. Not a single pie has been paid.
From my own submission. I have paid the 55 lakhs, my lord, to the bank.
Issue, when is that? 18/3/2025, the order is, remind there shall be an interim order of stay till the next date of hearing, subject to the petitioners depositing 20% of the outstanding amount. What is the 20% of outstanding?
My lord, 20% is, my lord, outstanding is around 3 crores 18 lakhs, my lord.
Hmm.
They have not paid even one single pay. I produced the statement of accounts also, my lord. Nothing is paid. I filed
paid
these.
55 lakhs. I'll place it on.
3 crore lakh amount, what is this 55 lakh?
Regularly, I'm paying the,
No, my lord, I produced a statement of accounts. There is nothing forthcoming.
I also place it on record, madam, with memo.
Should have done it by this time. I'll
Uh,
not, just like that from
second.
18/3/2025, you are enjoying the stay. And why are, and what on the merits of it, why should we interfere in this? Please argue on that. Ask your senior to come pass over.
Cell number 12. MS Nagaraja, KV Lokesh.
By next, but this all will pass orders later. 12, yes. Yes.
Lord, last occasion, your lordship has granted interim order and directed me to produce the acknowledgement for having service of, my lord.
1 minute. Where is the interim order? I have granted? Then transfer the petitions of the notice was issued on 13/2 and the reply was given. For that, the bank replied on 16/7/2025. No acknowledgement is filed and they have not received the same. And transfer the petitions of the, yes, an acknowledgement and he will file the same before this court. Let's just matter on. Respond bank shall not take any course. What is this?
Lords, 13/2 was issued. The legal heir of my borrower, the legal heir died. In fact, 13/2 was issued very long back. Again, fresh 13/2 was issued. They had replied, but there was a delay in our reply. So 70th or 75th day we are replied. Even otherwise, my lords, already Supreme Court has said 13/3 rule, 13/3 compliance is not mandatory, and if and it depends on what until to what extent they have agreed. In this case, only claim by the petitioner is that she will offer one-time settlement proposal to. She has offered one-time settlement.
What is the outstanding amount?
Outstanding amount is more than 70 lakhs, my lords. And we told we can't offer one-time settlement for you.
36 lakhs. 36 lakhs is outstanding. My lord, borrower is also died, my lord. Even guarantor is also not. They are not issued the notice to all legal heirs, my lord. Even after.
Who are you?
My lord, I am one of the wife of one of the legal heirs. The other daughters are there. They have not issued the notice. Only they're targeting me that I have made a representation, my lord. This is the situation. I lost my husband, my daughter-in-law also. Give me a concessional rate, my lord. I'm going to settle the matter. They take a coercive steps, causing the notice under 13/2.
Amount is 36 lakhs?
Yes, ma'am. That is in the demand notice itself, my lord.
Approximately 42 lakhs it will come, lords. This demand notice was issued way back in. Lords, the issue is that if some are not issued to notice to the other legal heirs, they should come and challenge. And in fact, he's claiming contention that some sisters who are not my borrowers, like sisters of my borrowers, are also the legal heirs are very much in existence, but we are not tied. The declaration given by the borrower at the time of taking the loan, who are his legal heirs, for them we have made them legal heirs.
How many, according to him, who are the legal heirs?
Is the legal heirs have been issued the notice, the 13/2 notice. He's one of the legal heirs. The petitioner is one of the legal heirs.
You ready to set the?
No, not yet, not yet. Please, I produce the document, ma'am, legal heirs.
No. Are you ready to settle the payment?
If they're considered, my lord, I definitely.
They are offering.
What consider?
They have to, I have made a representation long back, my lord, in December itself. My lord, after death of her husband, my lord, petitioner husband, she made a representative voluntary. Because that there is some loan is there. See, I have given a RBI guidelines, my lord, one-time settlement is that. You are giving a one-time settlement proposal. I am ready to settle the matter.
Amount is like a small amount.
Let's kindly come to the one-time settlement proposal which they have sought under writ of mandamus.
We will not issue such direction, but new amount is.
No offer is given. No offer is given. Just blanket it is telling kindly give me, my husband has died, my mother-in-law has died. Kindly give me discount.
Yes.
OTS. No offer is given. What is the offer?
Offer, my lord, I request that the one-time RBI, as per RBI guidelines, I requested that give me a concession rate, interest and all.
No, if they are giving, you have to take. Court cannot direct them to.
The second prayer, I will challenge the securitization notice, my lord, is a course step they have taken.
Them file appeal
That
before
now I have
DRT.
give the reply. They have not considered my reply also, my lord. They have not considered my reply. Even that is replied of that has been after 2 months.
You please come out with whatever your proposal is, or else I have to dismiss this writ petition.
That is considered to them. I will challenge the validity of the notice 13/2, my lord.
That we will consider in the light of the Supreme Court judgment.
If they produce, my lord, they are not challenged. They have filed the objection. They are only the maintainability of in respect of one prayer. They have not filed any objections with
If
me.
you are interested to settle the matter, you settle the matter.
Yes, my lord, definitely,
Yes. Give a
definitely.
proposal, what is the amount you are ready to pay?
Yes, definitely, my lord. If they are not, they are 2 times called
At or
upon.
next week,
Yes.
by
Interim
the
order.
time the petitioner shall give a proposal to the bank.
Yes,
And the bank shall respond, they shall come up with their response. If the proposal is not given by the next date of hearing, the stay granted with this court stands vacated. List this matter on 18.
18, interim order.
Interim order earlier granted is extended.
Cell number 30.
This will be connected with the 4074 of 2024.
List along with so and so, I number 1 of 25 to condone the delay of 251 days, condoned on condition,
Meanwhile, call
admit,
parties.
Cell
call
number,
for the record, registry is directed to call for the records, post for final hearing.
cell
14,
number 14, Nagaraja HR.
notice to the respondent. 15,
15,
15,
15.
I'm for a 14 matter.
ಇದೆ.
Appeal for,
notice.
I'm for appellant in this case.
Notice ಆಗಿದೆ sir.
what
Cell
do you
number,
want to say in 14?
I am for dispensation memos. File the dispensation,
Dispensation to whom?
respect number 1.
Memo is filed seeking dispensation or notice to R1, dispensed with, notice to the other respondents. Yes, 15.
cell number 15,
For appellant ಮೇಲೆ insurance company challenging on the road liability ಮೇಲೆ after amendment ಮೇಲೆ ಆಡ್ಸ್ಬೇಕು. The limitation barred by terms after lapse of 6 months the claim petition has been filed.
Then counsel for the appellant submits I number 2 of 25. Then counsel for the appellant submits that the claim petition is filed after 6 months and the same is barred by limitation. On that count, the insurance companies before this court, they shall be stay of all further proceedings. Say for 50% amount, 4 weeks, notice to the respondents.
cell number 16,
For the appellant, my lord, appeal on the question of quantum, my lord. Instead of deducting 50%, 1/4 deducted. My lord, income instead of taking 15,
Married person or unmarried?
he is a bachelor.
Bachelor.
Bachelor. So instead of taking, my lord, the income at 15,000, 16,250 has been.
How much will be the?
My lord, 15 lakhs, my lord, you lost me kindly 50%, my lord, you lost me.
15%, it won't be reduced to 50%, even if we calculate also.
My lord, it will amount to 50%, it will amount to 15,63,750.
No, what is the amount granted?
Total, my lord, 31 lakh has been
So
granted.
31 lakhs is granted.
Yes.
Even if you calculate, that much difference won't come 50%. You deposit around 20 lakhs.
My lord, 15 lakhs, 50% of 31
Let's
lakhs.
calculate now as per what you say.
Yes, my lord, 15 lakhs.
So how much has to be taken? What is the income? Which year is the accident?
This of, my lord, 2021, my lord.
2021 is 15,000.
Yes, my
What is the, he's a bachelor,
Yes, my lord.
40% future prospects.
Yes. I have calculated in my appeal memo itself, my lord.
How much is coming?
My lord, it's 20 lakh 16,000 under that.
What I
loss of-
said.
Yes.
20,000?
20 lakh 16,000 under that loss of
The land
dependency.
council submits that when the accident has taken place in the year 2021, the court had taken 16,500.
15,000, 16,250.
16,250 as the income.
My
And
lord,
as
as
he's a
per my
bachelor-
calculation, 12 lakh 60,000 is excessive.
Huh?
12 lakh
And
60,000.
he's a bachelor and the court had deducted only 1/3 towards his personal expenses. They submitted that the court, the amount that is awarded by the court is on the higher side and the same needs to be reduced. Considering the submission, they shall be stay on the condition that he shall deposit an amount of rupees 20 lakhs within a period of 4 weeks, and on such deposit, the respondents are at liberty to withdraw. Notice to the
It will
respondent.
amount, my lord, 13 lakhs is excessive, my lord.
cell number
13 lakh is.
How much is the amount granted?
Total, my lord, 34 lakh has been granted.
Correct. So.
And out of that, my lord, 10% contributory negligence. And my lord, now, my lord, 50% of 31 lakh 27,000 is 15 lakh 63.
Why should it be 50%? That's what I'm asking you.
I have, as per my calculation only, my lord, 13 lakhs it will be excessive.
Amount is granted 30 lakhs?
31 lakh 27,500. Around 18 lakhs your lords may kind of.
18 lakhs on such deposit, they're entitled to withdraw. Yes, next.
cell number
Notice to the
17,
respondent.
Sushmita.
17.
Sushmita.
Notice.
Cell number
18.
17,
18.
cell number 17, notice 18 withdrawal memo is there.
Petitioner may be permitted to withdraw this.
Matter is settled out of the court.
Memo is filed seeking to withdraw the petition. Take
Already
that.
filed
It
the
is
memo.
submitted that the matter is settled out of the court accordingly. Appeal is dismissed, the petition is dismissed as withdrawn. Yes, next.
Cell number 19. Cell number 19.
Petitioner, my lord. My lord, on the last occasion, I was directed to seek certain instructions with regard to this one. My lord, now, after seeking the instructions, my lord, certain new facts have come to my knowledge. And in this regard, my lord, the continuation of delay application that was filed along with the petition would be inaccurate. So, my lord, I'm filing this memo of withdrawal for withdrawing that continuation of delay application and filing a new fresh application by bringing out all the facts, my lord. If I may be permitted to.
Memo is filed to withdraw. The affidavit that is filed in support of the condemnation petition, the same is allowed and it is submitted that
My lord,
filed in the registry. So the petitioner will come up with a new application. Yes, next.
My lord, if a date may be fixed in this regard, my lord.
Next week, someday. Yes, someday in the next week. Yes.
Cell number 20.
20 appear for the petitioner. In this case, my lord, the private finance is misusing the SARFAESI Act, my lord. I had borrowed 18
What is
lakhs
this IA number
rupees.
1 now? We are
My lord, that I will withdraw, my lord, by impleading another.
IA number 1024. When council submits that he wants to, he seeks to withdraw,
That's
dismissed as withdrawn.
My lord, what has happened in this case is, I borrowed.
Even till now, notices are not sent to the respondents.
No, second respondent is separate.
Furnishing of.
Well, one submission, because I borrowed money from the first respondent, 18 lakhs rupees. I paid 76 lakhs rupees. When I
Whatever
go
it
to,
is, why you are not paying the process for the service of notice to the respondents?
no, I'll make it, that first respondent is not existing. my lord. Second respondent, he has issued 13-2 notice, 13-4 notice, he cannot, but it's a private finance company, they can't exercise the powers under the SARFAESI Act. They are misusing the powers and harassing the petitioner. For 18 lakhs rupees loan, he has paid 76 lakhs, and first respondent, when I go to
Say
get
that
back,
R1 is non-existing?
well, he says he has sold the company to a second respondent. The second respondent is served and he has.
File a memo to that effect. When council submits that, respondent number 1 is non-existing, as the same is sold to respondent number 2. I shall file a memo to that effect.
Take instruction, Milcard. I was told that he's still continuing in the Bangalore, maybe another address. I'll get instruction, have it on Monday or Tuesday, Millard, I'll get instruction.
This matter after vacation.
Millard, some urgency is there, I want to.
23 matter, there won't be any urgency now. List this matter after vacation. Petitioner shall furnish the process. Yes.
Cell number 21. Giri Kumar SV.
Yes.
Lord, interim order granted on 23/2024, some subject to my lord deposit of some money which they complied.
They complied.
They complied, but
What?
still my lord outstanding is my lord more than which outstanding.
Let's see what is the interim order. Submitted with the council, the interim order is complied with by the petitioner. Then when is the interim order?
The prayer my lord sought my lord my
Interim
demand
order
notice
has
my lord.
paid for subject to depositing 20. What is the outstanding?
My lord, now after giving the benefit, my lord, 3,77 lakh 1924.
No representation on behalf of the petitioner for dismissal tomorrow.
Grateful, my lord.
22.
22. Cell number 22.
It's a matter from yesterday.
Rakesh Kini.
Yes.
My lordship. My lordship, in that writ petition.
By that time, all the documents pertaining to the mortgage and the
Yes,
EC shall be
please.
placed before this court,
My
or
lords,
else a writ petition will be allowed on the ground.
My lord, one submission, my lord. There is a page number 2 in the writ petition. May just it is a two sheets, my lord. In that, it is clearly mentioned the alleged mortgage was created against the Schedule B property and other properties in 2010. My lordship, the sale, other things which is taken in 2013, but equitable mortgage has been done with us 2010. And his contention is that Schedule B is not mortgage with us, but my lordship, entire property, it has been mortgaged.
Give him a
And
copy of it.
in future, anything constructed in that property also still it is a secure to us.
Give it to him and a copy to the court. Take it.
Copy.
Yes, you purchased a property which is mortgaged the year 2010.
2013. This is,
2010.
I purchased in 2013.
It is in 2010 mortgage.
It's an unregistered mortgage. There was a registered mortgage with State Bank of India. I obtained NOC from State Bank of India. Only after that I registered this sale deed.
You can, you can have an unregistered mortgage also.
Please, my lord, with the letter of evidencing of deposit of title deed, we can secure the loan, the property. This is a standalone building, 1+2 floors. In future, if we construct also, entire property is mortgaged with us. In that, in this page number 3, my lord, Schedule B, it is written entire survey number. Entire survey number, it is mortgaged with us. In future, if we construct even missionaries, whatever it happens, it is mortgaged with us. It is to be with the bank unless he clears the.
How will he know?
My lordship, due diligence, respondent 3 and they are both are colluded and they have come to the, and this is also known this before 2018. 2018, he is telling that he got to know that. 2018 to till date, there is nothing from his side. He has not challenged anything. Now all of a sudden he is coming to challenge the possession notice. CMM order is taken, we have taken it. So based on this, we are having a control over that property, my lord. We will have in future also. This is mortgaged with us. We will not take back our thing. That is what our submission. And he cannot tell it is not part of it, not mortgage.
Yes,
For certain
you have
floors.
an interim order in your favor?
May I make one submission, my lord?
We have an interim order.
Yes, this is matter after vacation. Interim order earlier granted is extended till that. Yes, next.
Cell number 23. Kiran Sia, KV Lokesh.
For the respondent bank in this case, my lords.
Yes.
The interim order was granted on 28/10/2024. As against a dues of 90 lakhs, only meagerly 10 lakhs was ordered. He has cleared complaint. Thereafter, no installments have been serviced. Nothing. I filed a vacating of interim order.
Presentation on behalf of the petitioner. This matter for disposal tomorrow. Yes, 25.
Cell number 24.
24, yes.
Cell number 24.
We are giving a proposal for one-time settlement. Lords, since we have this matter on Monday, I'll withdraw this. I'll not take any further extensions. I'll withdraw this matter on Monday.
Then the senior counsel
Today
submits that
itself
they are
I'll-
approaching the bank for one-time settlement. And they'll be withdrawing this petition on Monday. List the matter on Monday.
So grateful. Lords.
15. Serial number 25. 25. Vasudevan.
Mr.
Pasu.
So the
Here,
is on his legs in the other court. Senior counsel is on. It's on his legs.
Password?
Very well. Lords.
Yes, next.
Sir,
Can it be
sir.
tomorrow instead of today?
Senior.
I have. Can
The
it
new,
can it be tomorrow, my lord, instead of today? Because I have number of matters listed today. I'm going from court to court. 2:30 you have to be here for other matter. I have another matter at 2:30 before this court. No matter, there's one other matter, my lord, at 2:30. So if your lordships can have it at 2:30, we'll finish it.
Yes.
2:30.
Great.
Yes, next.
Serial number 26. Serial number
For the
26.
petitioners, appearing for the petitioner, my lord, praying for the mandamus direction, my lord, in this case.
Mandamus to?
Karnataka Bank. Karnataka Bank.
For OTS scheme.
ma'am.
For one-time settlement. Directing the bank to accept the proposal put forth by the petitioner under their letter dated by providing reasonable time to the petitioner to settle the due amount. How can we grant this kind of an order? Tell your senior, list this matter tomorrow. It can't be granted. We'll dismiss it tomorrow.
Kindly pass the order, my lord, on this case.
Shall I dismiss it?
Or
That's why I'm asking, ask your senior to come. Tomorrow we'll dismiss.
Okay.
Yes.
Tomorrow. Serial number 27. Shant Kumar.
Appearing for the petitioner seeks a week time. my lord.
Why week's time?
Well, it's
If
counsel
there
on
is Mr. Vignesh Shetty, Canara Bank, Mr. So-and-so is directed to take notice on behalf of the bank. List this matter after vacation. Yes, 28.
Serial number 28.
Serve the papers on him.
Please, my
Dinesh Sebastian.
I appear for the
28.
petition case, your lordship.
interim order. my lord.
Interim order is there already.
Please, ma'am. Yes, ma'am.
It is there. It's fresh matter, I think.
Sorry, my lords.
Huh?
Sorry, my lords.
Look at it, 27. It's a fresh matter, isn't it? Yes, after vacation,
Please,
then
madam. Sorry,
28.
madam.
I appear for the petitioner in this case, Your Lordship.
28.
Your Lordship, I had filed a MC case. The petitioner had filed a MC case in 1140 of 2020.
Yes.
Your Lordship, the matter was posted for judgment on 13/12/2024. Thereafter, the respondent kept on 13/12/2024.
Hmm.
Thereafter, the respondent kept on filing IAs by filing advance applications, and the same got rejected. But right now, the matter is posted for judgment again, and again he has filed an IA, and copy is yet to be served. This is the modus operandi of the respondent. Hence, I'm requesting this honorable court to kindly at least give a direction to the lower court to dispose of the matter at the earliest, Your Lordship.
Which
The matter
court
is
is
again
this?
this is before fifth additional family court.
Fifth additional family court will not take up 2020 matters. No, we will see after vacation. This is matter after vacation.
Serial number 29 adjourned. Serial number 30. H.J. Ananda.
Yes.
Saket Bisani. 30. Saket Bisani.
No representation. This is matter after vacation.
Serial number 31.
My lord, this is OTS, my lord, regarding a one-time settlement. Annexure E, my lord, made on 20th May 2025.
We can't give a direction to the bank to accept your OTS.
And because ready to pay the amount, my lord, then 6 month time. One-time settlement, my lord, regarding. Annexure E, my lord, is. Application made on 30th May 2024.
Karur Vaisya Bank, who appears?
Vignesh Shetty.
Spinso is directed to take notice on behalf of the respondent bank. This is matter after vacation. Next 32.
Dispose of the matter, my lord.
Yes, 32.
32. B. Vijay Shetty.
In the petition filed by the petitioner herein for divorce, murder, section 24 application
What is
filed.
the order in?
Order, murder, 5,000 order has been passed.
You are the wife or the husband?
I am the husband, murder.
Why 5,000 cannot be paid?
Murder, the petitioner is a practicing advocate. He is just enrolled in the year 2025 April, murder. Other than that, murder, there is an opportunity is also not given to file the proper objection because
5,000 rupees will not interfere.
difficulties, your lordship may kindly see the documents. He has met with the accident and he is having some other health ailments also. He is spending a lot of amount to that aspect also. Your lordship may kindly see all these documents are there. Murder, one opportunity is given to me to file my objection. Let the trial court consider on the merits, matter, because your lordship may kindly see at page number 62. Application filed on 8/7/2025, my lord. My lord, and posted for objections on 17/7. Next hearing date, he could not appear. My lord, on that day, since non-appearance, my lord, on that day itself, case called and the petitioner absent and no representation, respondent and counsel present and filed a list with 2 documents. Objection to IA taken as not filed. Sufficient opportunity given. Heard on IA number.
The age is 32 years.
My lord.
You say that is a junior advocate.
Junior, just now, Marad, he is enrolled and he is just entered, Marad.
1,000 rupees, we can't interfere with that.
Marad, he is having.
If I can
Kindly see the difficulties, Marad. He is all health issues, Marad.
What
He is
health issues show to the court?
kindly see the document annexure L, Marad.
Page number?
Earlier, yes, page number 77, Marad.
Yes. What happened?
It was he was installed with the rod for the leg, Marad. That difficulty is having and continuously taking treatment. Next annexure M, Marad. There is a kidney problem also for him. Marad, kindly see at page number 82 and 83. I have produced the photograph of the
Children
X-ray.
in the wedlock?
Marad?
Any issues in the wedlock?
No, Marad. But she is earning, Marad. She is having 30,000 salary, Marad. She is working in some car company as some representative.
Forthcoming in the order?
Marad, in the order, Marad, because my objections, Marad, I could not file.
With regard to her income?
Marad, her income, Marad, they are not. It's not there. Anything is not there.
But the petitioner submits that. Petitioner is a practicing advocate, and they are recently enrolled as an advocate, and he is not having enough income. The court had granted 5,000 without giving a reasonable opportunity to file the statement of objections. It is submitted that the wife is earning an amount of rupees 25,000 as salary and suppressing the same. The order as she has obtained the order. Considering the submission, they shall be stay of all further proceedings. The petitioner shall take out hand summons of the counsel appearing for the respondent before the trial court and file a memo to that effect reopening day. After
Seventh-
2-3
seventh
days,
month.
no, 8th of January, or else the stay granted by this court stands vacated.
Yes.
In addition, the registry is directed to issue notice. Case 33.
Cell number 33, Harish KV.
Appearing for the petitioner in this matter, my lord. I filed a petition seeking for direction from this honorable court to the 6th additional family court for disposing of my matter within 3 months, my lord.
Which year is this?
My lord, actually the matter was filed before Principal Civil Judge Gauri Bittur, my lord, and after filing the civil petition by the respondent, it got transferred to the
No, which
Bangalore.
year is that original petition?
2022, my lord.
2022, it shall be disposed of within 3 months.
Please, my lord. The facts, my lord, the petitioner herein had filed a petition for restitution of conjugal rights. The respondent did not join with the matrimonial home. Later on, he had filed a petition for divorce. When it was about to get concluded, the respondent has filed a civil petition before this honorable court and got the file transferred before the family judge of Bangalore, my lord. Since then, she is not appearing before the court, and the court is granting time for her appearance and for the cross
We
examination.
can't pass any order to the 6th, direct the 6th additional judge family court to dispose of the matter because they are dealing with 2019 matters. 22, they are not entertained now. The present petition is filed seeking the following prayer. The MCs of the year 2022, and this court has directed the family courts to dispose of the old matters, that is till 2019. Hence, there cannot be any direction to the family court to dispose of a matter of MC which is of the year 2022. Accordingly, dismissed. 34.
34, Shrikant M.
Yes.
Vignesh Shetty, for respondent.
Lord, petitioner, for issuance of sales certificate in my lord favor of the party. Lord, what had happened, my lord, petitioner, my lord, paid the money pursuant to order made by this court. Now they are seeking a direction from this honorable court to issue a sales certificate by me. My lord may direct me, my lord, I'll issue it.
Why should they come to the court and ask the court?
No, correct, my lord. What had
Your
happened,
officer should do it when he has taken the money.
No, it's not that. What had happened, my lord? The petitioner is the second highest bidder.
Oh,
And he
this
was
is-
deciding over the property. He came and filed a writ petition. Pursuant to this honorable court order, he paid the money. But there is no direction for me to issue sales. However, my lord, I'm not on that. My lord may direct me, my lord, I'll issue it. Without it.
I think it has come up earlier.
Yes, I took at least
You
2-3
are
times.
saying the second highest bidder, our hands are tied, but we can receive the money. The
Court order, however, my lord,
petition is
I-
filed. That petition is filed, seeking the following prayer. The facts of the case are: the respondent bank has issued a e-auction sale notice dated 29th and 2023. Fixing the state of auction on 3/2/2024. The husband of the petitioner has contested the said auction and deposited an amount of rupees 8,18,000. Pursuant to the same, auction has taken place on 3/2/2024, wherein one MP Chandan has become a successful bidder by bidding an amount of rupees 84,80,000. And the husband of the petitioner has become the second highest bidder by bidding at an amount of rupees 83,80,000. Thereafter, the petitioner challenged the sale notice dated 29/12/2023 and also the confirmation of the bid dated 3/4/2024 by filing WP number 5306 of 2024. And the same was disposed of by order dated 21/2/2024, granting an interim order that the proceeding shall remain state, and further directed the petitioner to pay an amount of rupees 42,40,000 within 1 week and another sum of rupees 42,40,000 within 2 weeks. Why the successful bidder has not paid the amount?
We have given back the money to them. In fact, he came and requested the money back because some interim order is operating. We have returned the money.
It is stated that as per the orders passed, they have paid the entire amount. It is also stated that the successful bidder has taken back the entire amount. and has withdrawn from the sale. On 2/4/2025, the writ petition was disposed of on the ground that the petitioners have paid the entire amount and they have purchased the property in auction, and further liberty was granted to the bank to proceed further in accordance with law. It is stated that thereafter the petitioners gave a representation dated 11/4/2025. Initially, it was not endorsed, but the petitioner's copy was duly acknowledged on 17/7/2025, wherein they sought they have requested the respondent bank to facilitate the registration of the scheduled property in the name of the petitioner. But till today, the respondent bank has not registered the sale deed in favor of the petitioner, in spite of several requests. Hence, the petitioner has come before this court by filing the present writ petition. Then counsel appearing for the bank submits that the first highest bidder has already taken back the amount, and it is submitted that the entire amount is paid by the petitioner. In that view of the matter, the writ petition is disposed of, directing the writ petition is, the court is passing the following order. The respondent bank shall consider the representation dated 11/4/2025 and shall register the sale deed in favor of the petition.
Sale certificate. I may direct you to issue sale certificate to in favor.
Certificate in accordance with law.
Favor the petition.
Cell number 35, Dinesh Swami, seat of petitioner.
Time for the petitioner, my lord. My lord, I'm challenging the interim maintenance order of 25,000.
How much is granted?
25,000. My lord,
What is your salary?
my lord, I have not produced this assets and liability. My
No,
lord,
now you can tell the court what is your
my
salary.
lord, that's the only one I had to ascertain with the client. My lord, but the question here, Ms. My lord,
No, the no other questions after the respondent.
there's
enters
25 lakhs
appearance.
that she's been withdrawn from the joint account, my lord. My lord, the reasons have been stated in the
Get
order.
instructions, what is the salary of your client?
Yes, ma'am.
Yes. This is
Well,
the
that's
matter
it, ma'am.
tomorrow.
Yes.
Next 36.
Cell number 36. KV Lokesh.
For the petitioner, my lord, the police is not assisting me to execute section 14 order. Similar such matters, this court has directed Circle Inspector of Police to assist the.
Okay, take that order. Where is your representation?
Page 23 minutes.
They filed a postal receipt to your lordship.
They don't accept, they'll not give any acknowledgement. If we go and give the letter also, they'll not give any acknowledgement. The letter is sent by way of post.
They have not given any representation in physical worship. They have sent the letter through postal
No,
receipt.
that also why you won't
Yes,
accept.
That means the date has to be allotted, your lordship, on to which date they have to assist, and they have to engage the staff regarding.
No, whatever it is that you can communicate.
Yes, your
to
lordship,
them.
they should come in physical to fix the date as to when
Two,
the
three times,
possession has to
authorized
be.
officer had gone 2, 3 times, my
And
lords. They told today, tomorrow.
Then I'll fix a date on that day, let them go and then
Published.
let
Published.
them,
Yes, your lordship.
That can,
the present writ petition is filed seeking the following prayer. The petitioner before this court is a finance company, a non-banking financial company. The respondent number 225 of the borrowers herein has obtained the loan of an amount of rupees 1,43,42,900. And as there is a default in payment of the amounts, the petitioner, the account has been declared as in the non-performing asset, and the proceedings were initiated under the Securitization Act. They've issued a notice under 32, and also they have taken the symbolic possession of the property and has issued the possession notice under section 13(4) of the SARFAESI Act. Thereafter, they have approached the CJM Rural at Bangalore seeking assistance for taking physical possession of the secured property. Then an order was passed in the criminal miscellaneous number 987 of 2025, dated 13/8/2025, and allowed the application. It is stated that thereafter they have requested which respondent?
Respondent number 1.
Respondent number 1 on 13/9/2025 to provide necessary assistance for executing the order passed in criminal miscellaneous number 987 of 2025 dated 13/8/2025. Land counsel for the petitioner submits that in spite of their request, the respondent is not providing the necessary assistance. The learned then they appearing representing the first respondent submits that the petitioner has not approached the respondent, and just they have sent a letter representation to post. It is submitted
Without
that
mentioning proper date.
it is submitted that if they meet the concern with all the relevant details, necessary action will be taken by the respondent. Next para, having heard so and so, the petitioner shall approach the first respondent on 16th of December, and the first respondent shall grant necessary protection in accordance with law.
Because the government counsel kindly inform the police station, the order will take time.
Yeah, Lord.
Release of the order may take
Yes.
a short months.
Yes. Yes.
Tausif Ahmed,
Appearing for petition. Kindly pass over.
Password.
It has become infructuous.
In the afternoon, we'll do that. Yes, 38.
cell number 38.
So they take it as
Shetty.
230.
There are so many passwords. Passwords will be called there.
I'll take my
Yes, 38.
38.
Wait for some time.
Last question, this honorable court heard the matter and pass an order, it is maintainable. Directed them to file an objection honor before 26. They are not filed. I'm ready with my submissions. It's the same matter, my lord, bank purchased the property. My lord, contrary to 13(5)(a). My 20 crore rupees property, my lord, for recovery of my lord 3 crore, they themselves purchased it.
My lord,
contrary to law.
Writ appeal has been preferred against the order of this court. My lord,
So there's no stay. There's no
So
stay.
that's
matter has not been listed yet.
For
The
you-
certified copies of this court's order is not released. My lords. That's the reason the matter has not been listed. 1 week time may be granted.
The direction,
I'll file my-
they're not complied. They're not filed their objections.
Give that. Where is the order?
Please, my lord, kindly see.
25 matter, my lords. So I may be permitted to seek just like get my writ appeal listed, my lords. In fact, that's the only reason is that
No, in this, what is the order that is passed which is appealable?
the maintainability of the petition on the case of fraud.
No, have I passed an order?
Yes, your lordship has.
Where is that?
Interim order has, this court told the writ petition can be maintained under where section, my argument was that under section 17, any order under section 17, under section 18 is alternative remedy before DRAT. That was my argument. Your lordship told that writ can be entertained if fraud is alleged, only if fraud is alleged. This will create.
I made out a case before this honorable court. There's
Let me
apparent
complete,
fraud.
sir, please.
Yes, sir.
But this is what happens if this becomes a law, my lords. All the writ up section 17 applications which are dismissed will come before this court by clever drafting to the bringing to the purview of under fraud. That's the reason.
According to you, an intra-court appeal is maintainable under section as far.
18, yes, under the section 18 of the SARFAESI Act, absolutely appealable. This court in 3-bench judgment.
Intra-court, that is the appeal to the division bench.
Division bench to the appeal is only to the extent of the order of mental. If this court says, if this court would have told me, lords,
Says respondent bank shall file their objections by 26/11/2020.
lords, it is there that this lordship may kindly pursue the order. It is there. This court is maintained. It's maintainable. Your lordship-
Unless and until the objections are filed, unless and until this finding is there, how can this court ask you to file objections? Isn't it?
The lordship told.
So from this, what the court can understand is, as what all the malefides has is attributing to the bank, that the bank do not want to place on record.
Sir, we'll absolutely file objections. The thing is, I'm taking a chance before writ appeal. Not one opportunity may be granted.
No, because you have to prefer an appeal. This court said this is matter on 2/12/2025. By that time, you have to file your objections.
Yes.
There is no stay. There is no order from the division
Yes,
bench.
yes, my lords.
I will take
This
up
is first
this
time.
matter, list this matter next week,
Obliged.
On 18th, not 18th, on 16th.
Grateful.
By the time the objection shall be filed or
I'm
else
not in town.
the-
Personal reason, 16th, I'm not
basing
in
on the
town.
material on
18th.
record, this
Personal
court
reasons,
will
I'm not in
pass.
town on 16th.
Huh?
On 18th, I'm not in town on 16th. Personal
Yes,
reasons.
18th.
Obliged.
On the day, if the objections are not filed basing on the material on record, orders will be passed.
Obliged.
Till number 39,
Obliged.
P. Mohan, for petitioner.
Wait, please. Notes, this is writ petition by the borrower. I'll just place a short synopsis so that.
Which is the bank?
Bank of India.
Bank of India.
Also.
Who appears for Bank of India? Where is he?
39 minutes. Okay, wait.
Mr.
Bank of
Vignesh,
India.
you appear for Bank of India? Huh?
Mohammed Ibrahim. Mohammed Ibrahim appears for Bank of India. We don't appear.
Vignesh Shetty was appearing for Bank of India. Huh. I think you serve the papers on him, we'll take it up tomorrow.
Bank of India.
Mr. Vignesh Shetty is directed to take notice on behalf of the respondent bank.
There is
This is
little
granted
urgency,
tomorrow.
my lords. In spite of status quo order and the clear direction to hand over possession. they
That's
have-
fine. Any of, once, what I'm doing is in all these matters,
Business.
I'm not
I leave
passing any order. Tomorrow? Yes,
Till
next.
number 40, urgent, 41. Till number 41.
Appear for the petitioners.
Yes.
My lord, I have filed this writ petition challenging the order dated 11th August 2025 passed in MC number 1421 of 21, directing the petitioner to pay a sum of rupees 20,000 monthly from the date of filing the section 24 application until disposal of the divorce petition towards the miscellaneous expenses of the children, my lord. My lord, the London trial court has rightly held that the respondent has an independent source of income and she has taken undue advantage of the fiduciary capacity and she has made unjust enrichment. So there is no maintenance awarded to the respondent. However, with respect to the children, the maintenance is awarded, my lord, on a factually incorrect proposition. My lord, may kindly look at page number.
What is your salary?
My lord, here the main important point is that the children are in my custody, my lord. Children are in my custody. My lord, may kindly look at page number.
How will the court grant maintenance for them from asking you to pay?
My lord, that is the factual error which has been committed, my lord.
Where are your objections? Let us
Page
look
number
at your
22 may
objections.
be looked into, my lord. Para number 5.
No,
And
no,
in the,
your objections. Let's see your objections. Objections to the IA,
Aye.
24.
My lord, before going that, I would 1 second draw the attention of this honorable court to the impugned order. Page number 22.
No, no,
And
let's
page
take
number
it
24.
that, let us take it that the court has observed like that. But let us see, what did you say in your
Yes.
petition, in your objections?
One 130 is the objections, my lord.
130?
130, 130.
Hmm.
Here, my lord, I have narrated that I am taking care of all the expenses.
Paragraph.
Per-
Which paragraph you have stated that
Uh,
the children are residing with you?
My lord, here what has happened is that here, since the maintenance was sought for a sum of rupees 2 lakhs, my lord. Basically, she was asking for her maintenance was the priority, my lord. So my objections have been restricted to the extent that the respondent is not entitled for any interim maintenance from my end. My objections are focused primarily on the ground that the respondent is not entitled for the maintenance.
Must have filed your statement of assets and liabilities.
My lord, in the
In that you would show who are the dependents on you. On them, what are the amounts you are spending?
my lord, may kindly look into page number 118, my lord.
Yes.
The respondent's assets and liabilities.
Not the respondents, your assets and liabilities.
My lord, my assets and liabilities at page number 110, my lord.
Yes, let's see.
Here, my lord, I have clearly stated that for the maintenance, the clothing, toys,
Depends on the dependent family members. Yes, come to that. Details of the dependent.
yes, my
family.
lord,
One
children,
not-
Dara, Vyom, Jain, they are the minor children, my lord. I have said that they are my dependents and they are in my custody. And my lord, page number 110, I have given the list of expenses which have been incurring towards the maintenance of the minor children, my lord. And on the contrary, my lord, may kindly look at the affidavit filed by the respondent at page number 118.
No, please come to the impugned order.
My lord, one point I would like to draw the attention of this honorable court to page number 118. The admission made by the respondent.
I've seen that.
The school fees, she says that I'm not even aware of what is the school fees which is paid to the minor children. Now, my lord, may kindly look at page number 22. The petitioner has stated that it is the petitioner who is having the custody of both the children and is taking care of so and so expenses. But at page number 24, my lord, last but 3 lines, he has 2 children who are in the custody of the respondent and his approximate expenses.
Please come. Then counsel for the petitioner submits that the respondent wife has sought for maintenance for herself and for the children. The court has given a finding that the wife is capable of maintaining herself and she is not entitled for maintenance. When it comes to the children, the court has passed an order observing that the father is directed to continue to bear the educational expenses of the children, including the tuition fees and transportation fees. However, the father has to be directed to pay rupees 20,000 per month to the respondent wife in order to meet the other miscellaneous expenses of the children. Land counsel submits that when the 2 children are residing with the petitioner father, question of paying 20,000 per month towards the miscellaneous expenses of the children doesn't arise, and the court has misdirected itself on the facts of the case. Considering the submission of the petitioner, there shall be stay of all further proceedings. Pursuant to so and so, the petitioner shall take out hand summons on the counsel appearing for the respondent and shall file before the trial court.
My lord, one small, I'll take the notice on the respondent directly because the counsels have been changing very frequently, my lord.
On the counsel as well as on the respondent and shall file a memo to that effect by 8th of January, or else the stay granted by this court stands vacated without further reference to the court. Next.
Number 42, Ala Shetty.
Yes.
Petitioner, my lord, is a wife. My lord, she is the respondent before the family court. My lord, the husband has filed divorce petition, in which, my lord, the wife has filed an interim application under section 24. Application seeking interim maintenance 50,000 rupees and litigation expenses of 1 lakh rupees. The husband is working as accountant in Dubai.
You're seeking enhancement of the maintenance.
Not, it is rejected on the ground that both the petitioner and respondent could live only 6 to 7 months. That is the reason assigned. Kindly see page.
Notice to the respondent, petition permitted take out hand summons. Once a memo is filed, is this matter.
Number 43.
Stay, my lord. So tomorrow is the evidence there in the family.
No. Why should we stay the proceeding?
Otherwise, matter would be disposed.
Let it go on. We will not stay the proceedings. Yes.
But the reason that is assigned, my lord, for the passing of the impugned order.
We will decide the interim application independently. For that, we need not stay the further proceedings. Says 43.
My lord,
43.
date maybe.
Once you file the memo, it will come. Hand summons on the counsel for the respondent.
Please.
And file a memo. Once you file it, will come.
Great.
Yes, 43.
Motion CB.
My lords, I'm for the petitioner in this case, my lords.
Yes.
My lords,
Which is the bank?
My lords, I'll serve a copy to the counsel who is representing Canara Bank, my lords, Vignesh Shetty.
Where is he?
Outside. I will serve it, my lords. My lords, for my satisfaction, only 2 or 3 submissions, my lords.
No. All your satisfaction after Vignesh Shetty.
My lords, only 2 or 3, my lords. Only 2
I
or
will
3.
take it up tomorrow.
Tomorrow.
Yes.
Tomorrow.
Then counsel the petitioner is petitioner to serve the copy of the petition on Mr. Vignesh Shetty. He shall get instructions by tomorrow, list tomorrow. Yes, 44.
44.
Great.
H.N. Vasudevan.
For the petition.
Yeah.
The petition is challenging the rejection order of section 14.
Why?
By the
On
honorable
what
magistrate. On 2 grounds, the magistrate states that the original copies of the postal
acknowledgement cards has not been produced, but the postal tracking report along with the information or the letter provided by the postmaster of that particular post office has been provided. That has been marked as annexure also. But this
Similar matter you have filed earlier.
no, ma'am. This is the first matter.
No, in some other matter also same, this kind of, on the same grounds it is rejected.
Please, ma'am. But that is the only observation that is there, that and the 13-2 notice has been served to the same address, whereas in 13-4 notice, it has been returned with a note saying that no such person residing in the address. In between, my lord, the notice was also pasted before.
Come to the impugned order list.
Please, ma'am, place 16 of the impugned order.
Let's see.
Page 16,
Hmm.
6 lines from the top, my lord. Thereafter, statutory notice as required under section 13(2) of this act. Lord got it.
Yes.
Thereafter, statutory notice as required under section 13(2) of the act is issued. After expiry of 60 days from the said statutory notice, the applicant has taken symbolic possession of the petition scheduled property and they have furnished postal receipts, and there are no postal acknowledgement as seen in the case file to verify that the possession notice has been delivered to the respondents. But for having sent the notice, the respondents' RPD receipts are no RPD receipts are filed. There are no RPD acknowledgements to reveal that demand notice have been served on the respondents, and the copies obtained download from the internet is filed, but it is not endorsed by the postal authority. Not 65B is being complied with. So, and I will skip another 3 lines, Murad. There are no records for having last 2 lines. There are no records for having sent RPD receipts. Photocopies is filed, which cannot be considered to having satisfied this code as secondary documents. The petitioner has produced RPD return covers. This is under 13(4), which have endorsed as no such person on comparing address to which notice under section 13(2) reveals address of respondent as so and so, which is 13(2) notice is claimed to have been served, but 13(4) notice with the same address has written with endorsement as no such person. But in between this, the notice of taking possession has been pasted, and the owner of the property is also seen in the photograph. That photograph is also been produced along with the petition.
No, how
at
can,
page
how
38.
can the postal receipt, the acknowledgement says that there is no such person
Lord,
when
did
you
you-
have issued 13(2) notice?
13(2), after receiving of the 13(2), it looks like they have managed it, my lord. Because immediately after 13(2) notice, we have gone and pasted that particular notice on the conspicuous part of the property, along with the wherein the owner himself was there.
No, that objection raised with the magistrate is well founded.
Lord, please see this, my lord. My lord, may I draw your lordship attention to Rule 3 of the Security Interest Rules, wherein it clearly says,
Yes.
Rule 3, demand notice, my lord. Security Interest Enforcement Rules.
One.
Please. Demand notice. The service of demand notice as referred to in subsection 2 of section 13 of the Act shall be made by delivering, including hand delivery or transmitting at the place where the borrower or his agent empowered to accept the notice or documents on behalf of the borrower actually and voluntarily resides or carries on business or personally works for gain by registered post with acknowledgement due, addressed to the borrower or his agent empowered to accept the service of the post, or by courier or by any other means of transmission of documents like fax message or electronic mail service, provided that where the authorized officer has reason to believe that the borrower or his agent is avoiding service of notice, or for that any other reason, the service cannot be made as aforesaid, the service shall be effected by affixing a copy of the demand notice on the outer door or some other conspicuous part of the house or building in which the borrower or his agent ordinarily resides or carries on business or personally works for gain, and also by publishing the contents of the demand notice in 2 leading newspapers, one in vernacular language having sufficient circulation in the locality. And Rule 3 further says not any other notice in writing to be
You have
served.
done, it says under.
Please, my lord, when there is a doubt that the person is avoiding service. Now, my lord, 13(2) they accept. After that, we paste the notice on the property. There he is along with us.
No,
There is a photograph.
when the rule says about affixing the same, it says under. also.
Please, my lord, we are, the only thing is the originals is not being placed. Original postal acknowledgement is not being
No.
placed.
And also we're publishing the contents of the demand notice in 2 legal newspapers, one in vernacular language having sufficient circulation in the locality.
That we have publication, we have complied with that.
13.2 is complied with.
That even 13.4 also we have complied. Only the 13.4 notice has written with the postal, on the envelope, with the note saying that no such person in the said address, wherein 13.2 notice has already been served to the same address. So in between, after we receipt of the notice under 13.2, so they have managed to get an endorsement by the postal authorities that no such person is residing in the address.
So in that such case, what is the course available?
But we have pasted that particular notice on the conspicuous part of the property, and that person owner is also being seen standing along with the authorized person. That document is available, my lord, at page between page 38, 39, and 40. Specifically in 38, the owner is standing there, and the notices are pasted on the gate.
In the blue shirt.
Please, my lord. So he is the owner, and the next page, my lord, the authorized officer along with the newspaper of that particular date is standing next to the gate. And at page 40, the GPS tracking with the address on the location, that is also been provided to show that this is the same address and this is the same property.
Postal receipt and RPID cover both are very important to do the complaints of so and so. Here there is no complaints under section so and so.
That is the conclusion that has been drawn by the magistrate.
The respondents have published the Persian notice in Financial Express and also the Ganta on 28/1.
Since the postal acknowledgement did not return to us, which normally happens, we have provided the online tracking report along with the endorsement of the postal department.
Leonard Judge says even there is no complaints of 32.
Please see, madam, please see page 34, my lord. There is a letter issued by the postal department. Page number 34. This is in respect of 13.2 notice. So wherein, since the acknowledgement did not return to us, we wrote to the postal department asking us to provide the status of the envelope. So they provided that was sent from Santa Cruz Police
As
Post
far as
Office.
this is as far as 13.2 is concerned.
Similar one. Similarly, kindly turn to page 43. Even further, we have done it.
You have not received the acknowledgement.
Acknowledgement has not come. That's the reason we have used the postal online tracking report. And in 13.4, on page 43, again we wrote it to them. There also, the postal covers came back with a note that no such person in the address. But still, we have, in order to comply with this requirement of that, we don't have the original postal acknowledgement. So we wrote to the department, providing that to provide us the status of the package that has been sent. So they have come back with stating that has been returned to the company on 31/1/2025. So these, in absence of the original postal acknowledgement, well, we wrote it to the department. So when they say the online postal tracking report, it is cannot be relied upon. So a letter issued by the postal department, that particular post office from where the envelope has been booked, is also been placed on record. In absence of these two, it has been proceeded.
Pass orders. Next.
Obliged.
Cell number 45. Cell number 45.
There is one fact, my lords, in this ought to be brought to my lord's attention. I don't know, my lords, whether it is there in my learned senior's petition or not. This loan property, in respect of which they are seeking stay, under our noses, my lords, they have sold it off to a third party while it is mortgaged to me. And when they come before my lords is April 2025, they sell it off to a third party, my lords, and then they come here and seek interim stay. If they had, my lords, any genuine difficulty in repayment, we are willing to consider. They have not replied to my notice also. They sell to somebody else.
So did they say so in this, have you,
My lords,
have
I am
they
yet to
served
receive a
papers on
copy.
you?
No, my lords.
So the papers on.
And then I'll place along with these documents.
Yes, learn counsel for the petition,
Petitioner
serve the
one
copy of the writ petition on the counsel for the respondents.
I'll file wakalat, my lords.
Name, sir.
Varun S, my lords.
Yes. List this matter tomorrow.
Lords, grant me some time, my lords. I'll collate those documents only subject to my lord's discretion around a week's time, so that I gather that sale deed EC.
So I
They have
think
sold
the
it. Sold it
interim
to
order is not there in this matter.
only to collate and place those documents. That's all, my lords.
second demand notice issued. Already petitioners 1 and 2 has paid 25 lakhs.
That's why we'll have it tomorrow. Get instructions.
Really?
Because for if they're seeking interim order, I have to pass.
Very
For
well.
that, I'm giving you an
Very well,
opportunity.
very well. I'm grateful.
It's tomorrow.
Grateful.
Cell number 46.
Yes.
Petitioner my lord, obtained a loan of rupees
For
3
respondent.
crore my lord. But it is the total installment my lord paid on 13 installment he has paid. The as on my lord,
That's as on
311
date,
3/11/25. The total installment is due is now six installment due my lord. It comes around another 2 installment November and December installment and come to around 32 lakhs my lord. And, we are ready to pay my lord that 32 lakhs. Today is the action. E-action.
My lords, as on date, 3 crores 14 lakhs 97,000 is the pending amount, outstanding amount, my lords. Sale notice has been issued, my lords.
No, for regularizing the account.
For regularizing, they have to pay 32 lakhs.
They're ready
32
to
lakhs.
pay, it
That
seems.
we will pay.
If they pay by tomorrow, don't conduct the auction.
Yes, my lords.
Lord,
Pay by
tomorrow, this is the reason. The petitioner is working lord in a metro.
You can't have both.
Metro, Chennai metro try work.
Wherever it is.
ಅಲ್ಲಿ ಇದ್ರಲ್ಲಿ
wherever it
ಏನಾಗಿದೆ?
is. We will not
This is
stop
the
the
reason,
auction
Lord.
without any payment.
Hello, my lord, 2 weeks time will be granted, we will pay. We will pay, my lord. 2 weeks, my lord.
Let the auction go on.
Hello, 2 weeks, my lord. 2 weeks, my lord.
Will not grant.
We
2
will
weeks.
pay, my lord,
You have
32
to make
lakhs.
some payment, but by the time the auction is going to be conducted tomorrow. Or else what we say is let auction go on, not to
Yes.
finalize.
Yes.
In the meantime, you pay.
Yes, my lords.
Problem, my lord. We will pay, my lord, within 2 weeks.
That's what you pay within 2 weeks. Let the auction go on. If you don't pay, they will continue with that auction. Get instructions, pass over,
Kindly, my lord, this is the reason.
pass over.
Allah, we will pay, my lord. Kindly, 2 weeks, my lord, granted, my lord, to pay.
Either you pay some amount tomorrow or
Tomorrow, some amount we will pay.
whatever it is, you please ask the client and come back. Pass over. Next.
Cell number 47.
For petitioner, my lord.
Qazi Salim.
The petitioner is a bona fide purchaser. First purchaser, 11 to
Which
2019.
is the respondent bank?
A bank is a Maharashtra Bank and Bank of India. Two bank is there, sir. Respondent number 3 and 5.
Who are they?
Who are, the petitioner is not taken any loan from the bank. The petitioner is first purchaser. The respondent number 1 is a builder, created 2 more sale deed, same flat number. The respondent number 2 is taken loan from respondent number 3.
We'll hear the other side. Bank of Maharashtra.
Bank of Maharashtra.
Indian Overseas Bank.
Indian Overseas Bank. Vivek Keshwa Bhatt.
The possession notice issued by respondent number 3, against the respondent number 2.
Mr. What is the name for the fifth? Indian Overseas Bank.
IOB.
IOB who appears?
Vivek Kes.
So and so. And for the Bank of Maharashtra?
Divya Purandar.
So and so. Please serve notices on the both the advocates. We'll take up tomorrow.
Day after tomorrow.
Day after tomorrow.
Cell number 48. Amarnathan.
Woman is filing a maintenance application against a woman.
Huh?
Woman is filing a maintenance application against him. What has happened? The petitioner's father, Mela P. was mother, they were staying in that house, Mela. The petitioner's father.
Which is
Well,
the
other-
order now?
No, I'll talk. Petitioner's father died, petitioner's mother died, his brother died, she is staying in the house. The respondent first claimed stating she is the second wife of her father and filed a suit stating that I am the second wife,
So where is the impugned order? Then you can tell the
yes,
facts. I have to
That is the
understand what is
last-
it.
Yes, impugned order is at page number, time report order, Mela. Yes, ma'am, page number 72.
Yes.
Yes, ma'am, 72. Wherein to file affidavit of asset and liabilities along with necessary documents as contemplated under Rajesh Nehra case by plaintiff and second defendant. Well, I need not claim because I am the daughter of P. Srinivas. She claims that she is the second wife of that P. Srinivas and first suit they have filed it. Then she files an amendment application to say that no, she is not second wife, she is the first wife. And she got the child by IVF process. Petitioner's father was a patient and he died because of the 10 years ailment, Mellard. And she now claims she has married him somewhere in the. Well, at the time of marriage of petitioner's father, this lady, second was married with her husband and child attended the marriage in way back in 92. Now she claims she is the second wife of the petitioner's
She
father.
has filed an IA seeking maintenance.
No, she has filed.
Yes.
Ah.
Now you have succeeded to the estate of her husband, being the daughter.
Yeah, being the daughter. There's a gift deed. Gift deed,
Yes,
she's a partition suit is filed. In the partition suit, Mela, there's no question of maintenance and partition
What
claiming
is the
that.
suit? What is the suit about?
There's one partition suit.
Before which court?
The family court. OS suit, I filed the petition called me. Annex A. It's a partition suit, she had filed it. OS number 37821.
Against the daughter.
Yes, against the daughter. Partition stating that property I have a share. And she claimed the minor Ritvik, 2 years man, and Malad, she.
Land counsel for the petitioner submits that. It's a suit for partition. And I number 8 is for?
Maintenance.
I number 8 is filed for maintenance. It is submitted that the respondent is the daughter of the alleged husband. The petitioner is the daughter of the alleged husband. It is submitted that the question of filing the statement of assets and liabilities will not arise in this case like any other maintenance case, and the court, without considering the same, has passed an order, and they shall be stay of all further proceedings. Pursuant to the order dated 11/9/2025 in I number 8, notice to the respondents, same hand summons on the counsel for the respondent, memo by 8, or else the stay stands vacated. 8th of January. Yes, 49.
Cell number 49, Bhargav G.
Lordship, and for the petitioner, Your Lordship, this matter is a KLR matter and which
Your
has
Lordship,
been
this is
wrongly classified as
KLR matter, Your Lordship. This is
wrongly
not
classified
Blackie
as
matter.
Your Lordship.
Kerala.
Yes, Your Lordship.
This is matter before the court having roster.
Cell number 50, Ajit A. Shetty.
I appear for the petitioner, my lords. My lords, in 2019, I obtained a loan of
Union Bank of India, who appears?
Union Bank of India, that is Divya Purandar.
Yes, he is directed to take notice.
my lords,
Sir,
tomorrow is the
copy on
auction, my lords. We have already paid 90% of the amount, my lords. They have not issued us a loan statement, my lords. We are requesting them to provide us the loan statement.
Without hearing them, I will not pass any interim order.
Lords, tomorrow is the auction, my lords.
I'll pass over. Serve papers on her.
Yes.
Yes.
Cell number 51 for admission matters.
Insurance company challenging the count of quantum as well as contributory negligence, my lord.
How much was the case of death or injury?
Case of injury, my lord.
How much is granted?
Disability 14%, my lord. Tribunal consider about
How much is granted?
10,67,000.
According to you, what is admitted amount?
4 lakh rupees, my lord. Instead of 14% disability, future prospect consider 40%.
Admitted amount comes to what?
Admitted amount around my lord, 5 to 5.5 lakh.
Then why should you deposit for? It is submitted that the.
5 lakh I
company is
will
on the-
deposit, man.
I'm appealing for the respondent number 1, my lord. There is a
51, sir.
connected appeal is there, my lord. It may be connected along with that, my lord. Claimant's appeal. MFA 740025.
On the question of quantum, it is submitted that the court on 14% disability had considered the future prospects, and there is also contributory negligence on the part of the claimant. Considering the same, they shall be stay of all further proceedings on the condition that he shall deposit an amount of rupees 5 lakhs. The appellant shall deposit an amount of rupees 5 lakhs within 4 weeks. On such deposit, the respondent claimant is at liberty to withdraw. List along with, what is the appeal number?
7400, my lord. 740025.
Of 25. Yes.
Cell
Call
number
for,
52.
list is directed to call for the records.
Please, my lord, much obliged.
That's 52.
Cell number 52,
Climate favorable for enhancement. R2 may be dispensed, my lord. Enhancement, my lord.
Who to be dispensed with?
R2, my lord.
Memo is filed second dispensation of notice to
R1
R2
is universal sample.
with notice to the respondent.
Please, my lord.
53.
cell number 53,
Appellant in this matter.
Jagdish.
My lord, we are challenging the liability on ground of limitation, my lord. On 66 of clause 3, the claim, the accident is on 30/12, my lord, 22 on claim petition 2010 to 23, my
After
lord.
how much delay?
My lord,
After how much delay?
after 6 months, my lord.
Then counsel for the appellant insurance company submits that the claim petition is filed after 6 months from the date of the accident. which is barred by limitation, and still the tribunal has considered the same and granted compensation, consider the same. Stay 50%, 4 weeks. Notice to respondent.
Number 54.
My lord, I am appearing for the claimants, my lord, claimants appeal. My lord, the claimants are the second wife and children of the deceased, my lord. There is no
Please to the
compensation was awarded. Compensation was awarded to respondent number 3 to 5, my lord.
Notice to the respondents.
55.
My lord, I
Mohammed
pray for
Umar.
TCR also, my lord, call for TCR. Because they have filed.
Notice to the respondents. Yes, 55.
55.
Please,
Mohammed Umar. Mediation report not set.
No representation after vacation.
Cell number 56. 56.
Yes.
Yes, my lord, they have filed the memo, amount which have been deposited by the petitioner husband, my lord.
2,80,000 is due.
From the salary, it was deducted to the, directly to the court, my lord. And from the last 3 months, he is depositing to the court. I will take an instruction and memo of calculation which they have given. And what they stated is 14,000 rupees they have calculated. In view of the interim order passed by the honorable court, 9,500 9,000 rupees have to be deposited. Accordingly, he has calculated the amount and deposited the entire amount. That amount, what they have stated, are not due, my lord. That is why I will give the calculation and give me 1 week time, my lord.
After vacation.
But we have not received any compensation.
Cell number 57.
We have not received any interim compensation.
Interim order, I have already deposited before the trial court, my lord.
Let them withdraw.
Let the file memo of calculation.
It is submitted with the land counsel to the petitioner that the amounts are deposited before the tribunal, before the trial court, as per the order passed by this court.
Yes.
The respondent is at liberty to withdraw the same.
Please, ma'am.
Yes,
Cell
list
number
after vacation.
57. Pratima SK.
20,000 is awarded, but the problem is he's had a kidney transplant and for few months his health is quite bad. That is the only, I'll pay as an interim this thing 10,000, my lords. Whatever your lordship decides later on, probably by then his health also will be.
Salary no.
My lords, it is 55,000.
It is submitted that the salary of the petitioner is 50,000 and the court has awarded 20,000. He's suffering with kidney issue.
He's had a transplant, my lords.
He has
He's had a transplant.
Kidney transplant. Considering the same, they should be stayed 10,000 and by 5th of every succeeding month and arrears also at 10,000 within 8 weeks.
Grateful.
Yes, notice to the respondent.
But
58.
stay of the subject.
Yes.
Cell number 58. Anil Ramachandra.
My lord, I'm for the petitioner, my lord. In this, the award has been 10,000 to the wife and 5,000 each to 2 minor kids, 20,000. My lord, he doesn't earn a regular salary. He's a commission agent, which has been admitted.
What is granted?
My lord, maintenance has been granted.
How much?
10,000 rupees to the wife and 5,000 rupees each to minor kids.
20,000.
20,000. My lord, he does not have a regular salary. He's a commission agent, which has been admitted. His approximate salary on an average would be around 17,000, my lord. There was an interim order granted earlier where 13,000 rupees was granted, combined to all three. That would be more, in his capacity, my lord. And
How much is granted interim order?
my lord, in interim order, 5,000 rupees to the wife and 4,000 rupees each to the minor children, my lord.
That means 8 plus 5.
Yes, my lord, 13,000 rupees.
Now it is 20,000.
20,000, yes, my lord. My lord, it is beyond his
Land
means.
counsel for the petitioner submits that the court had granted 10,000 to the wife and 5,000 each to both the children, which is on the higher side, and there is no regular income to the petitioner. Earlier, court has granted as an interim measure 5,000 to the wife and 4,000 each to both the children, which she was able to pay. Considering the same, they shall be stay of all further proceedings on the condition that the petitioner shall pay 13,000, that is 5,000 and 4,000 each to both the children, and the arrears, if any, shall also be filed shall also be paid within 8 weeks on the same calculation. Yes, notice to the respondent.
Cell number 59 adjourned. Cell number 60. Chandranath, petitioner. Kamaleshwar Pujari.
Yes.
Appearing for the petitioner, my lord. My lord, past 2 years, she said that she made the submission that she's working in a company, but it is not temporary. But still, in the August 2025, still she is working and she's earning
Oh,
40,000 per month.
For a 2023 matter now,
My lord,
urgency.
My lord, in trial court, the order has been passed that it has been order has been made 10,000 per month for the maintenance, but again they are seeking and my lord, actually she is working in a company still right now and she is earning 40,000.
Where is the material?
Uh, my lord, kindly page number. 69, my lord. She said that she has the working and it is also a temporary based. Kindly page number 71. Details of the income.
Salary,
My lord,
what's your salary?
68,000,
What is granted by the court?
10,000. But I have to take care of the parents, age-old parents, my lord. And she's earning 40,000 and she can be maintained by that amount itself.
We'll see after vacation, no urgency for this. This is not after vacation, no representation on behalf of the respondent. Yes,
Case
ma'am.
number 61 adjourned. 62.
Much obliged. ma'am.
Talesh Appa case for petitioner. 62. Sadhana Desai.
No representation after vacation.
Case number 63.
I'm appearing.
One.
Be taken up after vacation. Just
Please,
get.
who appears to the respondent?
Respondent Lokesh KV.
No objection.
Kindly possible.
Then counsel for the petitioner then counsel for the petitioner submit the matter will be taken up after vacation.
Interim
Then
order.
there is no objection for the respondent. List this matter after vacation.
Interim order make.
Interim order earlier granted, extended. Is 64?
Case number 64. 64 Deepika.
Senior Counsel
Then
DR
Halli.
Ravi Shankar will make his submission. Can you take up by 2:30, my lord?
Yes.
Much obliged.
There's 66.
Case number 65.
Appearing for the
Rashmi
petitioner in this
Kaz.
case.
For the respondent.
Mainly
my lord.
press for short accommodation.
My lord, I have complied with the previous order of this honorable court where I have facilitated a meeting between the father and the minor's son, my lord. I would seek 4 weeks' time for me to file my objections, my lord.
Advocate on record is not well. Kindly press for time.
We'll have after vacation. List
Please,
this matter after vacation.
Case
Yes,
number
66.
66.
Much obliged.
M.A. Rajendra. 66 M.A. Rajendra.
Yes, my lord.
Where is the respondent counsel?
KB Monesh Kumar.
No, I am the petitioner here,
I said, where is the respondent?
or
counsel?
respondent, my lord.
Any urgency in this matter
No, your lordship.
after vacation? Yes, 67.
Yeah, one submission, can I make, my lord?
67.
This is the order passed by the DRT, I am before your lordship. It is a rule that any order passed by the DRT, I have to prefer appeal before DRT. When there is a delay, cannot be condoned either by DRT, DRT. Then who is the competent authority other than the writ petitions? In division bench, various courts have taken a various view with regard to the limitations. In one of the aspects of your lordship, when I am arguing the matter, your lordship very well observed that under section 14, when we are not the parties, they'll give the vacating
This
notice.
is the matter.
A vacating notice they have given. So based on the vacating notice,
Matter next week, no representation for the respondent.
yes, my lord.
68.
18 plus. Case number
I know.
67. Sanjay Kumar KN. 67.
I am for the petitioner in this case, my lord. I press for adjournment, my lord.
Yes.
I am out of
Petitioner
station
submitted.
as I have traveled to Tirupati for a temple visit and I
Yes,
could not
yes.
present before this honorable court.
Case number 68.
Appearing on behalf of the respondent, my lord, in serial number 68,
My
on
lord,
perusal of the order sheet, my lord, there has been a mistake,
Matter is urgent after vacation, sir.
my lordship, in serial
My
number
lord,
68, on
Sir, matter is urgent to after vacation.
Reduce the volume.
My lord, there is an interim order, madam. Kindly extend the interim order, which has been granted.
If there is any, or if there is interim order.
Pardon my.
If there is any, or there is interim order.
Interim order is there, my lord.
Yes.
I appear in serial number 68 for the respondent, my lord. On perusal of the order sheet, my lord, there has been a mistake, my lord. 14/11/2025 order states that list this matter on 4/12/2025, and there shall be a memo filed with regard to the compliance of the interim order. And if by way of reason interim order is not complied with, the stay granted by this court will stand vacated, and that would be reason for this court to dismiss the review petition itself, my lord. There is no interim order, my lord, in this.
When the matter was listed on 29/10, it was directed to be listed, my lords, in January 2026. Subsequently, matter was listed on 4/11. Again, my lords, that day order was passed to list the matter in January 2026. For some other case, my lords, order has been uploaded and therefore matter is listed today. It had to be listed in January 2026.
BSV. It is submitted that the order on 14/11/2025, this court has directed the matter to be listed in the month of January. However, the order pertaining to some other case is uploaded in this case. Order dated 14/11/2025 is set aside. This is matter in the month of January.
Great.
69.
No representation on behalf of the petitioner. It's submission of the counsel for the respondent. Is 69.
69. Sridhar
Respondent,
K.
Lord, I have to file my objections taken up after.
After vacation, no representation for the petitioner.
Much of.
Serial number 70. Dhananjay Kumar, kindly pass over.
Yes, 71.
Serial number 71.
So appellant in 71.1, my
Mr.
lord.
Umesh.
He's appearing online.
Passed over, my lord, I will come down in the afternoon.
2:30, please, my lord.
Serial number
Entire list is in the Passover now. Yes.
72.
Much obliged.
Final hearing Nasimurthy GV, 72.
No representation after vacation. What about 73?
73, that is parted matter, serial number 73.
Appearing for respondent in this case.
Petition in this case,
Respondent is present. There were 4 visits for the child, Your Honor. All 4 visits was been taken up and they had been to mediation center, Your Honor. There is some coordination between mother and child, Your Honor, as the court had said. If they
Well, Your Lordship, as a direction, we have kept the child present. The only problem is the child don't want to go. Even otherwise, we have been pushed the child. One eye is completely gone. He's one eye, only one eye is working. One eye is completely gone because of cancer. The child is a cancer patient.
No, on that.
Hey,
The court has
anyhow.
made an interim arrangement. How is that interim arrangement going on?
It was very good, Your
He
Honor. There was
don't want to go.
coordination.
He's present to the court. I can keep the present good. But we are pushing him that because it's a court order, we are pushing the child to go to the mother.
It's good for him. Let him go to the mother.
Now, Your Lordship, kindly direct this thing, GNWC. They are not leading the evidence.
Why are you not reading the evidence? How
For
is
the
it
last
connected
1.5
to
years,
this?
one and a half years.
There is this.
1.5 years, Your Lordship, this court was issued notice to the advocate, then they appeared. They are not appearing for 1.5 year here. They are not appearing for the. And Your Lordship, she's giving false. She's giving false.
Then we'll do one thing. Whatever is the interim order that is made, we will make it final, and we'll ask the GNWC matter to be disposed of.
Yes,
After
Your Lordship. Yes, Your
lunch,
Lordship.
we'll see.
Your Lordship, after lunch, I am having some other matters. Will kindly be passed out. I will keep present before the every date, every result. I will keep
I will
present. there.
dispose of the matter. I have to pass order, isn't it? I'll pass it in the afternoon.
Yes, Your Lordship.
Which one?
74.
I am for the respondent in 74. Madam.
You have no objection?
No objection. Madam.
74 after vacation.
Obliged.
46 minutes. Just now,
It will come. Yes.
46 minutes just now, pass over. My client is ready to pay tomorrow 10 lakhs. Remaining amount 22 lakhs and another 15.
Not after 2 weeks.
Bank is not agreeing for 2 weeks.
What they say?
They are asking.
It should be done tomorrow itself.
They are asking-
Anyhow, let bank not agree. Land counsel for the petitioner submits that the outstanding amount is
32 lakhs.
32 lakhs, which is also
3
admitted by.
crores, my lord.
Huh?
Outstanding is 3 crores.
Outstanding is 3
Regularization.
crores for regularizing the account.
3
The
crores,
amount
14
is,
lakhs,
the
97.
amount is 33 lakhs,
32 lakhs.
32 lakhs.
Correct.
Learned counsel for the respondent bank submits that the auction is going to be held tomorrow.
Today.
Its auction is going to be held today. It is submitted with the land counsel to the petitioner that by tomorrow, they will pay an amount of rupees 10 lakhs and the remaining amount by,
End of this month.
by, you said 2 weeks. What is today?
Today is 9.
Today is 9th.
9th.
You will pay by 23rd.
23rd.
The remaining amount by 23rd December. And in this regard, they will file an undertaking by Tuesday. List this matter on Tuesday. The bank shall not go ahead with the auction.
My lords, can I make one submission?
No mentionings now.
My lords, serial number 43 was adjourned to tomorrow, my lords. My lords, there is an urgency, my lords.
Is it Passover?
My lords, no. I was directed to serve a copy to Vignesh Shetty, my lords. I have already served a copy, my lords. My lords, my humble request, my lords, can I ask for the top of the list, my lords, tomorrow, my lords. There's an agricultural land, my lords. And they have,
We will complete the list.
my lords.
We'll complete. The
Yes,
list.
yes. Date.
My lord, serial number 24,
No,
interim order may be extended, my lord. Interim order may be extended, my lord.
In all the matters, interim orders will be extended, whether you ask or not.
Must have.
Sir, 43 ನಾಳೆನೇ ಹಾಕಿದಾರಾ?
55.
ನಾಳೆ. Thanks.
55.
Sir, past hour 55, 55 of vacation. No representation.
Petitioner ಬಂದಿದ್ದಾರೆ. Sir, 69, sir. 69 of vacation. Serial 47.
ಉಮೇಶ್ 2:15 ಬರ. Indian Overseas Bank. ಇನ್ನೊಂದು ದಿವ್ಯ ಪುರಂದರ ಅಂತ ಇನ್ನೊಂದು ಬ್ಯಾಂಕ್ ಇದೆ ಅದು.
ಮಹಾರಾಷ್ಟ್ರದ ಯಾರು?
ದಿವ್ಯ ಪುರಂದರ. ದಿವ್ಯ
ಸುರೇಂದರ?
ಪುರಂದರ. PURANDAR.
ಇದು ನಂಬರ್ ಸಿಗ್ಬೋದು ಸರ್ ಅವ್ರದ್ದು ಫೋನ್ ನಂಬರ್?
ಒಂದೇ ಒಂದಲ್ವಾ ಇರೋದು? ಒಂದೇ ಒಂದಲ್ವಾ ಪಾಸ್ಟ್ ಹೋಗೋದು? ಇಲ್ಲ ಜಾಸ್ತಿ ಇದೆ ಸರ್. 10 ಮೇಲೆ ಇದೆ.
ಅವ್ರ ನಂಬರ್ ಸಿಗ್ಬೋದು ಸರ್?
ನಂಬರ್ ಇಲ್ಲಿ ಉಂಟಲ್ಲ ಇದರಲ್ಲಿ ಇರ್ತಾ ನೋಡಿ ಇಲ್ಲೆಲ್ಲ ಇದ್ರು ನೋಡಿ ಬರ್ತದೆ ಮಧ್ಯಾಹ್ನ ಟ್ರೈನಾಗ ಹೋಗ್ಬೇಕಲ್ಲ ಹೌದು ಒಂದು ಲಿಕ್ವಿಡೇಷನ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ
ಲಾಸ್ಟ್ ವೀಕ್ ಓಪನ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮೇಡಮ್ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಪ್ರಮೋದ್ ನಾಯಕ್ ಚೇಂಬರ್ ಗೆ ಬಂದು ಮೀಟ್ ಆಗ್ಬೇಕು ಅಂತ ಹೇಳಿದ್ರಂತೆ. ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್
ಗೊತ್ತಿಲ್ಲ ಸರ್, ಅವ್ರು ಮೇನ್ ಇನ್ನೊಬ್ರು ಬರ್ತಾರೆ, ಅವ್ರನ್ನ ಕೇಳಿ. ನಂಗೆ ಗೊತ್ತಾಗಿಲ್ಲ ಏನು ನನಗೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಇಲ್ಲ ಸರ್. ಇನ್ನೊಬ್ರು ಬರ್ತಾರೆ ಮೇಡಮ್, ಅವ್ರನ್ನ ಕೇಳಿ.
This one like that.
58 in the month of January.
ಮುಂಚೆ ಆರ್ಡರ್ ಆಗಿತ್ತಲ್ಲ
ತಪ್ಪಾಗಿ ಟೈಪ್ ಆಗ್ತಿದ್ಯಾ? ಬೇರೆ ಕೇಸ್ ಇದು ಟೈಪ್ ಆಗ್ತಿದ್ಯಾ? ಜನವರಿ ಹಾಕಿಂತ
ಮಾತ್ರ ಅಲ್ಲಿ ಏನು ಹಾಕೋಬಹುದು ಅದಕ್ಕೆ.
ಜನವರಿಲಿ ಅವರೇ ಹೇಳಿದಾರಲ್ಲಪ್ಪ, ಇನ್ಯಾವ ಅರ್ಲಿ ಒಕೇಶನ್ ಬರ್ತದೆ ಇಲ್ಲ ಅರ್ಲಿನ ಒಕೇಶನ್ 15 ದಿನ ಜನವರಿಲಿ ಹೇಳಿದ್ದಾರೆ. ಜನವರಿ ಇದು ಅರ್ಲಿ ಪೋಸ್ಟ್ ಆಗಿದ್ರೆ ಆಗ್ತದೆ. ಎಲ್ಲ ಆಲ್ಮೋಸ್ಟ್ ಎಲ್ಲ ಮುಗಿದವು. ಪಾಸ್ ಹೋಗ್ಬೇಕಾ ನಿಮ್ಗೆ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಅವ್ರು ಕೊಟ್ಬಿಟ್ರಲ್ಲ.
ಈಗ ಹೇಳಿದ್ರಲ್ಲ ಸ್ಟಾರ್ಟಿಂಗ್ ಅಲ್ಲಿ ಲಾಸ್ಟ್ ಮೂಮೆಂಟ್ ಇದೆ.
ಲಾಸ್ಟ್ ಎಲ್ಲ ಆಲ್ಮೋಸ್ಟ್ ಎಲ್ಲ ರೀಚ್ ಆಗೋಯ್ತು.
ಎಲ್ಲ ಖಾಲಿನಾ?
ಆಲ್ಮೋಸ್ಟ್ ರೀಚ್ ಆಗೋಗಿದೆ.
ಮಧ್ಯಾಹ್ನ ಸಿಟ್ಟಿಂಗ್ ಇಲ್ವಾ?
ಆಟೋ ಇದೆ, ಪಾಸ್ ಓವರ್ ಇದೆ ಜಾಸ್ತಿ. ಪಾಸ್ ಓವರ್ ಜಾಸ್ತಿ ಇದೆ, ಜೊತೆಗೆ 230 ಮ್ಯಾಟ್ರಸ್ ಇದೆ. ಇದು ಅದು ಎಷ್ಟನೇ ಸೀರಿಯಲ್ ನೋಡಿ? 75 230 ಮ್ಯಾಟ್ರ್ ಅವೆಲ್ಲ 74 ವರೆಗೂ ಆಗಿದೆ.
74 ವರೆಗೂ ಯಾರಿಗಾಗಿದೆ?
ಅವ್ರಿಗೆ ಇಮೇಜಿಗೆ 73 ಪಾಸ್ ಓವರ್. 71 ಪಾಸ್ ಓವರ್. 74 after vacation. ಇಲ್ಲೇ ಇದೆ ನೋಡಿ, ಇಲ್ಲೇ ಇದೆ.
ಅಲ್ಲ ನಾನು ಹೇಳ್ಬಿಟ್ಟು ಹೋದ್ನಲ್ಲ ಸರ್, ರಿಸರ್ವ್ಡ್ ಅದು ರಿಸರ್ವ್ಡ್ ಬರ್ಸ್ಕೊಡಿ ಅಂತ.
ಸಪ್ರೇಟ್ ಕಳಿಸ್ತೀನಿ ಬಿಡಿ, ನಾನು ಫಾಲೋ ಅಪ್ ಮಾಡ್ತೀನಿ. 44 ತಾನೆ
ಅದು ಅವ್ರಿಗೆ ಹೇಳಿ, ಆಲ್ ಟೈಮ್ ರಿಸರ್ವ್ಡ್ ಅಂತ ಬರೀಬೇಕು, ಆಟೋ ಶೀಟ್ ಬರ್ದು ಸೈನ್ ಮಾಡಿಸ್ಬೇಕು. ಮೇಡಮ್ ನಾಳೆಗೆ ನಮಗ್ ಗೊತ್ತಿಲ್ಲ ಅದು. ನಾವು ಮೆಮೊ ಮೇಡಮ್ ನಾನು ನಿಮ್ ಹುಡ್ಗಿನ ಸರಿಯಾಗಿ ಕೇಳ್ಕೊಂಡೆ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಆಗಲ್ಲ. ಸರಿ, ಈ ವೀಕ್ ಅಲ್ಲಿ ಡೇಟ್ಸ್ ಅಂತಂದ್ರೆ ಅಲ್ಲ, ಈಗ ಇಲ್ಲಿ ಲಿಸ್ಟ್ ಆಗಿರೋದೆಲ್ಲ 6 ಮ್ಯಾಟ್ರ್ ವಾಪಸ್ ತೆಗ್ಸಿದೀವಿ. ನಾನು ತೆಗ್ಸಕ್ ಆಗಲ್ಲ. ಈ ವಾರದಲ್ಲಿ ಅವರು
Yes.
That was on 14th of March, my lords. Then 18th of March, my lords will kindly turn to page 23. A letter dated 12th of March is received by me on 18th of March. Kindly turn to page 23, my lord. Wherein the bank writes to me once again. I'll just read out the text of the letter. We refer to the above and your participation in the subject auction, offering a bid of so and so for the said property lot number 1 as per the terms of e-auction conducted on 24/2/25. You have been declared as successful highest bidder. As per the terms, you have remitted 25% of the final bid amount of 16 crores so and so, of that is 4 crores 1 lakh for the scheduled property, and we are glad to inform you that the sale is confirmed in your favor by the bank, and you are advised to remit 12 crore 4 lakhs, that's the balance 75%, on or before 28th of March 2025. To which, my lords, we respond at the very next page, page 24. Next day, we receive this on 18th of March. I'll just read out, it's a short email, my lords. We write to the bank. Dear sir, we acknowledge receipt of your email. However, we note that while your letter is dated 12th of March 25, the email containing it was sent only on 18/3/25. This discrepancy suggests that the letter was backdated. And anyway, there's no allegation as such, but in any event, admission that there is, it was received on 18th of March, second paragraph. Furthermore, as per the case details available to us, the Honorable High Court of Karnataka and writ petition number so and so has issued an order for status quo. Given this, it is perplexing that you have sent a letter dated 12th of March on 18th of March, despite the existence of the status quo order. Please take note that in light of the ongoing status quo order, the letter in question holds no legal effect unless and until the Honorable Court vacates the said order. Then, my lords, there is a long quietus while the writ petition is going on. I was not a party to the writ petition. The bank contested the writ petition filed by the borrower, and that writ petition came to be disposed of on 22/7/25. Wherein, my lords, in short, liberty was given to the borrower to approach the DRT within 3 weeks, and the interim order that was earlier granted was extended for a period of 3 weeks. Then, my lords, the DRT was approached by the borrower. My lords will find the order sheet at page 25, annexure F.
Yes.
Can I just read, my lords? There is a very short order again. I'll start with counsel for the applicant.
Yes.
Counsel for the applicant submits that the respondent bank has not confirmed the sale till date and stay for the same, and counsel for respondent bank submits that confirmation of sale is already done by the respondent bank. Time is granted as prayed for filing objection so and so. In the meantime, respondent bank is directed not to confirm the sale if it is not done by the respondent bank. This is on 11th of August. Now that interim order has been extended from time to time is what I'm told.
Even till now.
Even till now? It's still till there. We're not a party, but I'm presuming it's there till date.
Yes.
Then that was on, my lords will note, on 11th of August. Then about 17 days later, on 28th of August, the bank writes to me again at page 27.
Yes.
I'll just read that letter again, my lords. We refer to the above and your participation in the subject auction, offering a bid of so and so for the said property lot number 1. As per the terms of e-auction conducted on 24/2/25, you have been declared the successful highest bidder. As per the terms and conditions of sale notice, you have remitted 25% of the bid amount. You are advised to remit 12 crore 4 lakhs, the balance 75% of the final bid amount of rupees 16 on or before 30th of August. So they give me 2 days time on 28th of August to remit the balance 75%. To which, my lords, I once again reply. My lords will find my reply at page 29. Immediately on the next day, I file a reply, page 29. I'll just read from the text to the letter, my lords. Though I was declared as the highest bidder in the auction held on 24/2/25, the sale was not confirmed in my favor by issuance of a sale confirmation letter as contemplated under Rule 9(2) of the Security Interest Enforcement Rules 2002. As without issuance of the sale confirmation letter, the sale cannot be concluded and the borrower may use this as an opportunity to challenge the sale process. I was informed that the reason for non-issuance of the sale confirmation letter was on account of an interim order granted by the Honorable High Court of Karnataka in a case filed by the borrower. Even though the writ petition was disposed on 22/7/25, the Honorable Court granted 3 weeks time to the borrower to approach the DRT. Hence, the interim order was in operation until 13/8/25. Accordingly, I was waiting till 13/8/25 a receipt of the sale confirmation letter from the bank so that I could remit the balance 75% sale consideration in compliance with the statutory requirement. It has now come to my knowledge that on 11/8/25, one of the borrowers approached the DRT by filing proceedings by diary number so and so, and the Honorable Tribunal was pleased to grant an interim stay, restraining the bank from issuing the sale confirmation letter if not already issued. The said matter is still pending and has been reserved for orders. As per my limited legal knowledge, the said stay order continues to remain in operation until the final disposal before the Honorable DRT. Notwithstanding the above, I hereby convey my readiness and willingness to deposit the entire balance 75% sale consideration immediately upon receipt of the sale confirmation letter. I have already remitted 25% of the sale amount and I am fully prepared to close the auction process provided the sale is duly confirmed by issuance of the sale confirmation in my favor. We also request you to kindly withdraw your demand for payment of the balance sale consideration by 30th August 25, as the same is wholly unreasonable in the present circumstances. The auction purchaser who has already invested hard-earned money should not be subject to such undue pressure. We reiterate that we are only awaiting removal of the legal embargo to make payment, and we are here to assist the bank in recovering its dues in a lawful manner. Therefore, I request you to kindly issue the sale confirmation letter forthwith in respect to the auction held on 24/2/25, so that I may deposit the balance consideration and complete the sale transaction in accordance with law. So this was, my lords, on 29th of August 25. Then in the meantime, my lords, what happened was, I think there was some another writ petition, my lords, which of course stands withdrawn now. The borrower, my lords, and probably some borrower approached the bank for some settlement for OTS. Now they started entertaining that settlement offer while all of this was going on. Then on 10th of September 2025, my lords would come back to page 14. This is the impugned communication. Page number 14, Annexure A. Kindly see what they write in that. This, your lordships may recall, this is where the mischief really lies. This is in reference to your email dated 18/3/25 regarding your observation the legal status of the letter issued for the auction held on 24/2/25 in the account of Messer so-and-so during the subsistence of the status quo order passed by the Honorable High Court of Karnataka. Kindly mark this, Mr. We understand that our letter holds no legal effect. Hence, we hereby cancel the above mentioned auction held on 24/2/25. In this regard, we request you to collect the demand draft for the 25% of the bid amount deposited with us for the sale proceeds. I understand, my lords, initially the 25% we did not collect. So by RTGS, they transferred it. We transferred it back, but they just come back to us. So that is where we were at on that day also, my lords. We are in the same position. Now, my lords, our only grievance is this.
No. There was your letter dated
29/8/2025. Dated 29/8, my lords.
28/8.
29/8, correct. That's it, at page 29.
There is the response to that is only this.
That's all. That's all.
There is no other communication.
Nothing else. Nothing else.
Yes.
So therefore, my lords, your lordships may also recollect the defense that was set up on the last date was that, as per the provisions, Rule 9(4), 15-day period is cast in stone. 15-day period is expired. I am statutorily bound by the rules. Therefore, my hands are tied. I cannot do anything more. But my lords, your lordships may also recollect, I pointed out in their very own letter, they say that letter of ours has no legal effect. So as I was submitting on the last date, that 15-day clock has not even started ticking. So therefore, my lords, for them to send such a letter would be entirely arbitrary given the fact situation. And as I was submitting, there is some background going on about OTS offers and so on, which, given the fact that the Supreme Court has repeatedly held that there has to be sanctity given to the auction proceeding, that could not have been done. So that was what I submitted. I'll wait for what the bank has to say, then I'll rejoin. I'm sorry, Mr. Holla, there is the connected petition. I'm so sorry.
Yes.
Yes. In my case, my lord, there's not even, my lord, a confirmation order. If my lords, my lord, recollects. Sorry. Mine is, my lord, 29,083 of 25. I was a successful bidder. I was, my lord.
When the auction had taken place in this case?
Same date, my lord.
Same date.
24/2/2025. Then, my lord, I paid an amount, deposited an amount of 2.51 crores, my lord, being 25% of the bid amount.
Yes.
I was waiting, my lord, for the confirmation letter. In terms of 9/4, my lords, my lord, it's like carrying court to Newcastle. 9/4, my lord, they were required. They never gave me a confirmation letter. On 14/3, A writ petition, my lord, was filed by the borrower. Interim order of status quo was obtained.
Borrower is one and the same in both the matters.
Yes, same. Despite the order, the status quo, my lord, there is a status quo order. That means, my lord, even the bank should not do anything. What they do is,
So in this case also same orders. Same orders like in the other case.
but
Yes.
in my case, there is no confirmation letter also. My lord, at least in their case, they had issued a confirmation letter.
I think they have not issued.
Oh,
They have
in
not
their case
issued
also.
it. Only they have
Alright,
said it
same,
so
same. Then, my
before
lord,
the DRT.
we, my lord, sail in the same boat.
Yes.
They backdate, my lord, notice, my lord, backdating to 25/3, 12/3. My lord, if your lordship recollects, my lord, 14/3, my lord, there was an interim order. They, my lord, issue a letter backdating it to 12/3 and send it on 18/3. That's why, my lord, on the previous occasion, my lords had asked them to produce all the records, my lord, proceedings, my lord, from 24 to 25 to 10/9/2025. Nothing has been produced. Anyway, I leave it at that. Then, my lord, what they do is, they, my lord, ultimately, my lord, send me a letter saying that, well, your this thing, we are now
Auction
returning
is cancelled.
without even, yes.
Where is that communication?
Please come to my lord. 1/5, page 15, annexure A,
Page 15.
1/5, my lord, 15. My lord, it is 29,083, my lord.
Yes.
Page 15, annexure A, my lord.
One.
My lord sees cancellation auction notice held on so and so. With reference to the auction conducted on 24/2 in the above matter, we hereby inform that due to ongoing litigation before the Honorable High Court and DRT, we are unable to confirm the sale of the subject property. Accordingly, auction proceedings held stand cancelled. No confirmation letter, nothing. Therefore, my lord, and my lords are aware, 2024. One judgment, my lord. So, as I said, my lord, we come here and then, these are all matters which your lordships are so fully aware of. Supreme Court has held the moment, my lord.
Redemption of mortgage.
Correct. That's all. More than that. 2020. IDBI.
Very similar fact situation.
Correct.
Yes. Very similar fact situation.
Paragraph 3. My lord, I'm sure your lordships.
Paragraph number?
My lord, repeats, my lord, that judgment which I have given to your lordships, my lord, 2024 2 SCC 1. Para 10.3, my lord, 110.3. That's all.
Facts are at paragraph 3, my lord, of the judgment. Lord, we find how similar the facts are to the.
Let's read it.
Yeah, please come here.
The respondents, I just read paragraph 3, my lords. The respondents who are the petitioners in the writ petition are the auction purchasers of the property which comprises of 2 guntas land in survey number so and so, part in situated at so and so village, Telangana, pursuant to the e-auction. Which one? I'm so sorry.
I've given 24.
He has given me this.
That's a different one.
IDBI. I'm reading, I'm so sorry, I'm reading IDBI. IDBI is there?
In this, my lord, since I was on this, 110.3, my lord.
110.
Just have a look at it. 110.3, at my lord, last page 84, my lord. In accordance with the unamended section 13(8) of the SARFAESI Act, right to the borrower to redeem secured asset was available till the sale and transfer of such secured asset. That was, my lord, prior to the amendment. In other words, borrower's right of redemption did not stand terminated on the date of the auction sale or the secured asset itself, and remained alive till the transfer was completed in favor of the auction purchaser by registration of sale certificate and delivery of possession of the secured asset. However, amended provision section 13(8) of the SARFAESI Act makes it clear right to the borrower to redeem the secured asset stands extinguished thereunder on the very date publication of notice for public auction under Rule 9(1) of the 2002 rules. In effect, right of redemption available to the borrower under the present statutory regime is drastically curtailed and would be available only till the date of the publication of notice under Rule 9(1). That's, my lord, publication of, my lord, auction notice. Then, my lord, page 110, paragraph 110.7. The decision in Andhra Pradesh High Court in so and so, the decision in Telangana High Court laid down the correct position of law while interpreting the amended section 13(8), where, my lord, your lordship's court, I mean, sorry, your lordships are now ours, my lord, judge. The Telangana High Court and Andhra Pradesh High Court had held, my lord, that once the publication is there, my lord, right of redemption, my lord. In fact, in this, earlier, my lord, they had sought for a OTS, rejected, and then, my lord, all that is there.
You're relying on some judge.
Yes, sir.
Pass on that.
This is, I think at page 8, the second judgment in that, no, that page number 89. I think the first judgment is once again the same Bafna
Yes.
model which Mr. Holla had read. Page 89, I think it starts.
Yes.
Paragraph 3, madam. The respondents who were the petitioners in the writ petition are the auction purchasers of the property which comprises of 2 guntas of land in survey number 121 situated at so-and-so village, Mandal, so-and-so, Telangana. Pursuant to the e-auction notice dated 17/3/2018, the auction took place on 10/4/2018. The respondents were the highest bidders for a total sum of so-and-so. They deposited 25% of the bid amount, that is rupees 36 lakhs, on the day of the auction itself. The auction was confirmed, but the sale certificate was not issued and the sale deed was not executed, as the respondents could not deposit the balance sale consideration within 15 days, maybe for the reason that the appellant bank refused to accept the balance amount for various reasons. Finally, the appellant bank, by communication dated 24/12/2019, cancelled the auction and refunded the amount deposited by the respondents by means of 4 demand drafts, which were never encashed by the respondents. The respondents, as such, invoked the writ jurisdiction of the High Court, challenging the action of the appellant bank, cancelling the auction dated 10/4/2018 unilaterally, and for seeking a direction to issue the sale certificate after receiving the balance sale consideration of rupees 1,06,00,000. The aforesaid writ petition number so-and-so filed by the respondents was allowed by the impugned judgment and order dated 19/9/2022, passed by the High Court, holding that the appellant bank was not justified in withholding the sale certificate. The respondents were always ready and willing to pay the sale consideration. The appellant bank could not have denied the issuance of the sale certificate and the execution of the sale deed. The issuance of the sale certificate was not refused by the appellant bank for want of non-deposit of the balance sale consideration within 90 days, as stipulated under Rule 9(4). Therefore, such a plea taken by the appellant bank for the first time in the writ petition is not tenable. The argument is very similar here also. There is no communication which invokes Rule 9(4). The argument of the learned counsel for the appellant bank is that in view of the statutory provisions contained in the rules, especially Rule 9(4), since the respondents had not deposited the balance sale consideration within the mandatory period of 90 days, the High Court has erred in directing the appellant bank to issue the sale certificate and to execute the sale deed. The balance sale consideration was never deposited by the respondents within the time permitted, and the letter of the respondents clearly establishes that they kept on seeking extension of the time without depositing the amount. Moreover, on the complaint of the appellant bank to the CBI, the enforcement director has taken suo motu cognizance. That allows me. In the facts and circumstances of the case, the only issue which arises for consideration is as to whether there was any default on the part of the respondents in depositing the balance amount within the time prescribed pursuant to the auction sale dated 10/4/2018, so as to attract Rule 9(4) and allow the appellant bank to cancel the auction. There is no dispute to the fact that the appellant bank had issued an e-auction notice on 17/3/18 and had conducted the auction on 10/4/18. The respondents had participated in the said auction and were recognized as the highest bidder who had deposited 25% of the auction money amounting to so and so then and there. On the very same day, a sale confirmation letter was issued by the authorized officer of the appellant bank, requiring the respondents to pay the balance amount within 15 days so that the sale certificate may be issued. It may be noted that the respondents at no point of time have denied payment of the balance auction money as demanded to be paid within the 15 days period. It was only the appellant bank that denied the issuance of the sale certificate, first on the pretext that the e-guarantor had filed writ petition number so-and-so challenging the e-auction notice and had obtained a stay order on 18/4/2018. Secondly, the appellant bank on 8/3/2018 had made a complaint to the CBI and the ED took suo motu cognizance. That again may not apply. But here again, Malas will note. Here also, Malas, I'm ready and willing. I was always ready and willing, except that the stay order came in the way. Then Malas will may kindly come down to paragraph 18. I'll skip the remaining words. This is paragraph 18. The correspondence on record clearly reveals that the respondents were always ready and willing to deposit the balance auction amount of so-and-so and had rather submitted a bank draft dated so-and-so of the said amount and had requested for the issuance of the sale certificate and possession of the auction property. The said correspondence clearly establishes the bona fides of the respondents, and it was only the appellant bank who had avoided the issuance of the sale certificate. There is no material record to justify the non-acceptance of the balance sale consideration of the respondents within 15 days of the confirmation of the sale, and whatever pleas have been taken by the appellant bank to avoid acceptance are all subsequent and are not very material. In these facts and circumstances, reason for non-issuance of sale certificate is solely attributable to the appellant bank, and that there were no laches, negligence or default.
Yes, I have seen.
So therefore, this fairly applicable, no, even not, if not squarely, fairly applicable to the
Yes.
facts.
Yes.
Lord, your lordship may kindly take the first writ petition, my lord, which was
Yes.
argued by my learned friend Mr. Vikram. My lord, now the admitted position, my lord, is that there is no confirmation.
There is no
Confirmation. Both of us are saying there is no confirmation. Now the question that arises for your
But
lordship.
you have said so before DRT that it is confirmed.
Yes, my lord, we have said so before DRT. We are now also on record before this court that there is no confirmation. And the communication issue to the other side also says there is no confirmation. Whatever may be the reason. The fact of the matter, my lord, the admitted position on both sides is that there is no confirmation. The first submission I make to your lordship is, if there is no confirmation, what is the right that inheres in a bidder? Assuming that they are successful bidders, but their status does not change unless there is a confirmation. So my first submission to your lordship is that a bidder has no right to say you shall confirm. And in the absence of any such confirmation, there is no right vested in a party to approach this honorable court seeking for either a certiorari or a mandamus. Now, my lord, kindly see the prayer in the writ petition, my lord, if your lordships are kind enough.
Yes.
Page 12. Lord, kindly turn to page number 12, my lord. They're asking for a certiorari to quash Annexure A and to issue a writ of mandamus directing the respondent bank to consider the petitioner's request dated 29/8/2025 to issue sale certificate Annexure K and to pass appropriate orders in accordance with law. Therefore, my lord, what they are seeking for your lordship is a certiorari and a mandamus. Now, the mandamus prayer, my lord, will arise only if there is a certiorari in this case, because the other mandamus prayer would be a consequential prayer. And even if you look at the other way, my lord, if they are entitled to a sale certificate, then the communication and Annexure A would be bad. Now, therefore, the question arises as to whether they have a right to have a sale certificate issued. Does not the bank, who is a secured creditor, have a right to say, in the facts and circumstances of the case, I do not want to go ahead with the auction at all?
I will redeem the mortgage to the.
And redeem the mortgage, allow the debtor to redeem the mortgage.
So what all these judgments of the.
I will show to your lordships, my lord, that those judgments can be distinguished. I showed your lordships that, my lord. Therefore, my first submission to your lordship would be that there is no right vested in a auction purchaser whose sale has not been confirmed to get a sale certificate issued. Now, in the absence of that, my lord, my respective submission is a writ of this kind is not maintainable, seeking for a mandamus that you shall issue the sale certificate. Now, my lord, as your lordships have seen, my lord, whatever right can be claimed by the auction purchaser is on the terms and conditions of the public auction notice, on the basis of which, my lord, a bid was submitted. Now, please look at the auction notice, my lord. So we are producing the auction notice, is not on record. We're just giving it to your lordships.
Yes. Yes.
Lord, if your lordship will kindly turn to the page number, the last page.
There are no page numbers.
There's no page number. My lord, may I take it back and have it page number and give it to your lordships, my lord. So it will be more convenient for the court. I'm sorry, my lord, that it was not done. I just noticed it. Page numbers. Yeah. We'll give it to you. I tell you, Lordships, what the point is, so that I don't detain your Lordships. My Lord, the terms and conditions of the auction says that the bank reserves the right to vary, cancel, or rescind this auction for any reason without assigning any reasons. The point that I place for your Lordship consideration is, if a bidder has participated in the auction on the basis of certain terms and conditions as contained in the auction notice, is it permissible for a bidder to thereafter turn around and say, no, I am not bound by this? And my respectful submission is, that that is impermissible. If the bidder in the instant case, namely the petitioner, has participated in the auction, your Lordship may just see, my Lord, page number 7. Yes. Page number 7, my Lord, M. These are the terms and conditions of the auction. Begins, my Lord, the sale notice begins at page number 3. The detailed terms and conditions of the sale notice, my Lord, begins at page number 5. Yes. And the relevant term which I am relying upon, and I place it before your Lordships for kind consideration, is M. Yes. The authorized officer reserves the right to postpone, cancel, or vary the terms and conditions of the e-auction without assigning any reason thereof. Now, if a party has participated in the auction with open eyes with these terms and conditions, and I say I'm cancelling it now, I do not want to go ahead with this auction, and I do it before confirmation, before any right has vested in you, can they turn around and say, no, you cannot now cancel it, you're bound to go ahead? Virtually, what they're now telling your Lordship is, bank must proceed with the completion of the auction formalities because I am the highest bidder. I ask myself, my Lord, if after the auction is completed, before I confirm, there are number of litigations on this point, and I have, after all, my Lord, what is the whole object of the bank? Whole object of the bank, my Lord, is to ensure that public money is recovered. Now,
but unfortunately, it will not be the same stand of the bank in all the cases. If it is a uniform stand, we do accept it.
I know, my Lord.
Yes.
I know from where the court is coming, my Lord. But anyway, my Lord, in this case, at least, my Lord, I am fortunate to have a brief which shows, my Lord, that there is bona fide. The reason why I say so, my Lord, is this: on the basis of the settlement that we have with the borrower, 7 crores extra is being received by the bank. Now that undoubtedly is in public interest. Can it be said, therefore, that this right under M, clause M at page 7 can never be exercised by the bank, and that's what they're saying. And you participated in the auction with open eyes, saying that there is a clause like this. Therefore, my Lord, my respectful submission is that there's such a writ petition which goes against the terms of the very auction notice, the sale notice, would not be maintainable in the absence of any statutory right, and no such statutory right exists.
Yes.
That's my submission. And now, my Lord, I just want to show to your Lordship one judgment on this point. Where is the judgment which says that auction? My Lord, we are giving auction. My Lord, kindly see a judgment of a coordinate bench of this honorable court, which I am placing for your Lordship's concern. Number ಹಾಕಿದ್ದೀನಿ. Pages ಹಾಕಿದ್ದೀರಾ? ಹಾಕಿದ್ದೀನಿ. ಇಲ್ಲ ಕೇಳೋಣ. ನಾನು ಇದೆಲ್ಲ ಹೇಳ್ಬಿಟ್ಟು ಪೇಜ್ ನಂಬರ್ ಬರ್ಕೋತೀನಿ. ಪೇಜ್ ನಂಬರ್ 4%, ಪೇಜ್ ನಂಬರ್ 83 ಇಂದ ಶುರು. 83 ಕೊಡಿ. ಸಾಹೇಬ್ ಪರವಾಗಿಲ್ಲ ಬಿಡಿ, ಕೊಡಿ, ಪರವಾಗಿಲ್ಲ. ಸಾಹೇಬ್ರನ್ನ ಡಿಟೈನ್ ಮಾಡಬೇಡಿ. ಡೋಂಟ್ ಡಿಟೈನ್ ದ ಕೋರ್ಟ್. ಐ ಆಮ್ ಸೋ ಸಾರಿ. ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಕೊಡ್ತೀನಿ. ಅಲ್ಲಿ ಕೊಟ್ಟು ಅದರ್ ಸೆಟ್ ಕಾಪಿ.
Yes.
Yeah. My lord, the judgment of the coordinate bench of this court begins at page 83. And permit me to refer to paragraph 1(5), my lord, which is at internal page number 30 of this judgment.
Compilation ಕೊಟ್ಟಿದ್ದೀನಿ.
Compile it.
I'll give one set 10 days.
Copy. 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 Copy.
I've given the citation along with the. ಅದು ತಗೊಂಡು ಕೊಟ್ಟಿದ್ದೀನಿ ಫುಲ್ಸ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಈಗ.
I give. Please see para 15.
No, which judgment is that?
I am referring to the judgment which begins at page 83.
83.
Yes. There's a reference to, my lord, a judgment to the Madras High Court. And this honorable court follows the judgment.
Let's see.
May I place that for your lordship's consideration. The High Court of Madras in S. Moneymail versus Superintending Engineer has held as follows. A person who had participated in the tender and knowing the fact that he was unsuccessful cannot challenge the conditions stipulated in the tender. Such afterthought decisions or actions can never be entertained by the court. We are not concerned with that portion today. Kindly see para 40. This apart, even at the time of tender notification, the writ petitioner was aware about the tender conditions. Having accepted the conditions stipulated in the tender notification, the writ petitioner also had submitted his bid before the last date. Having participated in tender and after came to know that the writ petitioner was unsuccessful, then the writ petitioner cannot say that the conditions are void and mala fide. A person who participated in the tender notification cannot be permitted to challenge the tender conditions in normal circumstances. If at all such conditions are mala fide, the same must be raised at the first instance, and the unsuccessful tenderer cannot raise the ground that the tender conditions were mala fide and not in consonance with the guidelines issued by the Central Public Works Department of the Government of India. Such grounds raised cannot be accepted by this court at this point of time. The High Court of Madras holds that a person who has participated in a tender and emerges unsuccessful cannot challenge the conditions stipulated in the tender. As such afterthought action should not be entertained by the courts. I am in respectful agreement with the findings rendered by the High Court of Andhra Pradesh and High Court of Madras in the judgments quoted supra, and they would become applicable to the facts obtaining in the case at hand. And the judgment, my lord, of the Andhra High Court is referred to in paragraph number 14.
Yes. Yes.
Internal page number, paragraph number 14 at internal page number 21.
Yes. Yes.
And then, my lord, your lordship may kindly see, my lord, that quoted portion, paragraph number 12 at paragraph number 14. Tender condition number 19 that the bidders will not be awarded a spot building work of more than one ERO anywhere in AP, EP, DCL area might not have been in the earlier tender invitations, and one bidder might have been eligible for award of the spot building work of more than one ERO. But on that ground, the petitioner cannot insist the respondent to continue with the same condition. This condition may be for effective and timely spotting building work. Tender condition number 19 on the ground of challenge cannot be termed arbitrary. Then, my lord, kindly see para 14. It is well settled law that no person can claim a fundamental right to carry on business or trade with the government. Having said all that, my lord, kindly see para 16. The Directorate of Education, in Directorate of Education versus Educom Datamatics Limited, the Honorable Apex Court held that the terms and conditions of the tender are prescribed by the government, bearing in mind the nature of the contract in such matters. Authority calling for the tender is the best judge to prescribe the terms and conditions of the tender. It is not for the court to say as to whether the conditions prescribed with the tender under consideration were better than the ones prescribed in the earlier tender invitations. It is apt to refer to para 9 to 12 of Directorate of Education supra. Having referred to the judgment of the Apex Court, my lord, then there is a reference to Michigan rubber, which is in para number 18. Then 19, my lord, there is again a reference to Michigan rubber.
Yes.
Then, my lord, your lordship may kindly turn to internal page number 27, para 43 of the judgment which is quoted.
Yes.
Then, my lord, there is a reference to Article 14 regulating two preconditions or qualifications of the tender, that you cannot discriminate. And now kindly see, my lord, paragraph at internal page 28, para 23. From the above decisions, from the above decisions, the following principles emerge. Which, my lord, I am
Something
internal
wrong with
page.
the page numbers. You're referring to this.
My lord, the order of the coordinate bench of this court and that internal page number 28 of the judgment.
Yes.
Kindly see para 23, my lord, that is the quotation from the judgment of the Honorable Andhra High Court. From the above decisions, the following principles emerge. A, the basic requirement of Article 14 is fairness in action by the state, and non-arbitrariness in essence and substance is the heartbeat of fair play. These actions are amenable to judicial review only to the extent that the state must act validly for a discernible reason and not whimsically for any ulterior purpose. If the state acts within the bounds of reasonableness, it would be legitimate to take into consideration the national priorities. Then, my lord, I'm going to skip B. Kindly see C. In the matter of formulating conditions of a tender document and awarding a contract, greater latitude is required to be considered to the state authorities unless the action of the tendering authority is found to be malicious and a misuse of its statutory powers, interference by the court, is not warranted. And interestingly, my lord, this clause M is not challenged anywhere.
Yes.
Then, my lord, after having referred to all this, kindly see what this honorable court says. The High Court of Andhra Pradesh was considering an identical circumstance where supervision charges were to be indicated in tender document. Supervision charges in the model government order of Andhra Pradesh was from 0 to 6.5%. It was open to all bidders to quote 0% of supervision charges. This clause becomes the subject matter of the petition. The Andhra Pradesh High Court rejects the challenge that the quotation between 0 to 6.5% was anyway arbitrary. The court would further hold that it would not be open to the High Court to consider the issue unless the offending clauses would depict arbitrariness.
Yes.
So therefore, my lord, my respectful submission to your lordship on this would be that having participated in the tender on the basis of this clause M, it is not open for the petitioner to come and challenge it before your lordships. Now, my lord, kindly turn to the legal argument that has been advanced.
Yes.
The legal argument that has been advanced on the basis of Bafna's case. Now, please see section 13.8, which was, my lord, the section which came up for consideration. Kindly see 13.8 for a minute. Well, 13.8 was substituted with effect from 1/9/2016. And this, my lord, came up for consideration before the Honorable Supreme Court in Bafna's case. I'll read 13.8 for your lordship's kind consideration, lord. Where the amount of dues of the secured creditor together with all costs, charges and expenses incurred by him is tendered to the secured creditor at any time before the date of publication of notice for public auction or inviting quotations or tender from public or private treaty for transfer by way of lease, assignment or sale of the secured assets. The secured assets shall not be transferred by way of lease, assignment or sale with secured creditor, and in case any step has been taken with secured creditor for transfer by way of lease or assignment or sale of the assets before tendering of such amount under this subsection, no further step shall be taken with such secured creditor for transfer by way of lease or assignment or sale of such secured assets. So, my lord, the right which was given to a debtor to redeem the mortgage was at any time before the date of publication of the notice for public auction or inviting quotations. This is essentially a right given to the bank, the secured creditor, to say, sorry, I will not accept your plea for redemption. The bank is entitled to turn a debtor out and then say, I will not allow you to redeem your mortgage. This is a right which was given to the bank to tell a debtor that I will not entertain you anymore. Please do not come to me. This right can always be waived. Now, the question as to whether this right can be waived or not was not the subject matter in Bafna's case. Now, if the secured creditor says, well, it doesn't matter. I know that I cannot allow you to offer, but I will permit you to offer. Is it not a case where a secured creditor is waiving a right given to the secured creditor under section 13(8)? That's the question, my lord, I ask myself, and I place it for your lordship's kind consideration. If, my lord, in the instant case, the bank had told the secured creditor, the debtor, sorry, I will not entertain you, because I have already taken steps for putting the property to sale. Could the debtor have come before your lordships and said, no, I have a right of redemption under the Transfer of Property Act, and therefore the secured creditor was wrong in keeping me out? That right which was available to a debtor prior to the amendment to 13(8) is today not available to a debtor. But does it mean that a creditor cannot say, well, in spite of the fact that you have no right, I will still entertain you? That's the
So
question.
the sum and substance of your argument
My
is
lord.
the secure creditor has every discretion to redeem the mortgage at any point of time he wants.
Yes, that's
And
right.
issuance of a sale, auction sale notice is a formality according to the secure creditor.
That's right. And it is, and without the issuance of a sales certificate, auction purchaser, even though the auction purchaser may be the highest bidder, does not have any right. It is, in fact, what we call in law, my lord, an inchoate right. An inchoate right cannot be enforced in a court of law. That's the subject. Now, my lord, on the question of the waiver of a right, I just want to place one authority for your lordship's consideration.
Yes.
Yeah, waiver. Yeah? Yeah. Our copy, copy. Yeah, copy. Just pass on. But this also arose under the SARFAESI Act. Now kindly see paragraph number 19, my lord, 19.
It's a case of 2013.
Yes, yes. My lord, in Bafna's case, the question of waiver did not come up for consideration. That didn't come up at all. It was, that question has not been considered.
No, even on that day, on 13(8), this, by 2013, it was an unamended provision of 13(8).
My lord, 13(8).
It was amended in 2016.
Yes, correct. Yes, yeah, this was before amendment. That's true. That's true. That's true. But 13(8) was not the subject matter of this writ petition. I am citing of this citation, my lord. I am citing this only for the proposition that a right, whether it is statutory or contractual, can always be waived.
Yes.
Kindly see para 19. There is no doubt that rule 9(1) is mandatory. Like 13(8).
Paragraph number?
Para 19, my lord, 19.
Yes.
At internal page 92 of the citation. There is no doubt that rule 9(1) is mandatory, but this provision is definitely for the benefit of the borrower. Similarly, rule 9(3) and 9(4) are for the benefit of the secured creditor, or in any case for the benefit of the borrower. It is settled position in law that even if a provision is mandatory, it can always be waived by a party for whose benefit such provision has been made. This 13(8) was not made for the benefit of an auction purchaser. 13(8) was made for the benefit of the secured creditor to say, you need not entertain a debtor after a particular cutoff date. And therefore, having that right under 13(8), not to entertain, I can always say, all right, no, still, please come. That's exactly what happened in this case. And I showed your lordships, my lord, that even on the basis of the application of 13(8), we have not done anything wrong. I'll just complete a few lines in this, my lord. It is settled position in law that even if a provision is mandatory, it can always be waived by a party or parties for whose benefit such provision has been made. The provision in Rule 1 being for the benefit of the borrower and the provisions contained in Rule 9.3 and 9.4 being for the benefit of secured creditor, or for that matter for the benefit of the borrower, the secured creditor and the borrower can lawfully waive their right. These provisions neither expressly or contextually indicate otherwise. And today, I ask myself, how does a bidder get a right under 13.8? Under which provision of law? If this proposition that they are canvassing, my lord, that 13.8 is a complete bar, do not entertain. And therefore, every bidder, even an unsuccessful bidder, can come before the court and say, no, you shall not entertain the debtor, because the auction sale notice has been issued. That would be, my lord, in my respectful submission, a very incongruous situation in law. Then, my lord, I want to place before your lordship's consideration. Now, therefore, my lord, the proposition I place for your lordship's consideration is that a writ of the present kind should not be entertained. Now, my lord, can kindly see another angle. Writ is always a discretionary remedy. Even if there is an illegality, a writ will not be issued as a matter of right to a party. The court is entitled to say, yes, there is illegality, but there is supervening public interest, which dissuades me from issuing a writ, even if I can see an illegality. Now, my lord, for that, I want to place for your lordship's consideration. My lord, in the list of citations that we give your lordships, please be kind enough to turn to that authority, my lord, at serial number 3, that Eastern Coalfields case.
Third judgment.
Lord, would your lordship be kind enough to turn to page 46?
Yes.
Kindly turn, my lord, to paragraph 18 and 19, my lord. If your lordships will be kind, kindly see page 52. In every case where your lordship sees an illegality, I ask myself the question, would your lordships issue a writ? If the answer to that question is yes, then what is the meaning of saying that the writ is a discretionary remedy? The court can always say, well, there is an illegality I see, but in my discretion, I will not exercise my power to issue a writ. Now kindly see, my lord, paragraph number 18. The question that arises for consideration is that once he had availed the benefit by not stating the correct fact, whether the equitable jurisdiction of Article 226 of the Constitution should be extended to him. The division bench has recorded a finding that the respondent could not have been allowed to participate in the examination without producing the matriculation certificate. The said finding is based on an assumption and has been arrived at totally being oblivious of the inquiry report which records a statement of the respondent. In this context, we may profitably reproduce a passage from Union of India versus C. Ramaswamy. I'm going to skip that. Now, my lord, please see para 90. The controversy can be viewed from another angle. Thereafter, the learned judges opined that there is no justification in the proposition that principle of estoppel would not apply in such a situation. As is manifest in the case at hand, the respondent stated this on the higher side to gain the advantage of eligibility, and hence we have no trace of doubt that principle of estoppel would apply on all fours. It is well settled in law that jurisdiction of the High Court under Article 226 of the Constitution is equitable and discretionary. The power of the High Court is required to be exercised to reach injustice wherever it is found. In Sangram Singh, it has been observed that jurisdiction of Article 226 of the Constitution is not to be exercised whenever there is an error of law.
Yes.
Therefore, let me assume for the sake of argument that there is an error in law in entertaining a debtor in violation of 13.8. my contention is that there is no violation of 13.8. Assuming there is, would that per se entitle a petitioner of the present kind to the issuance of a discretionary writ under Article 226? That's why, my lord, the court says in Sangram Singh, it has been observed that jurisdiction under Article 226 of the Constitution is not to be exercised whenever there is an error of law. The powers are purely discretionary, and though no limits can be placed upon that discretion, it must be exercised along recognized lines and not arbitrarily. And one of the limitations imposed by the courts on themselves is that they will not exercise jurisdiction in such class of cases unless substantial injustice has ensued or is likely to ensue. I ask myself, please apply this test to this case. What is the substantial injustice that has been caused to the petitioner in this case? Well, petitioner did pay 25%. That has been returned. Whether they have encashed it or not is their discretion. Apart from that, here is a case where bank is now able to get from the debtor 7 crores over and above the money that has been realized from the auction. To that extent, it cannot be doubted that public interest is served, as opposed to the private interest of the auction purchaser, the petitioner. In such a situation, I ask myself, what is the injustice which has ensured or is likely to ensure? Then, my lord, kindly see, my lord, what the Honorable Supreme Court says, that apart, the High Court, while exercising jurisdiction in Article 226 of the Constitution, can always take cognizance of the entire facts and circumstances and pass appropriate directions to balance justice. The jurisdiction being extraordinary, it is required to be exercised keeping in mind the principles of equity. It is well-known principle that one of the ends of equity is to promote honesty and fair play. If a person has taken advantage, etc., but we are not concerned with that. I'm not for a moment saying that there is any dishonesty on the part of the petitioner. I would just stop at saying that this is not a case where there is substantial injustice has ensued or is likely to ensue. Per contra, this is a case where the bank's interest, I wouldn't say the bank's interest, my lord, is public interest, is safeguarded. And all that the petitioner would be entitled to is to get back this money. Now, my lord, another aspect your lordship may kindly see. Why do I say that there is no violation of 13.8? Apart from the plea of waiver that I place for your lordship's consideration. Lord, now, the entire confirmation and the auction has been cancelled, which means that the sale notice itself becomes non-est in the eye of law. If the sale notice becomes non-est in the eye of law, then 13.8 is not a bar, because 13.8 says before the issuance of a sale notice. Therefore, the first sale notice is the present sale notice, no confirmation, and it has been cancelled. There is a provision, my lord, in the sale notice for cancellation.
Petitioner can say there is no confirmation. How can you say there is no confirmation?
My lord, that
said so before the DRT.
My lord, that is because, I tell you, lordship, what has happened. Because in the writ, there is an order for maintenance status quo. And during the pendency
No, but
of that,
why did such a submission made
wrong.
before the DRT?
No, DRT, my lord, it is wrong. It, in fact, or the submission.
The counsel appearing for the bank has made the submission.
My lord, maybe, my lord, maybe that it has been done. I know, I am conscious of that. But the facts are staring in our face. Here was a status quo order passed on the 12th. Confirmation on 18th.
No, the submission, if I remember on the last occasion, Mr. Vignesh Shetty was submitting was status quo is not for any other purpose. It's only for the property. So that because of that confirmation is done is what he submitted.
I know, my lord, but possibly, my lord, we have thought about it a little more deeply. And one way of, my lord, one way is what my learned friend says. I'm not for a moment saying, but possibly, my lord, one other way of looking at it. One other way of looking at it is a status quo, do not do anything. And that's the plea that the petitioner also takes. Maybe, my lord, when we discussed it further, both of us thought that maybe this is a more appropriate, not for the purpose of the case, not as a plea of convenience, but there is a status quo order passed by the High Court. So, my lord, it is always better to give a broad interpretation to court orders and then err on the safer side. Because otherwise, my lord, court orders are, we should not, if you play with fire, you can't complain of burned fingers. So therefore, my lord, when you look at it that way, and there is no confirmation, the entire sale is set at naught, which means there is not even a sale notice. Today, if I want to, let me assume for the sake of argument, my lord, or that there was no settlement with the borrower, I have to start the process all over again. In which event, my lord, before I start the process all over again, suppose the borrower comes and says, well, please give me an opportunity to redeem my mortgage. I'm willing to pay you the money. Then 13.8 is not a bar. Therefore, my lord, looked at it from various points of view. My respectful submission is that this is not a fit case for exercise of discretion by this honorable court under Article 226. This is my anything else? My lord, there's another point that I want to place. I'm grateful to my learned friends for pointing it out to me. My lord, the question would be on maintainability of a presented petition. Please see the first judgment, my lord, in Agrawal Tracom, 2018 1 SCC 626. My lord, may I trouble your lordship to kindly turn to paragraph 18. Page 11.
Yes.
The short question that arises for consideration in this appeal is whether the High Court was justified in holding that the remedy of the appellant auction purchaser lies in challenging the action of the secured creditor PNB in forfeiting the deposit by filing an application under Section 17 of the SARFAESI Act before the DRT, or the remedy of the auction purchaser is in filing the writ petition under Article 226, 227 of the Constitution to examine the legality of such action. Then, my lord, please be kind enough to turn to paragraph number 27.
Yes. 27.
Page 18. My lord.
Yes, yes.
So far as this case is concerned, sub-rule 5 of rule 9 is relevant. It provides that if the auction purchaser commits any default in payment of sale consideration within the time specified, the deposit made by auction purchaser shall be forfeited to the secured creditor, and the auction property shall be resold, and the defaulting purchaser shall forfeit all claims to the property or its part of the sum for which it may be sold subsequently. Now, my lord, please be kind enough to turn to paragraph number 27. Reading the aforementioned sections and the rules, and in particular section 17.2 rule 9.5 would clearly go to show that an action of the secured creditor in forfeiting the deposit made by the auction purchaser is part of the measures taken by the secured creditor under section 13.4. The reason is that 17.2 empowers the tribunal to examine all the issues arising out of the measures taken under section 13.4, including the measures taken with the secured creditor under rule 8 and 9 for disposal of the secured assets. For the borrower, there can be any doubt but not that confirmation is also a measure under 13.4. The expression provisions of this act and the rules made thereunder occurring in subsections 2, 3, 4 and 7 of section 17 clearly suggest that it includes the action taken under section 13.4, as also includes therein the action taken under rules 8 and 9, which deal with the completion of sale of secured assets. In other words, the measures taken under section 13.4 would not be completed unless the entire procedure laid down in rule 8 and 9 for sale of secured assets is fully complied with by the secured creditor. It is for this reason that the tribunal has been empowered by section 17.2, 3 and 4 to examine all steps taken with secured creditor with a view to find out as to whether the sale of secured assets was made in conformity with the requirements contained in section 13.4 read with the rules or not. Then, my lord, your lordship may kindly turn to paragraph number 30 at page 21 on top. Yes. Third line. In our view, therefore, the expression any measures referred to in section 13.4 taken by the secured creditor or his authorized officer in section 17.1 would include all actions taken by the secured creditor under the rules which relate to the measures specified in section 13(4). The auction purchaser is one such person who is aggrieved by the action of the secured creditor in forfeiting their money. The appellant therefore falls within the expression any person as specified under section 17(1) and hence is entitled to challenge the action of the secured creditor PNB before the DRT by filing an application under section 17(1) of the SARFAESI Act. Then, my lord, please be kind enough to turn to para 34.
Yes.
Now that begins at top of page 25.
Yes.
In the light of the foregoing discussion, we are of the considered opinion that the writ court as also the appellate court were justified in dismissing the appellant's writ petition on the ground of availability of alternative remedy, statutory remedy of filing an application under 17(1) of the SARFAESI Act before the concerned tribunal to challenge the action of the PNB in forfeiting the appellant's deposit under Rule 9(5). So therefore, my lord, the remedy under section 17 of the SARFAESI Act is available not only to a debtor, it is also available to an auction purchaser. That is the law laid down by the Honorable Supreme Court. We find no ground to interfere with the impugned judgment of the High Court. Any other? Of course, my lord, there is one judgment of the Kerala High Court, and I must tell your lordship, my lord, that that judgment does not take note of the judgment of the Honorable Supreme Court in Bafna's case, but I shall place it for your lordship's reference, that's all. But I must point out in all fairness, my lord, that the judgment seems to go contrary to the law laid down in Bafna's case, but Bafna's case doesn't apply to the facts of the case. I just give that reference to your lordship, my lord, and we have put it in our second judgment. We have put it, the Kerala High Court judgment, my lord. But I must say, my lord, that the judgment may not hold the field today in view of the law declared by the Honorable Supreme Court. This is my
Appearing for the Lords, it's a no, my lords, it's a little piquant situation with which the borrower is pleasantly placed. The dues they wanted to recover was about 32 crores and we paid about 39 crores and we have settled this matter. But what is very relevant, my lord, says every auction sale which is initiated under the scheme of the under the SARFAESI Act and the security interest rules are required to be concluded in a time-bound manner. There are steps and stages which is required to be claused. Each stage gives certain rights to the borrower or to the secured creditor and ultimately to the auction purchaser in the event the auction purchase takes place. The primary question here is, when does that right crystallize in favor of the auction purchaser for the purpose of knocking at the doors of the court saying that, yes, he has paid 25% and therefore the remaining amount has to be accepted. Factually, it should be justified. Notice the order which was passed was status quo the property. The bank has understood it in a particular manner. Fair enough. That's what the banks thought. Notice my learned senior friend has already read to your lordships the order passed. Status quo quo the property. The bank issues a confirmation letter. Lordships may kindly have a look at that confirmation letter, which is produced at. I'll just take your lordships to page.
The submission is it is not confirmed.
Notice that the letter, because what prayer they are seeking is contrary to the arguments which they have made.
No, that's the bank's stand also.
Is
So
that
there is
it's
no confirmation.
Lord's bank stand, the letter which they are requiring your lordships to direct for consideration itself says it is not yet considered. Ask them to consider, ask them to confirm. Lords, I can understand if they want to rely upon the statement made by me. What is your statement before the court is what is to be looked into. Page 20, status quo quo the property. Then page number 23, the bank writes a letter on 12/3/2025 that your auction is confirmed. Lords, once the auction is said to be confirmed, then what happens? The clock starts ticking for the purpose of payment of remaining 75%. So either he can accept it or he can say, no, I don't want to accept it, the confirmation, which right is not given to him. But I'm saying that this is like a right of election. There he cannot approbate and reprobate at that point of time. When we say that your sale is confirmed, he writes a letter back on 19th of March at page number 24, where he says that there is an interim order of status quo. Therefore, your confirmation has no legal legs to stand. We don't accept your confirmation. you have denied our confirmation. If you accept our confirmation, 90 days is lapsed, the maximum period within which you could have paid the money, even then the sale would have gone. If you don't accept the confirmation, the next question is, do you have any such right to ask for confirmation of sale? Now, where does this right stem from? Now, if your lordships were to see the representation given, which they are requesting your lordships for a mandamus to consider, because that is something which is not read to your lordships. Page number 29 in the red papers.
Yes.
Request itself is for issuance of sale confirmation letter. BAFNA comes about when, that's the reason where I said that there are stages. We have not gone to the stage where there is a confirmation and at that stage there is a cancellation. No. We are at a stage when admittedly there is no confirmation.
So as per 13(8).
So far as 13(8) is concerned, the right which is given to the borrower seeking the redemption of mortgage is lost the moment there is a paper publication. That's essentially what is said. Now, this is so far as my right is concerned. No difficulty. I may not have the right to redeem the mortgage as long as that public notice for sale is alive. I wanted to put it this way, I had made this proposition earlier.
What you are saying, so it is that now they issue an auction notification, auction is conducted. Now without confirming it, they will cancel it.
Yes.
And now they will ask you, they will give you an option to redeem the mortgage.
If
For the purpose of redeeming the mortgage, they will cancel the auction.
Now it can be the other way around also. I wanted to put a situation of this kind to myself. They put it for auction. Auction doesn't take place. For some reason, there are no bidders.
No, that's altogether a different
Or
scenario.
there is a bidder, he does not pay the money. So 25% he deposits, remaining he does not deposit. Then what happens? Then again, the property is required to be re-auctioned. This is the window which is created at every stage when an auction is contemplated for the purpose of borrower to redeem the mortgage. 13(8) is not to be read. 13(8) in BAFNA's case was read as an absolute bar on account of the fact that there was already a confirmation of sale. No difficulty about that proposition. But 13(8) to be read that when no auction has taken place, no confirmation has taken place, or the auction fails, that no, I should not come and then redeem will be militating against the object under the
They have
statute.
given a reason why they have cancelled the auction here because of the pending litigation.
No, it's
They
there.
have not stated that as per the sale condition, you have not paid the amount.
No, it's the question is the action of the bank to be questioned by the petitioner. Petitioner will have to show the locus. This is where the entire question. That is the reason why I said, at every stage there is a right which accrues in favor of a particular person. When it comes to the question of an auction purchaser, the right accrues upon confirmation. Till then, he will not have a vested right. Until and unless there should be either an established right or a vested right or an establishable right in the petitioner for the purpose of maintaining a writ petition of the kind. If your lordships were to see page 29, what is that they are asking for? Request for issuance of sale confirmation letter in respect of public auction held on 24/2/2025. This is a notice which is issued by them on 29/8/2025 for consideration.
When did you pay the money to the bank?
No, it's this money. No, it's under.
The payments is not coming to bank.
November, my lords, we have paid it in the month of November.
The lordship says directed on 29/10/2025 to place the entire
Why it was
proceedings
not
that
placed
has
on
not
record,
been placed
Mr.
so far.
Vignesh?
But I'm told whatever document is there has been filed along with the statement of objections.
No, it's not whatever document.
It's on a legal.
Lord,
Yes.
This is
And
totally
on a-
different thing, Lord. The
This is
proceedings, the OTS proceedings, consideration, non-consideration to be placed is what directed, what was directed. That has not come so far.
The OTS okay, which has been given, has been placed, but not, that is dated 4/10/2025 before. That's been placed before, but that's already there before. There's nothing more, my lord, is the instructions I have.
Lord, there are at least 3 judgments, my lords, which consider this very issue. Lords, because whenever an auction is held, and the auction notification specifically says, or the law under which the auction is held specifically says it is subject to confirmation, or it is subject to confirmation of a particular authority. then what is the status of an auction purchaser? This is not a question which came about to be considered, my lords, in Bafna's case. Bafna's case considered post confirmation, no difficulty about that proposition. But what is the status of a person who is a bidder when the auction is subject to confirmation by an authority under the scheme of the statute? That is a point which your lordships is required to consider, my lords, in this matter. Now, if I were to just take your lordships notes, how the
Here.
auction
the
purchaser
only-
is playing a mischief.
The only purpose of cancelling their auction is because you have paid the money.
No, it's now-
Their case, your case is considered.
I
So
just
for that
want,
purpose,
can
I've asked
I
them,
persuade your lordships?
whatever are the proceedings that are between, what is the date I said in the last order?
2910.
But then why did you not place it before the court?
I think I have an answer for that, my lords.
No, that's for the bank to answer.
No, in the writ petition filed by them, there is an answer for that. In the writ petition filed by them, there is an answer for that.
The specific order from the court to place all the record pertaining.
That's of course, that is for the bank.
So and so, the bank should have placed
So,
it.
Lord, bank and my instructions are, my lord, that whatever documents are there have been placed along with the statement of objections, and there's nothing more.
Only the OTS letter is been placed.
And
Proceedings,
what-
the management committee
That's
is
all
not
that
been
it
placed.
is. The OTS proposal has been placed before the honorable court.
No, if he has paid the amount, that means the whatever is the acceptance of the OTS proposal, when was it done? What it is, they're all relevant.
It's recorded.
It's
in record.
Think of that as well.
But done for what the court feels
Would your
is,
lordship kindly see, my lord, the.
Canara Bank is conducting the affairs of the bank like as per their whims and fancies. That's what I've been seeing in this, with a couple of weeks, this court is hearing the matters. There are no rule, no rhyme, nothing. Whatever they feel, that would be the law. SARFAESI Act is, they can, to their understanding and to their advantage, they can.
Of course, they can't.
What it appears.
Of course, it can't.
There
be
are so
done.
many matters, not only this matter. And in fact, I told Mr. Vignesh Shetty that I'll pass an order directing the Reserve Bank to look into the affairs of the Canara Bank. Why are they conducting these affairs as per their own
In fact,
whims
your
and
lordship
fancies?
asked me, my lord, whether there is any proceeding accepting the offer. It is there.
That's what
We
I
have- we have
wanted to
produced it.
know.
We have produced.
No, from the
It is
day.
produced.
Where is that proceeding sheet?
It is produced.
Where is the
There is
proceeding
an
sheet?
inter-office memorandum. Please see that, my lord. That is the document.
Along with the memo we placed.
Along with the memo, I am given to understand it has been placed for your lordship's consideration.
So it's a request made by the borrower.
No.
Nಮ್ಗೆ copy ಕೊಟ್ಟು.
See where it is.
No copy has been furnished to us. It's a request they made on 11/9/2025.
My lord, would your lordship kindly see, my lord, the sequence? Please take our statement of objections that we have filed in this writ petition. Please turn to page 215.
That's only the
This is the offer proposal.
This is on 29/10/2025. Respondent bank shall place before this court all the transactions proceedings.
Yes.
That are taken place from 24/2/2025
Correct.
to 10/9/2025.
That's
Subsequent to this order, where is the memo?
My lord, please be kind enough to turn to our statement of objections filed on 7/11/2025. I'll give your lordship the sequence, my lord.
Yes. 7.
That your lordships will see that everything has been done in a transparent manner.
Let's see from February what is that.
My lord, please be kind enough to turn to page 215 of the statement of objections. As your lordship will kindly see, my lord, statement of objections is dated 7/11/2025 after your lordship's order. Now, my lord, at page 215.
Yes.
This is a letter that has been received from the borrower.
1 minute.
MSQ said, correct.
Dated 11/9/2025. Saying, my lord, please give me a one-time settlement in the matter of Amalor International Limited, who is the borrower. And now kindly see the third paragraph, my lord. Hence, as a surety to the aforesaid loan transaction, we would like to propose
Notes I've written in the other book. Yes. Yes.
May I read that, my lord?
Yes.
Hence, as a surety to the aforesaid loan transaction, we would like to propose a sum of rupees 33 crores as one-time settlement amount towards full and final settlement of the aforesaid loan amount pertaining to loan account number so and so Further, we would also like to mention that the entire aforesaid loan amount would be settled within 90 days from the date of intimation of acceptance of a proposal amount of 33 crores by the bank.
No, I have asked from the month of February 2025 till whatever from February, because whatever the correspondence that is going on between the parties.
The entire one-time settlement proposal started only on 11/9.
Not about one-time settlement. I only said with regard to this auction sale, right from February till.
Oh,
9.
all the auction sale. Well, that will give.
That is what I have put this order.
That will give. That's not. Because what was understood, my lord, was with respect to the voting. That's why it was. Oh, wait. That is so.
Okay.
There's no difficulty, my lord. They can file it. I mean, there's no. But my lord, whether the bank is right or bank is not right is in so far as the court is concerned. What they should do towards the court is concerned, be transparent. Whether it is right or wrong is a different issue. My lord. Their understanding may be right, may be wrong, but it's a different matter.
He has something to say.
No. What the court wants, where is it? It's all
in the petition, not the main petition only.
No. Is there anything else in the file?
Nothing according to.
Is there a file? Produce that file. So we'll produce that file. Yeah, I tell him to place the entire thing. My instructions are that whatever documents are there in the file are already before this court in terms of the documents filed by the petitioner and in terms of the documents filed along with the statement of objections. But
Auction notice.
no hesitation in giving your lordships the entire file. It will be done. And then, my lord, just to complete the sequence. Sorry, sir, to interrupt you.
Sir, sir.
My lord, after this letter that was given for OTS on 11/9/2025, the acceptance of the OTS for not is on 4/10/2025.
This order. This is Shampa's order.
Yes.
Now, my lord, this acceptance of the OTS proposal was in the context of an order that had been passed by this honorable court on 17/9/2025, which your lordships will find at page number 217 of the statement of objections.
This court has directed you to
Yes.
consider one-time
Yes. May I read that portion? The first respondent has brought the subject property a secured asset for sale, with the petitioner having successfully participated in the same.
Where is that order?
My lord, page 217, my lord, of the statement of objections. It is in the presented petition.
Yes.
May somebody lordship to kindly see page 218. The order, my lord, begins at the bottom of page 217 on 17 September 2025. And the relevant portion, my lord, is at page 218. May I read it, my lord? The first respondent has brought the subject property a secured asset for sale, with the petitioner having successfully participated in the same. And the cause for this petition is the decision to cancel the auction sale, calling upon the petitioner to collect the demand for 25% of the bid amount offered. Shri so-and-so learned senior counsel with the petitioner proposes to highlight certain timelines to show that the first respondent's imputed decision is arbitrary and that it could not have cancelled the auction. Shri so-and-so, the learned senior counsel for the first and second respondent, and Shri so-and-so learned senior counsel applicant whose application is now taken on record, are categorical in stating that with the interim order must be by the DRT in the case of so-and-so, respondents are restrained from confirming the sale, that the applicant has deposited amount with 14 crores as part of the terms of the OTS scheme offered for closure.
No, pausing here for a minute.
I'm sorry.
No, just now you have referred to this one-time settlement letter that is on 11/9/2025.
Yes.
This 11/9 you have forwarded it on 17/9. By that time you already forwarded that OTS letter offer.
Yes, sir.
Competent authority for
Okay.
consideration.
And therefore, my lord, what they say is, these submissions are considered, and this court opines for the present that the just arrangement would be for the competent authority to consider the OTS proposal uninfluenced by the pending proceedings to be placed before this court for this court's next order that should be. When queried, Shri so-and-so submit the decision of the competent authority will be before 25/9 while calling upon said decision to be placed on record, subject to further orders, office is directed to release it on 25/9. And of course, my lord, it was not done on 25/9. It was done a few days later, and it has been placed before this court. This is the sequence, my lord. Notwithstanding the entire file, whether it is a duplication of the records already before the court as part of the petition or as per the statement of objections, record file will be placed before this court.
Yes.
Once I just, there's two submissions, my lords. If your lords were to see, rule 9(4), my lords, because as I submitted, my lords, the question is as to whether there is any vested right in an auction purchaser where a sale is not confirmed when the statute requires the sale to be confirmed to come before the court and say the auction should be concluded. No, it's notwithstanding 13(8) may oust the borrower, no difficulty about it. But whether that will give a right for the auction purchaser to come and say that no, since the auction is concluded, 25% is paid. I am saying that no, you have not confirmed the auction.
No,
Even
the whole purport of 13(8) and the judgments of the apex court stressing upon the moment the auction notification is issued, the right of the borrower for redeeming the mortgage is no more available, but the reason is to have the sanctity to the auction proceeding.
absolutely no difficulty, my lords. Now,
But it
let's say,
appears from this
no,
that there was no.
if your lords were to see the facts which my learned friend read out from the Bafna's judgment, and admittedly the sale was confirmed, it makes a rank difference. If the sale is confirmed and sale is not confirmed, makes a rank of difference. This is essentially, my lords, the splitting line between the rights of an auction purchaser and the rights of the bank for cancellation of the action. This is essentially the cutting point. That was a case where the sale was confirmed. The auction purchaser accepted the confirmation. Then he said, I am accepting the confirmation, I am willing to pay this money. Then after that, the bank said, no, we want to go back and we'll cancel the auction. It is in those circumstances, of course, there they wanted. In those circumstances, what the Honorable Supreme Court said, quay the bank, is that the moment you confirm the sale, you cannot go back. You cannot go with the borrower who did not have a vested right under 13(8) because you had already confirmed the auction. That's the reason why I said, it's a situation where, in the same scenario, let us assume a situation where the auction is conducted, 25% is deposited, he accepts the confirmation, does not deposit the remaining money. Then what happens? There is no auction. Then the property is open. What is that they are required to do? Once again, notify under 13(8). Because the whole process is to be continued from 8.5, 8.6, 9.1, and then go on up to 9.6. Lords, may I kindly see rule 9.4, my lords.
Yes.
Rule 9.2.
I think even in this case, this 9(4) also need not be considered.
9.2, my lords. We need not go to 9.2 only, my lords.
Yes.
Because that's where it is. That subject to is very important, my lords. What is?
Yes.
The sale shall be confirmed in favor of the purchaser who has offered the highest sale price in his bid or tender or quotation or offer to the authorized officer, and shall be subject to confirmation by the secured creditor. So confirmation of sale. Then what happens? If your losses were to see, next, the balance amount, the reason why there is a significance to this confirmation is what is referred to in subrule 4. Balance amount of the purchase price shall be paid by the purchaser or authorized officer before the 15th day of confirmation of sale of the immovable property, or such extended period as may be agreed in writing by the purchaser of secured credit not exceeding 3 months. So confirmation is the starting point for making the payment or vesting a right in them to make this payment. When do they get the right to make the payment? They pay 25%. Let us assume everything, I have not come for any one-time settlement. Bank says that I am not confirming the sale. Can they come before the court and say, please confirm the sale? It's essentially the point, my lords. This is where we stand. We have not gone to the stage where it is already confirmed and whether it is cancelled. That stage has not come. Notice a similar situation came up before the Honorable Supreme Court. Subrule 6, may I just read it?
Yes.
In default of payment within the period mentioned, on confirmation of sale by the secured creditor, if the terms of payment have been complied with, authorized officer exercising power of sale shall issue a sale certificate of the immovable property in favor of the appellant in form given in Appendix 5 to these rules. So confirmation of sale is a sine qua non for authorizing or the statute recognizing a right in an auction purchaser to pay, to tender the balance payment. Otherwise, he doesn't get the right at all. This more or less a similar issue came up for consideration before the Honorable Supreme Court. Supreme Court judge.
Yes. Yes.
Lords, then your lordships may kindly see paragraph number procedure in public auction, my lords, is at paragraph number 14, it is extracted. Then paragraph number 25 and 26.
Yes.
The law on the subject is settled that courts, being the custodian of the fundamental rights, are under an obligation to interfere where there is an arbitrariness, irrationality, unreasonableness, malafide, and bias, if any. But at the same time, the court should exercise the power of judicial review with a lot of restraint, particularly in contractual or commercial matters. Undisputedly, the provisional bid in the instant case was not confirmed by the competent authority and not being accepted after recording his due satisfaction by an order dated 2793, and the decision of the authority in passing the order of cancellation of the auction of the bid was scrutinized, examined by the appellate tribunal authority, and discretion exercised by the competent authority in taking decision for cancellation was upheld at the later stages. This being a settled law, the highest bidder, this is important, the highest bidder has no vested right to have the auction concluded in his favor, and in the given circumstances under the limited scope of judicial review under Article 226 of the Constitution, High Court was not supposed to interfere with the opinion of the executive who are dealing on the subject unless the decision is totally arbitrary, unreasonable. It was not open for the High Court to sit like the Court of Appeal over the decision of the competent authority, particularly in the matters where the competent authority of floating tender is the best judge of its requirements, and therefore the interference otherwise has to be very minimal. Now, it's just that one sentence, which I read to your lordships at plastum F.
Yes.
Now, the scheme of the statute also contemplates the same thing, because he cannot come and say, I wanted to, that's the reason why I said, Lords, the bank says that reserve price is 1 crore. He says 1 crore 1 rupee, auction purchaser. He is the highest bidder, there are no other bidders. He deposits 25% because he is the highest bidder. Secured creditor has to confirm the same. Secured creditor says, no, I don't want to confirm.
But that's
because
not the scenario in this case.
Pardon, Lords?
That's not the scenario.
No, I am only submitting, Lords, that if this confirmation does not take place, I am only submitting a scenario where he says 1 crore, confirmation is not done. He cannot come before the court and say, no, I have a vested right for the sale to be confirmed.
He cannot.
That's
in those circumstances.
That is the only that is the only question here. This was also a situation where the bank offered, all right, I want to confirm it. Then, having said that you have not confirmed, can you now reprobate saying that no, it is confirmed? It is not. But fortunately, that is not their case. Lordships may kindly have a look at Annexure K, the ingenuity with which the petitioner presents himself before the court. 12-3 confirmation they want. 19th March, he says, no, I will not accept because it's got no legal legs to stand. I will not accept your confirmation. Notes after that, what they do is they give this letter on 29th of August 2025, Annexure K. Prayer B is to consider Annexure K. The Prayer B is designed like direct them to issue the sales certificate by considering Annexure K. Annexure K, if your lordships were to see, my lords, that closes their case, that shuts the door against the petitioners. Subject is request for issuance of sale confirmation letter in respect of public auction held on 24/2/2025. So with the plea which they have come before the court, now they cannot reprobate. I wanted to say it is a confirmation. They say no, there is no confirmation. Even now they want the court to accept that there is no confirmation. I'll put a worse scenario against myself. All right. The council had made a statement, there is a confirmation. Bank has communicated, yes, there is a confirmation. Once we say it is confirmation, let us assume that the bank says there is a confirmation. It is a confirmation for all purposes. That's essentially, my lords, one proposition. If that is the scenario, if your lordships were to see, my lords, the manner in which the law is designed, the amount stands forfeited because admittedly they have not paid it within the stipulated time. 30th of August was the time which was extended to them in the previous letter, which is at page number 27. They say you paid by 30th of August. So now again on 29th of August, 30th August, they say, all right, you pay, make the payment. They don't come forward to make the payment. 29th August, they say that no, there is no confirmation. You have not yet confirmed the auction. Notice for 29th also, they say that no, there is no confirmation of auction. Now, once there is no confirmation, they stop at rule 9(2). They don't go to the next stage at all. Now, they cannot say that no, the bank is bound to confirm the sale. Because subject to condition, they are the subject to acceptance by the secured creditor, gives a vast discretion to the secured creditor whether to confirm or not to confirm. This is subject to confirmation by the secured creditor. That gives, the moment it is made subject to confirmation by the secured creditor, it is not some mechanical process when such legal provisions are made and subject to the confirmation by the secured creditor. It has some object. There he gets an element, of course, discretion is not whims, of course, but he gets a discretion, a commercial discretion, which will be purely a commercial discretion, which is a secured creditor will take whether or not to confirm this auction or not. But the moment you say, yes, I have confirmed the auction, then it is for them. If you say it is confirmed, you are out of time. If you say it is not confirmed, you are out of court. Either of the ways, you don't have a right. So therefore, Milords, there is one judgment, Milords, of Justice Pinaki Jose, who was, he dealt with what is the concept of confirmation. Lords, this judgment runs contrary to BAFNA on the latter part. I just wanted to say this, Lords. This is pre-amendment of 13(8). The word transfer and sale came up for consideration in a different context. But what I am referring to is, it also dealt with the situation, what is meant by subject to confirmation. Lords, which is at page number 13. The bottom of the right-hand side bottom corner, Lords, is the page numbers. Lords, clause 8, sale is subject to confirmation by the bank. In the letter dated 31/3/2002 addressed by the appellant declaring the appellant as the highest bidder, authorized officer of the bank clearly stated thus the sale shall be confirmed in the name of India Finance Securities on the payment of entire bid amount subject to confirmation by the bank. The appellant therefore from time to time is informed that the acceptance of the bid or sale shall be subject to confirmation by the secured creditor. Therefore, the acceptance of the bid by the authorized officer in our considered view would not amount to confirmation of sale by the secured creditor. Just only that sentence. Even if that letter is given by the authorized officer and says subject to confirmation, that does not amount to confirmation. So they stop there. Now what happens is there is one more judgment. I've asked them to get it. If at all an auction purchaser wants that, yes, I want this to be concluded in any manner, one coordinate bench took the view. If auction purchaser says that the bank is not doing certain things pursuant to the auction, then the coordinate bench has taken the view. This is the petition number. Can you just pass on the 25628 of 2024? I'll just ask them to get this judgment.
Yes.
No, that's not there. The coordinate bench took the view. The proper course is to first deposit the money, tender the money, and then contest the proceedings. It is not that you pay 25%, hold the remaining money. In the usual course, if nothing had happened, maximum period available for them was 90 days. The reason why 90 days is fixed is also dealt with by one of the judgments of the Kerala High Court, which said the period of 90 days is fixed because in a real estate particularly, 90 days, the Securitization Act and the security interest rules deemed it appropriate is the time within which there may not be a major change in the values of the property. But the moment 90 days expires, then fresh auction has to be undertaken from the stage of 8.5. Well, that's the view taken by a division bench of the Andhra High Court, saying that every time there is a requirement of a fresh valuation to be taken place. The reason being that there will be an escalation. It may be appreciation or it may be a depreciation. So therefore, my lords, my respectful submission is that there is no vested right for maintaining the writ petition of the kind.
Yes, reply.
Yes,
Yes.
5 minutes, my lord. I know the end.
Yes.
Lord, first submission, my lord, that they have been making is, there's no right of confirmation. Please look at 9.2, my lord. Rule 9.2. 9.2 specifically states, my learned friend, my lord, an astute lawyer does not read the proviso. He reads only, my lord, 9.2. Please look at 9.2. Sale shall be confirmed. Wording used is shall, and then what? Subject to confirmation. That proviso, my lord, says, provided that no sale shall be confirmed if the amount offered by the sale price is less than the reserve price. Therefore, my lord, the confirmation can be denied by them only, my lord, if the sale price is less than the reserve price. This is one aspect. Second is, we are speaking of, my lord, discretion. It's a writ discretion. Look at their conduct, my lord. First, they say that, my lord, they backdate that. Look at the conduct of the bank. Your lordship, my lord, granted an interim order. They, my lord, backdate, my lord, the letter, send us a confirmation letter. And, my lord, on 18th, my lord, we receive it. There is a stay order granted by your lordship. Therefore, my lord, we said, my lord, there is no confirmation in that manner. But they, my lord, confirm it. Letter says, I confirm it. This is one aspect. More important is, look at the conduct, my lord, malicious conduct of this. Backdating of letters, my lord, saying, all this. And, my lord, your lordship specifically directed, produce all the documents. They don't produce it, my lord, deliberately. Now, my lord, they rely upon a judgment of, my lord, the 2018 1 SEC. Please look at that judgment. It's clearly distinguishable. 1 minute. Don't mix up my papers.
Compilation.
ಇಲ್ಲ ಅವ್ರು ಕೊಟ್ಟಿದ್ದು 2013 10 SEC was given by Mr. Raghavan. Please have a look at that.
Yes.
My lord sees, look at, my lord, paragraph 4. I'll tell you, lord, is why. That was a case, my lord, where, because, my lord, they say waiver. This is, my lord, waiver, my lord, which is a right vested in the bank, not, my lord, I did not waive it. Now, please look at paragraph 4. On 9/12, bank got mortgage property valued, which was fixed at so and so. On 18/12, bank published an auction notice in the local newspaper. Please come to para 5, my lord, line number 4. Public auction was conducted on 11/1. 18/12 to 11/1 is, my lord, within 30 days. Mandate requirement is 30 days. And that, my lords, get that, my lord, at running page 18, paragraph 18. Para 18, if your lords has come to, two things clearly emerge from the above letter. My lord, auction purchase, my lord, the borrower gives a letter. Two things clearly emerge from the above letter. First, at the time of auction, sale on 11/1, borrower was present. He did not object to the auction being held before the expiry of 30 days from the date on which the public notice of sale was published. He also agreed bid given by the auction purchaser of 8.5 lakhs, which was the highest bid, be accepted. Now please come to paragraph 19, which is so, my lord, strongly relied upon. There is no doubt rule 9(1) is mandatory, but this provision is definitely for the benefit of the borrower. Similarly, 9(3) and rule 9(4) are the benefit of the secured creditor. Secured creditor can waive it. 9(2), my lord, is a, my lord, vested right in me. It is, my lord, it is for my benefit. 9(2), my lord, if your lord says, look at, my lord, 9(2) specifically says you shall confirm. Therefore, my lord, this waiver, I did not waive it. They may have waived it, my lord, is of no consequence. Then writ is not maintainable. Please look at, my lord, the Bafna's case. Writ was filed, paragraph 4 and paragraph 113. Writ was filed. Honorable Supreme Court, my lord, writ was allowed. Therefore, this argument, my lord, is, and one of their judgment itself says, if you have malicious conduct, my lord, it must be looked at. This is, my lord, a clear case of malicious conduct would be my submission. More than that, my lord, otherwise, my lord, will be keeping on repeating. Extremely grateful to your lordship, my lord, for the patient hearing that your lordship said. Just 2 minutes.
Now,
Lord, if your lordship permit me, can
Yes.
I go to the other court, my lord? Because there's a partner, he was, my lord,
Yes.
grateful.
just 2 minutes, but I also won't repeat anything. Now, I just want to point out, my lords, the dangers inherent in the arguments advanced by the respondents. Now, if in essence, the argument was that there is wide discretion left with the banks, wherein even after an auction, I need not confirm. If I need not confirm, then the clock gets set back, in which case there is a right to redeem the mortgage. Kindly, I don't need to elaborate more. The dangers are apparent to see. If that much discretion, if the provision is construed in such a wide manner to give such wide and exhaustive discretion to the bank, whereas complete violence will be done to the provisional section 13(8) and rule 9(2), 9(3), 9(4), everything. I just want to point out, Malas, what Mr. Raghavan said was that section 13(8), this 2016 amendment, was essentially to vest a right in the bank. But that, Malas, is contrary to what BAFNA itself has held. Paragraph 85 very clearly also says, yes, there would be a chilling effect on auctions. What would be the right of a successful bidder? There is sanctity to the auction process. I won't trouble my lords reading the paragraphs 85 to 87. In fact, 85 to 92, if my lords may kindly note. I won't trouble my lords reading it. There, my lords, the 85 to 92.
90.
There, my lords, the rights of the auction purchaser are very much predominant in the minds of the Honorable Supreme Court. So it's not as if it's just between the bank and complete discretion in the bank and a possible setting the clock back under section 13(8). So therefore, and as I said, I don't need to elaborate. The mischiefs are very, the possibility of mischief, giving such mischief/misuse, if such wide discretion is given, is very clear. All that has to be done is conduct an auction. For whatever reason, I don't like that auction purchaser. I don't want to confirm it. I have discretion to back up. That can't be the intention. Otherwise, as in this case, all that has to be done is encourage the the borrower, go to the court, go to DRT or a high court. I will not contest the matter, get a stay. Then what do? I'll do all of this. Finally, I will set the clock back. That can't be encouragement, which is why section 13(8), the object has to be kept in mind that the auction purchaser also was predominant in the minds of the legislature in the first place and the Honorable Supreme Court while rendering BAFNA. That's all. I don't think anything more.
One para, I forgot to bring it to your lordship's notice in that judgment of the Andhra Pradesh High Court minutes at page number 14. This is what I had noted, minutes.
Pinaki Chandra Ghosh judgment.
Please, minutes.
Paragraph?
Paragraph number 22. I'll just read that particular portion, Lord. This is exactly the proposition.
Yes.
That I will just place this judgment also. Arvind Kumar versus Government of India is referred and it is extracted. Minutes. I am unable to immediately place lay my hands on that. I'll just paragraph number 22. Learned counsel for the appellant placed reliance on the decision of the Supreme Court in Arvind Kumar versus Government of India and Sagar Mahila Vidyalaya Sagar versus Pandit Sadashiv Rao Harshe to contend that once the sale is confirmed by the court, sale becomes absolute and the auction purchaser has got a vested right in the property, whether sale certificate is issued or not. It was also held that the issuance of sale certificate is only ministerial act evidencing the transaction of the sale that was already taken place and the sale certificate does not require any registration. In Arvind Kumar versus Government of India, it was held that when a property is sold by public auction in pursuance to an order of the court and the bid is accepted and the sale is confirmed by the court in favor of the purchaser, sale becomes absolute and the title vests in the purchaser. Sale certificate issued to the purchaser only when the sale becomes absolute. Sale certificate is merely evidence of such title. It is well settled that when an auction purchaser derives title on confirmation of sale in his favor and a sale certificate is issued evidencing such sale and title no other deed for transfer of the court is contemplated or required. In this case, the sale certificate issued was registered, though such sale certificate issued by a court or an authorized officer does not require registration. Next paragraph, the first sentence is important. From the above, it is clear that auction purchaser derives title on confirmation of sale only. That's essentially what I referred to the 2022. The consistent view taken is the same thing. This is that coordinate bench's judgment minutes which I referred to. But it is not that it is like a game of chess. Para 6 is the operative portion.
Yes.
The court must opine that the petitioner cannot succeed in the present petition because petitioner, having participated in the auction, is aware of the consequences and being put on notice thereof should have offered the entire sale price. similar to what happened, my lords. If there was any default by the first respondents, the bank in delivering portion or otherwise in complying with the terms of the sale requirement, petitioner should have availed the remedies in law to operate upon tendering the full value offered. Not the bona fides, they can say about things, but bona fides will arise. Let us assume, my lords, when this proposal was before this honorable court, when this honorable court made an observation that our proposal for one-time settlement is being considered. If they at that point of time said that, no, I'm depositing 75%, I would have been in a very precarious condition, but they never did it. So they have held back the 75% from March 2025 till date. So being ready and willing is not a suit for specific performance.
What about those documents, February?
That full file would be.
Please do it within a week, within 2-3 days. That shall be placed.
Tomorrow,
Third-
2 days. Tomorrow, within 2 days.
Third reserve,
Can I just make?
give it to the court officer.
We'll
those
give it to
documents
the court
them
officer.
also.
Great.
The mark.
Malas, just
Ah.
two absolute
What
last
we'll do,
submissions.
Malad, is-
Skip my mind. Two absolute last submissions. One is, Mr. Holla, of course, alluded to it. To show the conduct of the bank, my lords, Mr. Raghavan pointed out that page 215, the letter was dated 11th of September. 11th of September, one day after that cancellation letter to us. So kindly, let's see the conduct, the fact that there was a lot happening behind the scenes. And second aspect, my lords, on instruction I'm submitting, if, of course, the fact that it is public money, the fact that it's a public sector bank, no one denies. But if they were so interested in, if the final objective was only to get the best price, but we already had deposit 25%. They could have tried to renegotiate, or anything is possible. But to say that only that person has the right to claim to pay 7 crores more, therefore I will foreclose every other right. That also, the conduct speaks volumes. If they ask us tomorrow, possibly we may be willing to better the price. Then it becomes which is why the sanctity of the auction process is there.
The debtor is the owner. Debtor is the owner. Yes. Great. Sir.
Grateful.
So grateful.
Yes.
That interim order may continue. until-
Interim order earlier granted. Yes.
So next, yeah.
We'll see later. Other passes.
Till number 37, pass over. 37,
Yes.
Tawshif Ahmad. 37,
Who appears for the petitioner?
It has become infructuous. What the challenge was the.
Yes.
Petitioner.
Huh?
That is.
It's passed over. Where is he? It is submitted with the loan council appearing for the bank that already the property is sold by the time the interim order is passed. The auction is conducted and also same is finalized. At the request of loan council for the petition list is matter on so and so. No further adjournments will be granted. Morning it is passed over. Yes. Hmm. Property is sold, it seems. Property is sold by the time the interim order is passed.
Your Lordship, however.
And it is finalized also.
Your Lordship, however, Your Lordship has also mentioned that sale certificate confirmation may not be made in the said order.
No. When is the order passed?
On the same day of the sale.
On the same day, Your Lordship. And in case, and the confirmation has been done on the 7th day, within 7 days, Your Lordship.
Then counsel for the petition take out handsome and so and so. I purchased the property. Now the reserved price is rupees 20 lakhs.
Yes, Your Lordship. Which is much lesser than the.
And I think we have to hear this petition. You
Yes,
have to
Your
file your
Lordship.
objections to. We have.
They have
You have
already.
filed already?
Yes.
Yes, we'll hear this after vacation.
Situation
Your
is,
Lordship, interim order may be extended. Your
Interim order earlier granted is
situation
extended.
is this. Now that the interim order has, and the sale has already taken place and confirmed, now the auction.
Will you
purchase-
confirm it within
7 days time, Your Lordship.
1 hour from the time of the auction?
Yes.
When was it communicated to you?
No, I've placed all those materials before.
No,
the
when
court.
was it communicated?
It was communicated in. You have to
On the
do-
same day it must be.
No. It was not communicated on the same day.
When did you communicate?
Your Lordship.
Communicate the order to the respondent.
Your Lordship, it was communicated on.
Yes, this is matter after vacation.
50.
Now the situation
Ajit
is,
Shetty.
the auction purchase is already. We
We'll
have
see,
to
we'll
issue
see
the
after
sales
vacation,
certificate
yes.
on the
Ajit Shetty,
There is some urgency in this. Can I
We'll see,
request the
we'll see
court to
after
kindly have it
vacation.
on Monday?
Not possible, there are so many matters.
I understand, but
Because this has to be heard, considering the fact it is not that some other writ petition where they've just like that come before the court. They say that they're saying that when the price of the property way back, it is 20 lakhs.
that's correct.
Yeah.
And I will request the court to take just page number 99. That is all. I will not trouble this court. If the court does still want to adjourn the matter, I will not trouble this court.
List this matter on 18th.
Much obliged.
Not 18th.
Just one letter.
No, list this matter on 16th. No time today, no.
Interim order
16th.
may be
Because
extended.
they
Your Lordship.
themselves
Interim order earlier granted is extended till then 16th.
cell number
Yes.
50, 50.
Yes.
Hearing for the respondent, my lord, we served a copy today, my lord. Tomorrow, my lord, the sale is on 11.
Stay is on?
Sale is on day after tomorrow, my lord. We served a
Tomorrow.
copy tomorrow, my lord. Date.
Yes, next. What is her name?
Divya Purandar.
So and so, print the name of so and so. Yes.
Yes.
Cell number 64. Cell number
Yes.
64.
The one-time settlement timelines I have breached. 10.83 crores, 53 crores was required to be paid. But I am tendering the demand draft for entire 10.53 crores. I'm just filing this memo, my lords. And let them consider if there is anything to be paid by means of an interest.
Them give first representation, my lords, because this letter has,
It's been long back.
means 24, this petition was filed in
Lords,
25.
what happened? September
Them give
2020.
first representation, e-auction was challenged, when we issued the sale notice, all these things came up. It is not a separate, it is filed only challenging the letters which he had not completed the interim order. This, it was filed only challenging the
Now-
e-notice, subsequently, other prayers were
We-
included.
18
Let them give first
18
representation.
18 crores was the,
We'll do one thing. We'll keep this writ petition pending.
Lords, this may keep
Give
this
your
pending.
representation
We
for
will give
one
that,
time
let them,
first.
let them,
And I'll
yes.
record that you have already,
Lords,
your amount of.
10 crores, 53
and all
lakhs
is
is
very-
what we are offering, my lords, along with our representation.
Let them offer, my lords, let the bank consideration, let them go on, because
This,
in this writ
senior
petition-
counsel appearing for the petition submitters, they are ready to offer. They're offering an amount of rupees 10 lakh,
10 crores, 53 lakhs.
Lakhs. And
Can I-
copy of the DD is also filed, DD number 001916, dated 6/12/2025. And there may be a direction to the bank to consider the same. Land counsel appearing for the respondent bank submits that the petitioner has never come up with a.
Lords, can I just, Lords, OTS was approved for 18 crores 53 lakhs. September 2024, it has lapsed. Lords, then they wanted to bring the property for auction. Then we went back and said we want to pay the money. Lords, at that stage, the bank was not inclined. It is in those circumstances we have come before the court
No,
because
but you're giving this 10 crores.
10 crores, 8 crores is already paid. Out of 18 crores, 8 crores is paid. What is due is only 10.53 crores.
Submitted that
Balance
earlier,
of-
the OTS proposal was accepted for an amount of 18 crores and 8 crores was already paid. And as the remaining 10 crores was not paid by the petitioner, they have issued the auction notification questioning the same. The present petition is filed. Then a senior counsel submits that they are ready to pay the remaining amount of 10 crores. 10
With
crores.
10 crores, 53 lakhs with any additional amount which
Tax,
they,
and even if any additional amount is there also, they are.
in the
ready to
nature of
pay.
interest, Lords, your Lordship.
Then counsel, as interest, in the form of interest, then counsel appearing for the respondent bank submits that the petitioner can approach the bank by filing a fresh representation. On that, the bank will pass appropriate orders
We will consider in accordance with law.
in accordance with law.
Memo.
In accordance with law. List this matter, the petitioner shall make a fresh representation to the bank. List this matter after vacation.
Please, my Lords.
There is an interim order in this.
No interim.
No,
There's no interim order.
anyway, action could not take place.
There's no interim order, minutes. It can be taken up after vacation.
Yes, after vacation.
Cell number
Any dates, January first week,
70.
date has been decided.
Cell number 70.
Lords, any date, my lords, first week, second week of January, my lords, any date, my lords,
Second week of January.
any date.
70, my lord.
No, no, the date I'm not giving. It's like fixing the next roster also.
My lord,
All the
see-
dates. Let's.
Appeal
you
for,
can move before
petitioner,
the-
my lord.
Yes, 7.
Serial number 70, my lord.
20.
There is totally 3 writ petitions have been filed by the party, my lord.
Hmm.
Your lordship may kindly direct the office to post all the matters together, my lord, because
What is the urgency now in this?
there is already an interim order, my lord. They made the part payment. Thereafter, they have not bothered to make any
Give that interim order.
in other connected matter, my lord.
What about this I'm asking?
This matter is a fresh matter.
What is the order
The
they are
basis of
seeking
that.
at this?
There is total 3 loans which have been availed by the party, my lord. In one, she has been,
List along with all those matters after vacation.
I'll give the,
Yes.
I'll submit the details of that, ma'am.
Sale number 71.
With the board only granted is extended.
71.1, I appear for the appellant in this case, please, my lord. There's a case where the check was bounced, which was issued by the insurance company, my lord. It was not reached the, sure, it has been heard multiple. Any date may be please given, my lord.
This is the matter on 15th.
Yes. Much obliged, my lord.
Next.
Sale number 73, filed. 73.
Ma'am, for the petition in this case,
I
sir.
just wanted to make
Give
a
that.
submission in this case, Your Honor. The petition was been filed by
This is of which year?
of 2020, Your Honor.
Which
And,
court?
Before first additional principal family judge, Your Honor. From 2020 till 2023, there was no objection filed by the respondent for the mains.
Anyhow, they have filed now. Will pass an order directing the court to dispose of the matter. Whatever is the interim arrangement made by this court, you please
Your
continue with
kindly
that.
the order may be, at least the order may be granted for once in a month, Your Honor. The petitioner.
What is the order passed by this court?
2 hours, that is on every Saturdays, Your Honor.
So what do you want?
I want, at least the court can order once in a month, Your Honor, the child gets to spend time with the petitioner. Since 5 years, he had been begging to
Your
court,
lordship,
Your Honor.
your lordship.
After,
No, when the court grants you every week,
Your Honor, he comes, he holds the hands of the child and sits. And it makes, it is not a space to the mother and
when
child.
did the mother meet the child before
Yeah.
this order?
Before this order, she never met, Your Honor.
No, when she last seen the child?
2019, Your Honor.
So be happy with it and let it continue. We will see we'll ask the GNWC itself to be disposed of.
Your Honor, one direction may be made that when the petitioner is with the child, the respondents keep it away, Your Honor, staying with the child, and it is uncomfortable to mother to at least speak, ask
To an
for his
extent,
whereabouts,
your lordship, we are pushing the child. The child is for the court.
Holding the hand and
He
sitting,
lost
Your
his eye due to cancer.
There is no medical report, Your Honor.
What?
This is the only false
I
allegation.
can show. He is one duplicate eye, that is. What is, only one eye.
But mother also
And
need to
moreover,
care
I'm
the
one
child,
is a
Your
cancer
Honor.
patient. She left the child when she came to know that he is a cancer patient. She ran away somewhere. See, I got all the documents.
5 years she had been waiting, Your
He
Honor.
is the advocate. She is the advocate.
So why do you refer
And at the time, see, at the time of divorce, she's an advocate. She was
So
the
what?
advocate.
Is anything wrong with that?
Your
Being an advocate
your
for the
lordship,
respondent?
she was the advocate for petitioner at that time. She herself has given custody to the petitioner at that time.
And there was a.
That is the document.
Also written,
That is
Your
the
Honor.
document executed between.
Mother will have the visiting right.
That
But
is a-
since 5 years, they are denying the visiting
Your
right.
lordship, that is a document, and she has see.
The document itself says that she has visiting right, Your Honor.
See,
That was a terms and
they have not
condition
come.
which was
They have not
limited,
come.
Your Honor.
They have not come. Lordship.
Please come. The present writ petition is filed. Where is the impugned order? The father is before this court, agreed with the order dated 25/9/2023, whereby the father is directed to hand over the custody of the child to the mother forthwith, failing which the petitioner is entitled to take the custody, failing which the mother is entitled to take the custody of the child through due process of law. Then counsel appearing for the petitioner father submits that the boy is aged, what is his age now?
8 years.
He is aged 8 years. Mother has left him in the year 2019. The boy is suffering with cancer and he lost his one eye. The boy is not at all interested to meet the mother. This order passed with and sending the child to the mother is not in the interest of the child. The court had failed to take all these aspects into consideration. When this matter came up before the court on 4/11/2025, this court has passed the following order. Extract that operative portion of the order. Land counsel appearing for the petitioner submits that as per the orders passed by this court, though the child was not interested to meet the mother, the father has made all his best efforts that the child meets the father from the mother. Land counsel appearing for the mother submits that an order may be passed where once in a week custody is completely given to the mother so that they'll be able to develop bonding. The land counsel, in response to that, land counsel appearing for the petitioner, father submits that the boy is not at all interested as the boy has no acquaintance with the mother from 2019. It is further submitted that the mother is not cooperating with the trial, even the GNWC, and let there be a direction to the family court to dispose of the GNWC expeditiously. Next one. Having heard the counsels on either side, there is a material on the court. It is admitted fact that right from 2019 till 2025, like from the last 6 years, the boy has not met the mother. The boy, as on today, is aged about 8 years. So by the time the mother has left the child, it is true, he was 2 years old. And from that time till now, he's staying along with the father. In these circumstances, this court is not inclined to grant is not inclined to grant the complete the visitation, the custody to the mother for a day. Hence, considering the balancing the interest of both the parties and also the interest of the child, this court is passing the following order. On every Friday, he has school.
Saturday, he says school.
On every Saturday between 2 to 5, the mother can exercise the visitation in the child visitation room, the Bangalore Family Court, until further orders. The family court shall dispose of the GNWC by as expeditiously as possible, but not later than June 2026. Yes, next. This done. This court.
75. Mahabaleshwar.
No, my lord, we are on the other. That is the beauty of this profession.
It takes time.
Lords, it will take. I had argued this matter for almost about 3 hours before the coordinate bench.
According to me, my lord, 10 minutes.
What is the issue?
Not the issue is, the challenge is to the treating of the account as a non-performing asset. It's a very peculiar account, not which is funding the export projects. Not the export projects, whenever it is funded, RBI guidelines says under what circumstances the NPA can be treated. Not first they gave a reason. Because of the intervening COVID, they extended the period. When the loan account was alive, they said that no, we have treated your account as NPA. We never knew why they have treated our account as NPA. But when we kept on asking them, they said that there is one bill dated 19/8/2021, which we have crystallized. I just want to say what is meant by crystallization. If there is an export bill, how it happens is, let us say it's a transaction for about 1,000 crores, $1,000. There will be 10 bills for $100 each. So for encashing every this bill, I have to give consent, and the recipient of the services will give consent, upon which the bank will realize this. If once that situation arises, if the honoring does not take place, it will be in dollars. So they will convert that into Indian national rupees, INR. That is the process of crystallization. They said the bill dated 19/8/2021, we have crystallized, and therefore we have treated our account as an NPA. Then we were not aware what has happened, because the moment that account is closed, I will not have any information what is happening with that bank account. We had to install a crane services in a port in China. Then we have done business of 650 crores with this bank on the basis of the security of the same properties in 13 loans. A woman entrepreneur has done it. So then you said, no, it cannot be, because 19/8/2021, you have actually encashed it. So then we went before the banking ombudsman and said, no, look, banking ombudsman, they are saying our account is NPA, but 1980 is already recovered. So the question of treating this account as NPA does not arise. When we said that, they came back and said, no, we have not extended this loan, the period of the loan up to September 2021. May 2021, they crystallized so September up to July 2021, it is extended. And then we have to complete the project by September. Then that is the stand which they took. Then we went back to them and said, look, I don't know whether you are aware of it or not. This is the extension letter which you have given. When the loan is alive, you cannot treat my account as an NPA on the ground that this time is lapsed. So then they realized, yes, this is also not possible. Then they appointed something called as ex parte forensic audit within themselves. Forensic audit is conducted, and what they say is there is a diminishing of the value of the secured assets. How? Two of the properties which we have mortgaged, they made an allegation saying that these are the properties mortgaged in 2013, not now. From 2013, papers are lying with them only. 2022-23, they get this internal audit or the forensic audit and say, in respect of two properties, we have only the color photocopies of these properties. There is a diminishing of value of the assets which is pertaining to the secured assets. Therefore, under clause zones of the RBI circular, we are now treating your account as the NPA. This is the third reason which they have given. For the very same property, they have gone before the magistrate, taken possession. Same property, they have already put it for auction for the same value.
We'll have it on Tuesday at 2:30.
Please, Willots.
Tuesday at 3:30.
Tuesday, yes.
Yes.
But,
interim
we
order
also
may be
filed-
extended.
We have also prepared a synopsis of our submissions.
Yes.
Can we have your lordship's permission
Yes.
to file it? We have given a copy.
We have also filed our synopsis minutes. Two synopses
According
are
to me,
filed.
my lord, briefly put, all this is not open for being said in a writ petition in Article 226, because Supreme Court has said every question, including the question as to the propriety of treating an account as an NPA, has to be urged before the DRT.
We'll hear it.
We will.
Please, Minutes.
We will.
So grateful.
We will file this. Great.
Sir, tole. 70. Connected.
Connected number
42.
ಪಿಟಿಷನ್ ಅಂತ ಪ್ರಕಾರ ಸೀನಿಯರ್ ತಗೊಂಡ್ರಂತ ಕಾಣುತ್ತೆ ನೋಡೋಣ ಇಲ್ಲಿ ನಂತರ ಸಾಫ್ಟ್ ಕಾಪಿ ಇದೆ. ಒಂದು ಮ್ಯಾಚ್ ಆಗ್ತಾ ಇಲ್ಲ
ರಿಸರ್ವ್ ಅಂತ ಬರ್ಬಾರ್ದು ನೋಡಿ. ರಿಸರ್ವ್ ಅಂತ ನಾನು ಬರೀಬೇಕು.
ಎಲ್ಲ ಶುರು ಆಯ್ತು. ನೀವು ಏನು ಕರಿಬೇಕಿತ್ತಲ್ಲ, ಹರ್ಷಿತ ಹೋದ್ಲಾ? ಮ್ಯಾಟ್ರ್ ಹಿಯರಿಂಗ್ ಆಗುವಾಗ ಅದೇನ್ರಿ ಹುಡುಗಿ ಇಷ್ಟೊಳಗೆ ಚೆನ್ನಾಗಿ ಹಿಯರಿಂಗ್ ಇತ್ತು, ಮತ್ತೆ ಕೆಲಸ ಅಲ್ವಾ ಇದು? ಸಾಕಾಗಿ ಹೋಗಿದೆಪ್ಪ, ಇದು ಬಿಡಿ. ಸ್ವಲ್ಪ ಬೆಳಿಗ್ಗೆ ಮೂಡ್ ಆಫ್ ಮಾಡ್ಕೊಂಡೆ ಆ ಕಿರಣ್ ಒಳಗಡೆ. ಐ ಕಾಂಟ್ ಐ ನಾಟ್ ಟಾಕ್ ಟು ಹಿಮ್ ಓನ್ಲಿ ಹಿಯರ್. ನಂಗೆ ಆಗೋದಿಲ್ಲ ಅದು. ನಾನೇ so many work. ಎಲ್ಲ ತಗೊಂಡು ಹೋಗೋಣ, ಅದು ಪರವಾಗಿಲ್ಲ ಅಂದ್ರೆ ಎಕ್ಸ್ಟ್ರಾ ಇದೆ. ಅಂದ್ರೆ ಎಲ್ಲ ನಾನು ರಿಲೇಟ್ ಮಾಡ್ಕೊಂಡು
ಪೆಂಡಿಂಗ್ ಅಲ್ಲಿ ಕೇಳಿ ಅಂತ ಹೇಳಿದ್ರು, ಬೆಳಿಗ್ಗೆ ಮೂವ್ ಮಾಡಿ ಬಂದಿದ್ದೀನಿ, ಮಿಸ್ ಆಗಿತ್ತು ಅಂತ. ಅದು ಇವತ್ತು ಆಗಲ್ಲ ಅಂತ ಇದಾರೆ.
3 ಆಗಲ್ಲ ಅಂತ
ಹೇಳ್ತಿದ್ದಾರೆ. ಆಮೇಲೆ ನಾನು ಹೋದೆ.
ಅದೇ ಸೇಮ್ ಬೇಗ ಇನ್ನೊಂದು ಸೆಟ್ ಕೊಡ್ತೀನಿ. ಸಾಫ್ಟ್ ಕಾಪಿ ಇದೆ, ಇನ್ನೊಂದು ಸೆಟ್ ಕೊಡಿ. ಹೇಳಿ
ಸೇಮ್ ಮ್ಯಾಮ್, ಸೇಮ್ ಎರಡು.
Madam.